Good morning. How are you all? Very good. I'm Jack Balkin. I'm the director of the Information Society Project at Yale Law School. And I basically am here to welcome you and to welcome all the other people who are just about to be here who we've been tracking, and to this location tracking and biometrics conference. This conference is co-sponsored with our dear friends at the Engelberg Center at New York University. And it is sponsored by Thomson Reuters, in particular the Thomson Reuters Initiative on Law and Technology. And I want to give a big shout out to Heather Branch, the woman who makes everything here at the Yale Law School possible. So thank you very much, Heather, for doing all the wonderful things you do. The second thing I want to do is I want to introduce Chris Segoyan, who among his other many accomplishments happens to be a Yale ISP visiting fellow, and he is going to walk you through some of the technology we're going to be talking about today. Chris?
Thank you. So I have 20 minutes. I don't know if I can stand and do this. Let's see if that works. Can you guys hear me? In the cheap seats in the back? Yeah. So I have 20 minutes to give you the basics of cell phone tracking technology. This is not going to be an exhaustive survey, but I want to give you enough to get through today. I've read a number of briefs from lawyers over the years, and there are a few things that people always get wrong. So my hope is that today I will be able to help you with those kinds of things. So there's a great line in Brandeis's dissent in Olmsted, where he says that the progress of science in furnishing the government with the means of espionage is not likely to stop with wiretapping. And location is but one of the examples of technology that allows the government to peer into our most private space. I'm going to be talking today about a few ways that the government tracks people's location, some through the assistance of the phone companies, but others more directly. There are sort of two main categories of location data that the government can get. One is historical data, which is information about where you were in the past or where someone was in the past. And the other is information about where someone is right now. The historical location data is more limited for the simple fact that it had to already exist and it had to be retained for the government to get it. So this is a cell tower, and your cell phone is connected to multiple cell towers at any given time usually. Your calls will be handled by either the tower with the strongest signal, or if that tower is busy, the next tower in line. Your phone generally knows where a few towers are at any given moment, so that when you move from one place to the next, your phone has a few other towers sort of in its pocket ready to switch to, and it figures out which one it's going to switch to depending on who has the strongest signal and who's available. These towers are everywhere, and they're generally run by the run or owned or leased by the telephone companies. Telephone towers, cell towers, have a range of coverage around them, and this is typically drawn in the form of a circle, although the actual range of coverage is not actually circular. When the government requests cell tower data from a phone company, they get the location of the tower, which will be an accurate data point of where the tower is. They'll know the approximate signal strength or the range of the tower, and then in many cases they'll learn that one of three faces of the tower. So that the tower has sort of the 360-degree coverage area around the tower is cut into thirds, 120 degrees, and so the government learns where the tower is and which face or which direction the signal is coming from. That's all they get with a tower. They may also get some signal strength, but really what it's doing is it's allowing the government to place the individual phone within this circle, somewhere within this circle. And there are techniques they can use to narrow it down to a portion of the circle, but they never really get a unique point within that circle. And really what we're seeing as technology advances is a changing of the size of the circle, but with single tower data, it's always about placing a phone within some approximate range of coverage around a tower. So phones used to just do voice and to a lesser extent text. And then a few years ago, smartphones came out, and particularly the iPhone. And what the iPhone did was it really drove the usage of data by consumers. And the phone companies were crushed by the amount of data consumption that smartphones were using. And the phone companies have a fixed amount of bandwidth or of spectrum that has been provided to them by the FCC that they've paid for. And so when consumers suddenly start using a lot more bandwidth and the towers that they have already reach capacity, the phone companies need to be able to provide more bandwidth. And the way they do this is by shrinking the coverage area around individual towers and placing suddenly a lot more towers in any given place. And so, of course, what you see then is cities with lots of smartphone users, places like San Francisco and New York, suddenly the government had to, the phone companies installed many, many more towers, right? And so what you end up with then is this, where this tower used to maybe have a few miles of coverage area around it, suddenly that shrinks. Not because the phone tower is not as strong or because it's not capable of reaching these long distances, but in order to get many more towers into a fixed space, they shrink the coverage area around a tower. What that means then is when the government is requesting data about someone's location information, historical location information, and the person is living in a city with lots of smartphone users, suddenly the approximate location information obtained through historical data is more accurate simply because there's less coverage space or coverage area around any given tower. As more smartphones enter a city, the coverage area around individual towers shrinks. Right? And so a place like New York, you may have a tower on every block or more than one tower on every block. And what this means is that with simple single tower data in our modern data-rich environment, single tower data is increasingly more and more accurate. And so in high density areas, either areas with lots of people or particularly areas with lots of people using smartphones, the accuracy of single tower data keeps going up. Now, it's not just people using smartphones. Many consumers demand a lot from their cell phones. And they, in many cases, demand more than the phone companies can deliver to consumers through the towers and the network that the phone companies have. And so if you call up your phone company and you say, look, I'm really not happy with the coverage. I get dropped calls in my living room. You know, I'm paying you guys $60 a month. Why are you not giving me good service? The phone companies, in an effort to avoid you dumping them, will send you one of these devices in the mail. These are called either femtocells or picocells, depending on how they work. But essentially, it's a small cell tower. You put it in your house. The phone companies usually give them to you for free in exchange for keeping you as a happy customer. And instead of your calls going over the phone company's network through the phone company's towers, your calls go over one of these devices through your residential broadband internet connection. And then from there, they hit the phone company's network. And so you can make a call in your living room or in your kitchen, and it'll be using one of these devices. And then when you step out of your front door and walk down the street, the call will get automatically handed off to the phone company's network, to the phone company's actual towers. Right? And so if the traditional towers have a fairly large, say, 4 or 5 mile coverage area, or area of service, and then in a dense urban environment, we have maybe 1 mile or half a mile of service, the femtocells have a very, very small area of service. The one that I have in my living room, for example, doesn't reach my kitchen. As I walk from one room in the house to the other, I can actually hear the call being transferred from my femtocell to the phone company's network. You hear it, I hear a click every time I walk sort of through the kitchen door. Right? And so what this means then is that for single tower data derived from a femtocell, the area of coverage is actually one house alone. It's very rare that you're mooching from your neighbor's femtocell. I mean, these things are not very strong. Now, it's important to know that when the government is requesting single tower historical data from the phone company, they don't know where you've been in the last 30 days or the last 15 days. They don't know if you've been in your house or whose house. They don't know which places you've been. They don't know when they're asking for data whether they will be obtaining femtocell-derived single tower data or phone company tower-derived data. But as of a year or two ago, there are now more femtocells installed in the United States than traditional towers. And that doesn't mean that you're normally going to be talking to a femtocell, because the regular towers have a much larger area of coverage. But there are a lot of femtocells, and the carriers are sending them out as fast as they can to fill the gaps in their network. All right, There are two kinds of historical requests. You have the less accurate ones, and then you have the more accurate ones. And so, sorry, there are two kinds of real-time requests, I think. Sorry, there are two kinds of historical requests. So you have requests for information about one person. So that is, tell me where John Smith was for the last 30 days. The government knows the telephone number of John Smith. They know which telephone company he's using. They go to the phone company and they ask for every data point that the phone company has on file. But the government can also go to a phone company and say, tell me everything about anyone who was near this particular point, this particular place in time, right? So we know that something bad happened at this 7-Eleven. Tell us every person who was within a mile of this 7-Eleven at this given time. And these are called tower dumps. And you'll probably hear more about these later today. There are people in the room who care a lot about tower dumps. Tower dumps are really useful if you're, say, investigating bank robbers and you don't know who committed the crime. Maybe there have been a string of bank robberies and you believe it's the same gang who's done them. You don't know who they are. The government, in some bank robbery cases, has requested cell tower dump historical data of everyone who was near the several bank robberies and then combined and correlated the logs to see what the common phone numbers were in those scenarios. The important thing to understand with the cell tower dump scenario is that the vast majority of people in those dumps are not going to be the target of the investigation, right? For the person you're actually looking for, you're also going to have 100 or 200 or 500 or 1,000 innocent people. Now, the government doesn't have a time machine, and so what this means then is that the only information that's available to them is stuff that the phone company was already saving and recording and retaining. And so generally what that means is location information, or at least the tower you're using at the beginning of the call, at the end of the call, and whenever data is being sent back and forth between the phone and the tower. So for a dumb phone, that will just be call data and text message data. But for a smartphone, where your phone is constantly checking for email, you may have data points in phone company records every few minutes, basically whenever your phone is looking for updated email. All right, so those were the requests. That was the method by which the government can request historical single tower data. The government can also get real-time data about a target, and the term used frequently is something called pinging a phone. I mean, you should think of it similar to Marco Polo. The phone company sends out a signal saying, "Where are you?" and the phone says, "I'm over here." And the technology that's used varies, but what you need to understand is that when the phone company sends out a request, they can find out where a phone is pretty quickly in response to the request. So the FCC, through congressional legislation, or mandated by congressional legislation, required that the phone companies comply with E911 location requirements. So the idea was that the phone companies should be able to locate you in an emergency when you call 911, and so they forced the phone companies to provide the ability to locate their customers upon demand. The FCC didn't require specific technology of the phone companies. It was up to the phone companies to figure out how they were going to do it, and the phone companies sort of did it in two different ways. The GSM carriers in the United States, which are AT&T and T-Mobile, they're the big ones today, use something called triangulation. This is basically you have equipment that's placed on the towers, and through a combination of data from multiple towers, you're able to triangulate a phone. And so the names of this vary. It's estimated time of arrival or angle of arrival, and the particular technologies differ. But the important thing to understand here is that the phone doesn't have to identify itself to the network. The network is able to actually figure out where the phone is, but you need 2 or 3 towers for this to work. And so this may not be effective in the most rural part of the country. This does have the advantage, though, that it doesn't require any assistance from the phone. There doesn't need to be any special hardware put in the phone. So any device that's on the GSM network can be located with this technology. The FCC required that 67% of calls provided by the GSM carriers be identifiable to 100 meters and 300 meters for 90% of calls. And the carriers, I believe, have met this requirement. The other way that the carriers have been able to comply with the E911 requirements is through the use of GPS chips. So this is a mistake that I've seen in several briefs now from different lawyers. Cell phones do not communicate with satellites. The communication stream between a satellite and a phone is one way. The satellite sends out signals and the phones all listen for it, but there's There's no response signal. So you have this network of satellites in space. Phones with GPS chips listen to for the signals coming from the satellite and can then determine their own location. GPS is very accurate. And so this is the technology that Sprint and Verizon decided to use. They've put this in every phone that's been sold for the last decade or so. Whether it's a cheap phone or a smartphone, there's a GPS chip in those devices. GPS has the downside that it doesn't work when you're indoors, or if you are in, say, downtown Manhattan and the signals, you cannot get a clear view of the sky. And so there are pros and cons to both the GPS and triangulation method. But in both cases, regardless of the company and the particular technology, all of the companies can provide real-time location data upon request that is far more accurate than many forms of historical cell tower data, although probably femtocells are more accurate than either of those other two things. And so the requirements for the accuracy of real-time GPS data is 50 meters for 67% of calls and 150 meters for 90% of calls. All right, I'm going to quickly talk about two other things. So the first is how the government gets this data. So for the first few years after this technology came online, what would happen is the government would make a request to the phone company, and a phone company employee would type in a few commands on a keyboard, and that would cause the location data to be acquired. You would have teams of employees, and in fact, Sprint is revealed a few years ago they had more than 110 employees in their electronic surveillance team doing nothing but responding to requests. And this was very labor-intensive, and the phone companies were getting a lot of requests. In 2009, I recorded a Sprint executive at a conference saying that we turned on our GPS tool web interface for law enforcement about 1 year ago, and we just passed 8 million requests. The tools just really caught on with law enforcement. And so Sprint was facing such a high volume of requests that they actually set up a self-service interface where once the police had provided the appropriate order, they could then log into this website and get updated location data themselves. It was a self-service tool. Sprint's not the only company that set up something like this, and so AT&T, these are documents that the ACLU obtained through a FOIA request. The AT&T has a GPS tool, they call it the E911 tool. They charge $25 a day for location data. Sprint, this is a copy of an invoice that we obtained. I don't know if you can see the $30 over there, but so Sprint charges $30 a month for all you can eat location data provided to the government per number. So 2 numbers, $60, 3 numbers, $90. But this is definitely much cheaper than it used to be when you had to pay an employee to type a single command. Nextel, which merged with Sprint, used to charge $150 for every time they obtained location info. And so now you get it $30 a month, all you can eat. And T-Mobile also provides data for $100 a day. So all of the big carriers now provide a self-service interface. And the interfaces vary, and how the government gets the data varies. In some cases, the police will get an email every 5 minutes with a Google Maps link to with a little dot on the map. In other cases, they'll see it on a screen. I mean, it varies, but they all provide self-service tools. So what I've just talked about are the ways that the government compels the phone companies to provide location data. The last thing I'm going to talk about is something that you'll be learning more about in a couple panels down the road today. And this is the way that the government can directly acquire location data themselves. If they don't want to use the phone company, or they cannot talk to, the phone company will not provide the data to them. So this is a cell tower, and your phone always talks to at least one tower. The underlying technical standards used by our phones today don't have any authentication, which means that your phone has no real way of knowing or proving that it is in fact talking to a phone tower run by your phone company. If you have an AT&T phone in your pocket and your phone hears a broadcast from a tower that says it's an AT&T tower, your phone will connect to that tower whether or not it is actually a real AT&T tower. There's no way of proving that it actually is an AT&T tower with the older standards, the 2G standards that your phone still respects and responds to. And so this is also a cell tower. It's a device sold by a defense contractor called Harris, the Harris Corporation in Melbourne, Florida. They're not the only company that sells this kind of technology, and it's been available for about 15 years. They're about $60,000 a pop. And they're fake towers. They're fake towers that trick your phone into talking to this device instead of to the phone company's actual tower. And the purpose of this is to obtain location data, to get your phone to identify itself and provide the phone's unique serial number, to triangulate the location of the phone. And some of these devices are also capable of intercepting communications content because to your phone, they are the tower, and then they can provide access to the actual cell network. These have been available for about 15 years. Kevin Mitnick, who was a very famous computer hacker, was actually caught using the predecessor to this device. And they're used around the country. Sheriff Joe Arpaio in Arizona has one. The police in Virginia and Maryland have them. ICE has them. DEA has them. FBI has them. We use them in military and defense operations too. And the basic way they work is that the tower, or the Stingray says, "Hi, I'm an AT&T tower," and then your phone says, "Hi, AT&T. Here's my data." They're actually not that complex, but we haven't known a huge amount about them. This is also in the Stingray family. Although the one I showed before is fairly large, this is one that is man-portable. It's worn under a vest. This photo was taken by one of my friends at a surveillance trade show. These are used to obtain information about who's been at a protest. For example, the police can walk through a protest and surreptitiously collect data about every phone that's been nearby. There are some really interesting things that we'll talk about later about the Stingray, but the only thing that I want to leave you with is the fact that these devices send out signals. They're not passive, they're not just receiving, they're sending out signals that your phone then responds to, and the signals from these devices penetrate homes. They penetrate the wall of a home, they penetrate your car, your pocket, your handbag, and then they actually go into the phone and cause your phone to respond. And so there are some really fun, interesting issues that I hope we'll discuss later about the fact that the government has this device that they drive around in a neighborhood that's sending signals out into people's homes. All right, so if there are any questions, briefly I can take them. Otherwise, I look forward to a really fun discussion today. Thank you very much. Femtocell,
Can you spell it?
FEMTOCELL, or picocell, PICOCELL.
Or Microsoft for AT&T.
Sorry?
AT&T calls them Microsoft.
Yeah, Microsoft, and they all have special brand names as well, but it's just a small tower. It's a small tower in your living room.
I have 4 in my house.
You have 4 of them, okay.
So you can know which room I'm in.
Okay. Oh, you left. Would you prefer to sit in the middle?
No, I just thought somebody else might have notes in your way.
All right, good morning. So let me just start by thanking Margot and Heather and Jack for putting the conference together. And thank you for waking up so early on a Sunday to get to this panel. We're going to be talking about location tracking and the right to privacy and the Supreme Court's decision in Jones. I'm going to let the panelists do most of the talking, but I thought it might be useful just to start by setting out a few of the questions that I hope we can address or at least touch on in the next 90 minutes. So let me set these questions out and then I'll introduce the panelists. So first, how worried should we be about the proliferation and increasing technological sophistication of location tracking technology? Chris's extremely useful presentation sort of starts from the premise that this is something we ought to be worried about, but it might be worth just thinking through why it is that we should be worried about this technology. Second, in what circumstances should location tracking be a concern of the Fourth Amendment? And in particular, should it matter what technology the government is using, or how efficient or inexpensive the technology is? Should it matter whether the target's location information is obtained directly or through a third party? Should it matter whether the tracking is invisible to the target? Or to ask that question in a slightly different way, should it matter whether the target has notice, either contemporaneous notice or delayed notice of the surveillance? Should it matter whether the government is making a permanent record of the information it's obtaining through the surveillance? Or should it matter how the government intends to use the information that it's obtaining? And then, should it matter whether the surveillance is individualized or generalized or dragnet surveillance? Chris drew that distinction between obtaining information about the location of a particular person, and on the other hand, asking cell phone companies to disclose all of the numbers that were in a particular vicinity at a particular time. And then, should it matter how precise the surveillance is, or the degree to which the surveillance is automated rather than directly controlled by humans? And then finally, and this is something that I'm sure we will talk about, should it matter whether the surveillance required a physical trespass? I think that maybe the last question I'll just identify is if location tracking should be a Fourth Amendment concern in some circumstances, and obviously the Supreme Court has now held that it is, what follows from that? What protections should kick in, and when should they kick in? So with that, let me introduce the panelists. First, on my far right, Scylla Smith is a senior fellow at the Information Society Project here at Yale. Prior to joining the ISP, she was an attorney with the Center for Reproductive Rights for 13 years. She writes about privacy, reproductive rights, and the Information Society. Judge Kaczynski, as everyone already knows, is a judge on the U.S. Court of Appeals for the Ninth Circuit. He was appointed to that court by President Reagan in 1985. He's written eloquently and powerfully about the right to privacy. Unfortunately, much of that writing has been in dissent, but maybe that will change post-Jones. And I'll skip David for now. Susan Freewald is a professor, I'm coming back to you, is a professor at the University of San Francisco School of Law. She has published widely about cyber law and information privacy and has authored or co-authored many amicus briefs in cases involving the electronic surveillance laws. And then David, last but not least. David Gray teaches criminal law and criminal procedure at the University of Maryland's Francis King Carey School of Law. He's written about retributive justice, transitional justice, and of most direct relevance to our discussion today, about the Fourth Amendment. Some of what he's going to talk about today is based on a collaboration with Danielle Citron, one of his colleagues at the University of Maryland. So I skipped David because he's our first speaker. He has very kindly agreed to provide a kind of summary of Jones so that we're all starting in the same place. So we will begin with him.
And I promise that the brilliant bits of this are all from Danielle, and any mistakes are entirely mine, but don't report back to her. So in this time last year, the United States Supreme Court, in a landmark non-decision, nearly held that we have a quantitative interest in privacy under the Fourth Amendment. The facts in Jones by this point are well known. Mr. Jones was tracked by law enforcement officers in Washington, D.C. over the course of 28 days using a GPS-enabled tracking device. And in the course of that surveillance, officers gathered over 2,000 pages of data and were able to monitor his comings and goings on private streets for an entire month. And the question presented to the court was, is this a violation of his Fourth Amendment rights, which, as most of us here know, turns out to be a question about whether he had a reasonable expectation of privacy. And 5 justices of the Supreme Court, writing in concurrence, would have held, had they had the chance, that Mr. Jones had a Fourth Amendment reasonable expectation of privacy in the quantity of that data, which is to say, as Justice Alito suggested in his concurrence, that he had a reasonable expectation of privacy in the totality of his movements over public streets for 28 days, even if he did not have a reasonable expectation of privacy as to his movements over public streets for any particular afternoon. the amount of information matters. And this is what's come to be called the mosaic theory of Fourth Amendment privacy, which is to say that when we aggregate certain quantities of data, a magic threshold is passed, after which we have a Fourth Amendment reasonable expectation of privacy that the government, at least, and hopefully nobody else, would gather that much information about us. A little bit, fine, but not too much. As I suggested a moment ago, that was not the holding in Jones, rather that was the threatened holding in Jones. The actual holding in Jones was based on trespass, because unfortunately these officers violated the terms of a warrant they'd been given and effected a physical intrusion upon Mr. Jones's car to install the device. And that was the centerpiece of what turned out to be the majority holding. But nevertheless, the shot has been cast over the bow, and Danielle and I really feel that we are in 1967. In 1967, the United States Supreme Court was confronted with facts that nearly required it to overturn Olmstead. Olmstead, of course, mentioned earlier, is the famous case where the court said that there is no violation of the Fourth Amendment if law enforcement officers install a wiretapping device and listen to telephone conversations, as long as installation of that device does not involve a physical intrusion into the home. In Katz, the court was confronted with a circumstance where conversations had been listened to, not with a wiretapping device, but with what was cutely called an electronic ear attached to the outside of a public phone booth. And the court announced that the principles underlying Olmstead had been cast by the wayside of history, but nevertheless did not directly overrule Olmstead itself. Which is to say that as of 1967, the court said, if you bring us a wiretapping case, we're going to say that wiretapping violates the Fourth Amendment. You need a warrant to do it. And the very next year, before that case made it to the court, the legislature came forward with the first iteration of the Wiretap Act, and to my knowledge, Olmstead has never been overturned on its facts. We think we are in exactly that same time now, in that same posture now, with a series of surveillance technologies, some of which Chris has described in his presentation. And so the question after Jones is how to make sense of that feeling we have that we have a privacy interest not to be watched all the time, particularly by government. What's the doctrinal pedigree of that feeling? Is there a Fourth Amendment foundation that we can rely upon? And if there is, how does that feeling get translated into a practical set of procedures and policies that can be implemented by legislatures, executives, and courts in a predictable way that doesn't lead to a whole host of difficulties for our poor Article III friends? And we're going to answer all of those I'm going to answer all of those questions for you in the next 5 minutes, and then I'm going to tell you what counsel in Maryland versus King should have said in response to some important questions in the oral argument earlier this week. And in a moment of obvious obsequity to the chair, I'm going to explain why the Supreme Court got it flat wrong in Clapper. Here we go. What is the Fourth Amendment all about? From its inception, the Fourth Amendment is creating a bulwark against the natural rise of a surveillance state. Law enforcement officers, as Justice Jackson tells us in Johnson, are engaged in the often competitive enterprise of ferreting out crime. They want to get the criminals, and that's a very good thing. But they want to get more criminals, they want to do it with less labor, they want to do it more efficiently. And this puts law enforcement officers on a teleological path towards a surveillance state. They're going to take advantage of every opportunity they can to increase their surveillance capacities. Pushing back against that natural teleological impulse is the Fourth Amendment, which tells us surely law enforcement officers are entitled to engage in reasonable searches and seizures, but they are not allowed to engage in unreasonable searches and seizures. And unreasonable here is defined by the interest of the people as against that unreasonable search. That privacy doesn't appear anywhere in the Fourth Amendment, but the court has been very clear, at least since United States versus Katz, that the real rights interest, the Fourth Amendment interest underlying that prohibition against unreasonable searches and seizures is a privacy interest. What kind of privacy interest is it? Well, it's been difficult, of course. Oh, I'm terribly sorry.
No, it's okay.
It's been very difficult to give a clear articulation of what that privacy interest is. But in our view, it is simply this. We have the people of the United States have an interest embedded in the Fourth Amendment not to live in a surveillance state. And so the Fourth Amendment, as enforced, ought guard against the natural rise of a surveillance state. And there are good foundational reasons for thinking of the Fourth Amendment in this way, and Danielle and I have elaborated them, but the two that I'd like to present to you now, and we'll talk about at great length, I'm sure, for the rest of the day, are a basic liberty interest in not being watched all the time. There is an effect on us in being watched. It's not just creepy, but it limits our capacities for ethical self-exploration, for ethical self-development. It limits our capacity to develop ourselves as persons and as citizens. And therefore, there's also a democracy interest in not living in a surveillance state, which is to say that it's impossible to have a thriving democracy where ideas compete and political views are developed and expressed if the government is watching us all the time, everywhere we go. And so the Fourth Amendment is the primary constitutional tool to preserve those liberty and democracy interests that are behind our interest and our privacy interest in not living in a Fourth Amendment surveillance state. What then does this tell us about cases like Jones? Well, as Danielle and I argue, it's wrong, just wrong, to think about these privacy interests on a case-by-case basis, looking at how much information law enforcement has gathered on us in a particular instance in a particular investigation. Rather, the concern at the surveillance state is one that is, I'm going to shortcut a little bit and just say, almost collectively held. It's our interest not to live in a surveillance state. Surely it's mine individually, but it's ours together, surely. And what we're worried then is about the unfettered access of law enforcement to certain surveillance technologies. There really is no surprise here, right? What is the prohibition against unreasonable physical search and seizure, and including kicking down our doors and looking through our bedside table all about? Do we prohibit law enforcement officers from effecting physical searches of our homes? Of course we do not. What we do forbid them to do is go wherever they want, whenever they damn well feel like it. The unfettered access to physical search is what the Fourth Amendment prohibits and guards with the warrant requirement. We're not proposing anything more radical than that, which is to say that we should identify the kinds of surveillance technologies that have the capacity to facilitate broad and indiscriminate surveillance, and those technologies should come under Fourth Amendment control. What does that mean? Nothing more than we know it's meant since 1967, which is that courts or legislatures or executives should come forward with constraints on access and use of those surveillance technologies that will affect a reasonable balance between the legitimate law enforcement interests at stake in those technologies and the privacy interests threatened by those technologies. With that in the rearview mirror, I would like to turn now first to Clapper. And how much time do I have, Jamil?
2 minutes.
2 minutes. All right. I'm in good shape. I'm going to first talk about Maryland versus King then, because
You
counsel
should
for
definitely get the clapper.
counsel for Clapper can defend himself, or he can extend my time in order to affect his interests. So Maryland versus King, which was argued in front of the court earlier this week, deals with a bill in Maryland that allows law enforcement officers to take DNA samples from individuals who are merely arrested for violent crimes, and to feed those DNA samples, the results of those DNA samples, into both a state and federal database. They also take the entire genome that's taken out of that sample and give it to a series of health record databases for scientific research. And we don't have any difficulty in finding that this kind of DNA testing technology, and particularly the integrated sharing of DNA testing results, is the sort of technology that would facilitate broad and indiscriminate surveillance. And so if you grant me this, then the question is, how do we effect a reasonable balancing of competing interests behind this kind of policy? And in order to demonstrate how this balance might be affected, I want to give what should have been the answer to a couple of questions that were given to counsel at Tuesday's argument. Justice Ginsburg. But these are all cases. I mean, the dominant use is to solve what they call cold cases. Yes, Your Honor, that is precisely the primary use of this technology. It serves legitimate law enforcement interests in solving cold cases, catching people who have not been caught and convicted, and also for releasing the innocent. Question. But your argument would not be so limited, would it? Under your theory, there is no reason you couldn't undertake this procedure with respect to anybody pulled over for a traffic violation. Well, Mr. Chief Justice, in fact, there is, because that would surely affect an unreasonable balance between the competing interests at stake in this kind of technology. To allow us to take samples from anybody and everybody would surely err on too far on the side of law enforcement interests and facilitate exactly the kind of surveillance state that the Fourth Amendment is designed to prevent. Therefore, we've struck a balance at the center somewhere by allowing us to take samples only from people who have been arrested. But if it's just to solve cold cases, which is the way you started, then it's just like searching your house to see what's in your house. That could help solve a cold case, couldn't it? Well, surely it could, Your Honors, but as we all know, the warrant clause stands between law enforcement officers and physical searches at homes because that provides a reasonable balancing of competing interests that are at stake in that search technology. We think that the legal constraints on access and use to DNA technology affected by this law provide an equally valid balance. Sorry, I have to skip back and forth between the records.
Are you doing your right answers or the ones?
I'm saying my right answers.
Oh.
Question, which is, there is something inherently dangerous about DNA collection that is not the same as fingerprinting. Exactly right, Justice Sotomayor. Fingerprinting is not DNA. There is infinitely, literally infinitely more personal information embedded in our DNA than there is in fingerprinting, and so DNA testing is different, which is why, if I were writing this law, I would say we ought to destroy the samples immediately after their use. Justice Kagan, the future is very close, isn't it? The future is here. And so it is incumbent upon legislatures, executives, and the courts in combination to come up with reasonable constraints on access and use of this kind of technology while recognizing and preserving the legitimate law enforcement interests that surely are served by technologies like DNA identification, GPS-enabled tracking, and so forth. Sorry, Jamil, thanks for the extra 10
Sure.
minutes.
Yeah, you know how much I want you to get to Clapper, but maybe we can do that in the Q&A.
I would love to do
Yeah.
that in Q&A.
Yeah, okay. Scylla, I hope you have had lots of coffee this morning and can,
I'm working on the
All
Diet Coke.
You need, yes.
Broadcast can hear you clearly. Can you make sure the microphone is aimed towards you so we can hear you?
Yes. How's that? Good? Okay. Wow, that woke me up. If the Diet Coke didn't, David will. Okay, I have three sort of stories to tell, so I'm going to try to tell the three stories within my 10 minutes, I think. Let me say first that given my background, which is in the reproductive rights world, the thing that was most fascinating to me about the concurring opinions in Jones, although I find the physical trespass thing sort of interesting for separate reasons. But the most interesting thing to me about the concurring opinions was the difficulty they had in saying what exactly is wrong with this GPS thing. It seemed obvious to them at oral argument. As soon as Justice Roberts extracted an affirmative answer to the question, you mean you could put this tracker on all of our cars and track us everywhere? And the government lawyer said, well, yeah. And so that it was obvious at that point that the court was going to strike this thing down come hell or high water. They just didn't know how. As Walter Dellinger said at a conference that some of us were at recently, it was as if they were saying, this can't be doctrine to follow. Now, they were like this at oral argument, but they were also a bit like this in their opinions as well. And my contention here today is that although I think the concurrences fail as models of clarity, there is a rule that we can use to guide evaluations of surveillance techniques in the future, and it's just a heartbeat away. But first, to do it, I think we have to resist an overemphasis on the mosaic theory, or the aggregation theory, as David puts it, to determine when a reasonable expectation of privacy has been violated. An overemphasis on mosaics has two impacts. It results in an overly narrow view of the justice's privacy concerns. And second, it serves to obscure the important role that original principles played in limiting the reach of the rule that they're setting out. So the failure to see these limiting principles in the concurrences has led to significant anxiety among the prosecutorial community and their chief defender, Orrin Kerr, particularly. Maybe it's just his anxiety, but there's anxiety about how this rule will apply to future surveillance techniques, and a concern, this is the most surprising to me after reading the opinion, a concern that the Jones ruling and mosaic theory will be applied to limit human surveillance by individual officers themselves. So the point of, and I've written a paper, a bunch of us were at this conference, so I've written this paper for the North Carolina Journal of Law and Technology, in which I go into this in more detail. But what I'm trying to do is provide a path forward. I think it's a path that the court wants to follow and needs a little help in following, and I think it's also the right path. The end point of my article and this thing, it's a little self-serving because it's a rule that we proposed in an amicus brief that we filed. But I think it's the proper rule, and I think the court wants to get there. But the end point is a rule that's both broader in some ways and more limited than the mosaic theory alone implies. It's broader in the sense that it finds surveillance intrusive not just where the technology collects a mosaic of information, a mosaic being, as David described, something picks up individual tiles of information and creates a broader picture of you, but also where the surveillance technology chills expression of constitutionally protected behavior that can take place in public with other people, but is nonetheless private. Now, I just want to take a little break here to advocate for something to those of you who are lawyers in the group, which is not to be too lawyerly, to take a step back from your overdetermination of terms and terminology, and to think more like a poet sometimes when you read these things. So when something says it happens in public, that doesn't mean it's not private. And you know, this is, I think, a problem that lawyers also have. It's a problem we have with this term reasonable expectation of privacy. Nobody can really figure out why that doesn't mean if the thing is happening already, then you no longer have a reasonable expectation of privacy in it. Well, that's just ridiculous. I mean, of course, the general warrants were happening, but they were the purpose of the Fourth Amendment. So it's not a reasonable expectation in that it's not going on. It's what we should reasonably expect to be limited to, you know, to control about ourselves. So, okay, I'll put that aside. I know, I only have 5 minutes. Okay, so the first point that I want to make, okay, I'm just going to go straight to my first story, which is the holes in the mosaic, and why I think there are holes in the mosaic, and it's important to see them. And to illustrate these holes, let's start with a scenario that I think is more inclined to capture the fancies of a younger generation than our old references to 1984. Imagine that Chancellor Palpatine, the Star Wars character, and virtuous senator from Naboo, who is really the evil Darth Sidious in disguise, sets out to discredit the Jedi and their Senate supporters so that he can monopolize power. He orders a tracking device that relays information back to giant computers that produce, does it relay information back, Chris? No, it doesn't. See, okay, it collects information from the, yes, okay. I have to correct that in my paper now because I got the technology wrong. Anyway, so he puts these tracking devices on all these people and he follows them. He discovers Anakin's relationship with Senator Amidala. He discovers that Obi-Wan buys cartons of death sticks despite actually being a spokesperson against them, right? And he also finds out that Amidala, despite her relationship with Anakin, actually frequents a lesbian bar called Sisters with some of her more attractive friends from the planet Naboo. He also finds out that Mace Windu and Yoda take out their spaceships and speed through Coruscant's back alleys for fun, and he uses all this information to undermine his targets and turn them against each other. All the characters resist his blackmail except for one, Anakin, of course. This all may seem far-fetched. After all, Jedi are trained in the ways of the Force. But here on planet Earth, the Supreme Court has acknowledged that history And most recently, Anjali Dalal actually has done this too, even though the Supreme Court hasn't acknowledged it yet. But history and Anjali Dalal abundantly document the tendency of government to view with suspicion those who most fervently dispute its policies. And given our history and some current practices as well, it's not difficult to imagine, for example, an administration devoted to a culture of life, targeting the staff attorneys at the Center for Reproductive Rights, hypothetically finding out that 50% of them are gay, 30% are Muslim, and one of them has fathered 3 children by 3 different women. These are all hypothetical examples. They use the information in various ways to undermine the center's litigation and public education efforts. On the other side of the aisle, perhaps President Obama and his administration track Paul Ryan during the campaign, and they track a number of them who of his staff members who are pro-life, and they discover that Paul Ryan works out at a gay gym. His staff members visit abortion clinics during hours when procedures are performed, no protests are underway, and the administration uses this information to discredit them with conservative constituents. Okay, so these are realistic, I think, in my view, scenarios. And let's look at how the Mosaic would look at these things. The Mosaic does do some good work here. It connects not only Amidala's relationship with Anakin, but also her visits to the lesbian bar that she's not told Anakin about. So it might be worse than non-aggregation. If you have this aggregated information, you have more material with which to blackmail Anakin and turn him against Amidala. But the Mosaic doesn't tell the whole story, and aggregation of all this data isn't the only problem, and it may not even be the most important problem with GPS or with this kind of surveillance. The most common examples of the technology's intrusiveness involve the possibility that certain information will be obtained, information that can be obtained just by discovering one trip to the gay bar or one trip to the abortion clinic. And in fact, the concurrences, although they lean on the Mosaic concept, they don't fully embrace it. They don't cite to the Maynard decision, the lower court decision in the case itself, which has an incredibly persuasive, to many of us, discussion of the Mosaic. They don't cite to Judge Kaczynski's also incredibly persuasive and eloquent dissent. I'm not sucking up here. But it was widely quoted in the briefs, in amicus briefs before the court. They make no reference to it whatsoever. And they don't cite at all, strangely, to Maynard on that point, on the Mosaic point, which is odd. So I said, something is up here. And I looked at Sotomayor's concurrence, in which she talks about the New York State case, People versus Weaver, and she quotes from that opinion where they talk about the discovery of trips to a psychiatrist or a plastic surgeon, an abortion clinic. She talks about the indisputably private nature of these trips. And then she makes a significant move beyond mosaics when she suggests that a more fundamental change to the jurisprudence should be considered, to reconsider the third-party rule. And, oh dear, I have 1 minute. And she questions the notion that secrecy is a prerequisite to privacy at all. I think Alito also makes very little use of the Mosaic concept, also doesn't quote to any of these decisions. And he says, the best we can do in this case, he sort of throws up his hands, is to apply existing Fourth Amendment doctrine and ask whether there's a degree of intrusiveness that's been violated. Now, so this is why I think that actually the rule that they're pointing to here is a broader rule than the mosaics. So let's move on to my second story. Can I? No, I can't. But what I will say is that at the end of the day, if you go through the oral arguments, it's actually very interesting. You can see the justices, the concurring justices, pick out the two principles that in the end they're going to rely on. And Breyer talks about how what we're trying to do here is to figure out what's the difference between human surveillance and 24-hour GPS surveillance. They come back to this over and over again. And at the end, they rely on two principles. And this comes up in the oral argument, and then it's in the opinions. When the normal resource constraints no longer apply to surveillance technology, the Fourth Amendment requires that abuse must otherwise be constrained. And this is in the concurrences as well. And then, as Justice Breyer, sorry, Brennan. Oh, Justice Breyer refers to, I know.
Fun memories.
I know. He talks about the harm of living in a surveillance society. He says, take it backwards. What should a democratic society look like? And what the court comes to is that a society, the harm of living in a society where technology is used to follow you all the time is the enormous chilling effect that will have on people, on people's associational and expressive behavior. As Justice Sotomayor says, awareness that the government may be watching chills associational and expressive freedoms, and the government's unrestrained power to assemble data that reveal private aspects of identity is susceptible to abuse. So these are the two things they rely on. It limits the ruling on mosaics to not human surveillance until we have a clone army, at least, that can follow everybody around. Human surveillance is not susceptible to the type of abuse that they're talking about. So, or incurs concern about human surveillance is sort of, we deal with that very easily and quickly that way. But it also, it looks at whether there's a type of technology or type of surveillance that is going to chill our associational and expressive freedoms. And I think this is the rule going forward. In the paper, I talk all about how this is a perfect example of living originalism with a nod to our friend Jack Balkin. I think it is. I think this is what the court is doing. It's trying to figure out a way to take old concepts, original principles from the Constitution and apply them in a way that makes sense for technology that the framers could have had no idea would ever come into existence. Thank you.
Thanks, and sorry to...
No, I'm sorry to take so long.
Okay. Susan?
All right, thank you. Audience members, virtual and real, gaze upon our panel. This is a group that is actually well prepared to answer the myriad questions that Jamil just posed, really asking us to come up with a test, a very detailed test, for addressing the many questions that the Jones decision left open. In particular, how does the Fourth Amendment apply to location surveillance when there isn't a physical trespass? For example, when the law enforcement agents use cell site location data, as Chris Segoyan was talking about, or when they use a remote turn-on of location devices, for example, when they use the GPS device that our cars have or our phones have. These are questions the decision left open. Another really important question the decision left open, is a warrant even required? Is probable cause required? All these questions the decision left open. And this panel is among some of the best situated people to answer that. Scylla has an article coming out where she elaborates on her second and third stories that we didn't really get to hear about, and her test. David Gray, along with the talented and brilliant Danielle Citron, have a series of articles in which they elaborate on their test. Priscilla, when she when she filed the brief for the Yale ISP, was good enough to include a test that I have worked out in some of my scholarship, detailing the 4 factors that I recommend that we use, that I can talk about in Q&A for surveillance, when surveillance should be subject to the Fourth Amendment. My 4 factors, I'll just put them out tantalizingly, are that when surveillance is hidden, continuous, intrusive, and indiscriminate, it should be subject to the highest level of Fourth Amendment protections. So there are other people who are doing good work in this area. Chris Slobogan. Oren has got work out in this area, Oren Kerr. All this work could be informing and aiding, I forgot to mention Judge Kaczynski, who has already been complimented on his very eloquent dissent in the hearing from En banc and Pineda versus Morena, and has been at the forefront of very forward-thinking and intelligent and eloquent decisions about how to apply the Constitution to new technology. For example, just actually had a really important decision about the Computer Fraud and Abuse Act, comprehensive drug testing. The Ninth Circuit really benefits from Judge Kaczynski's analysis. And yet, I'm here to tell you a sad story, which is that all of this work is not getting into the courts. And the lower courts are not doing the important work of percolating the Jones test and figuring out how the Fourth Amendment should apply to surveillance, both directly applicable to Jones, in other words, following the Jones facts, and extending out from the Jones facts involving other types of location surveillance. And the reason for that is because of a decision that the Supreme Court issued the year before Jones called Davis versus United States. And in Davis, what happened was the Supreme Court considered whether or not to, well, let me just say it this way. The Supreme Court expanded the good faith exceptions to the exclusionary remedy. So everybody knows Leon, which says that if the officers rely on a defective warrant, the court should deny the suppression remedy based on the good faith reliance on a defective warrant. And the court has extended that to if officers rely in good faith on a statute that's later found to be unconstitutional, that's okay. We shouldn't penalize them by granting a suppression remedy. And what the court did in Davis is find yet another reason to deny a suppression remedy, and that is when officers rely on binding appellate precedent. So when the precedent at the time of the officer's conduct gave the officers reason to believe, basically, that what they were doing was legal, then even if that conduct is later found to be unconstitutional, courts considering motions to suppress based on that conduct later found to be unconstitutional should deny them. And so so the Davis decision did two things. One, it was basically actually decided on the basis of an automobile search. And so it was based on a separate set of facts. In the case of Davis, the search, the court actually said that Davis, the search that they conducted in Davis was clearly unconstitutional at the time based on binding New York precedent. And so the actual holding of Davis, the narrow holding was when binding precedent specifically authorizes the conduct of the search, you should excuse the conduct in the sense of not granting the exclusionary remedy. But there was also a lot of language in the decision of the Supreme Court where the Supreme Court indicated its distaste for the suppression remedy. And it really was dicta, but it was a lot of broad language saying that the exclusionary remedy is not a personal right, and we should engage in a cost-benefit analysis where we weigh the cost to truth and public safety in granting the exclusionary remedy against the benefits to deterrence, which the court found were really not there unless the officers had engaged in sort of flagrantly culpable conduct. So going back to Jones, after the Jones decision, the Supreme Court remanded some cases and said, hey, circuit courts, figure out what to do in light of our decision with these surveillance investigations where the decision is still pending. And one of them was the Pineda-Moreno case. And they sent it back to the Ninth Circuit and said, what do you think? Do you think this surveillance should now be considered illegal in light of Jones? And the Ninth Circuit could have looked at the 2010 decisions, including Judge Kaczynski's dissent from rehearing on Bank, and said, wow, Judge Kaczynski made some very convincing arguments about how the surveillance will take us into an Orwellian state, and particularly considering that 9 justices of the Supreme Court just didn't approve of this GPS surveillance, let's reconsider this whole question. And instead, because the government raised the Davis good faith argument, the panel said, let's look back at our precedents from 1999 and the 70s to figure out if, in 2007, when the officers engaged in the surveillance of Pineda-Moreno, they thought that what they were doing was legal. Oh, yeah, they did. And so that's an example of a narrow application of the Davis rule that shows you that in a case where the binding precedent in the circuit was applicable, the courts will avoid thinking about how Jones applies. And so the Ninth Circuit said, Jones actually makes this conduct clearly unconstitutional, which we're not going to give any further discussion to. But once the cases get out from under the shadow of Jones, in other words, once the investigation takes place after January 2012, then we'll figure out what to do with Jones. So in the narrow application, we're delaying consideration of Jones for that several year period until the investigations took place after Jones was issued. Much more pernicious and that's pernicious and troubling on its own because again we have to wait several years to get the benefit of Judge Kaczynski's reasoning and the reasoning in the Seventh Circuit, which also had a very interesting decision in Cuevas Perez that we won't get the benefit of. But more pernicious and troubling even than that is that courts are using the broad language from Davis to reach out beyond, in circuits in which there is no binding precedent, to engage in this broad cost-benefit analysis, this focus on officer culpability, and say, well, we don't have binding precedent in this circuit, but the consensus of the law generally at the time tells us that we shouldn't grant the suppression remedy. And so in those cases, they're denying the suppression remedy. And what I should make clear, if I haven't made clear previously, is in cases where they're denying the suppression remedy, again, they're not engaging in the Fourth Amendment analysis. They're saying, why should we engage in the Fourth Amendment analysis? We're not going to grant this defendant suppression, and we don't need to get into constitutional issues where it's not necessary. Or else they're engaging in a very cursory analysis and saying, but this is dicta, so we don't want to spend a lot of time here. And so we're really losing the development of Fourth Amendment law, which, by the way, Oren Kerr predicted when he wrote several articles about the negative effect of Davis on Fourth Amendment law development and when he argued Davis to the Supreme Court. Most troubling is that courts are using a just ridiculously expanded version of Davis to apply it to location data that's not even involving GPS, and they're just completely untethering Davis from its facts. And an example of that is Jones on remand. And so on remand, the district court in the DC Circuit considered whether Jones could make a claim based on prospective location data surveillance. And the officers in that case got a D order, which no court really had approved of. You have to get either a hybrid order or a warrant. And the court, in analyzing this, said, oh, I think there was good faith reliance on a warrant, and there was no warrant. I think there was good faith reliance on the statute, and the statute on its face wouldn't have allowed this kind of surveillance. Oh, well, Davis. And the court said, no suppression remedy here, and I'm not going to talk about the Fourth Amendment. Someday, maybe we will. And if that trend continues, I think I have to stop, says my next door neighbor here. If that trend you wanted me
You have 2
something?
minutes.
Oh, I have 2 minutes. Oh, okay, so maybe I can slow down. If that trend continues, I have to read my signs better. If that trend continues, then Davis will be used to really inhibit the use of the Jones rule beyond the actual facts of the case. We will not have the benefit of the tremendous learning of this group and others like us. And I just want to say also, I did a preliminary look at trying to acquire some statistics. And when I say I mean me and my research assistants. And we found, this is just preliminary, I have to not massage, but I have to massage these numbers. No, I have to, no, I didn't say that. I have to check the work of my research assistants and make sure I'm doing the search right. But we did a preliminary search of lower court cases in the year post-Jones, where we looked at cases that cited Davis, Jones, and GPS. And we found 36 cases that fit that description in Westlaw. And of those, 30 granted the Davis good faith exception, 6 didn't. 32 denied suppression, 4 didn't. And we found that only 10 engaged in Fourth Amendment analysis. And I think that number's inflated because I don't think my research assistants quite understood what I meant. But at most 10 engaged in Fourth Amendment analysis. And some of those, again, were either just a standing analysis or, I think this is what is right, but it doesn't really matter because I'm going to deny suppression. So the Davis case is having a significant impact on the development of Fourth Amendment law. In other words, it's inhibiting it. And just lastly, I think this is really going to force us to think about the fact that the Supreme Court really doesn't like the exclusionary remedy. And if we want meaningful privacy rights, we're going to have to look elsewhere. But I haven't fully developed that idea, but I think that's where we're going. So really interested in your questions and in hearing from Judge Kaczynski.
Thanks, Susan. Judge Kaczynski.
Thank you very much. First of all, I want to thank Jack, Margot, and Christopher for inviting me here. I go to these conferences because I learn a lot, and I find I can better understand this complex world we live in technology when I attend conferences. Christopher and I were at a conference 3 years ago, and that's when I first found out part of what he showed us today, and I then wind up citing in an opinion and sort of shaped my thinking about the area. And I read Susan's paper about Davis. I wish I'd read it a year ago. I guess it
I
was
didn't write it a year ago.
before Pineda Moreno came out of our court on remand, because I know I did not appreciate the significance of Davis, and probably didn't give the case as much consideration as I should have.
Maybe it's a good thing you hadn't read it. You might
Well-
not have written that.
No, this is on remand. This is on remand for the Supreme Court. So this is very useful. I'm here mostly to listen, so I'm going to say very limited things. I'm going to try to stick to the 5 minutes. So I'm going to speak just narrowly about the one point that Scylla mentioned that was in Justice Sotomayor's concurrence in Jones, and that is the problem of a third-party doctrine. This is a huge, huge problem in this area, and I want to try to explain why, and why it's going to be so difficult to overcome and to deal with it. And if you go back and think about Katz and what happened in Katz, the Supreme Court adopts this rule, this sort of new principle of the reasonable expectation of privacy. And what they said is the conversation is private. Why? Because it's a telephone conversation, and he closed the door to the phone booth. It's really sort of significant as you start to think about it, because they look at the world and how it operates, and his conduct in the context of that world. There was a phone booth, and he closed the door. Now, think about what happened if the case happened today, right? The conversation would have happened on a cell phone with somebody yelling out and being able to hear this. So I'm not sure they would have had quite the same perception of how telephone conversations work. But anyway, they made the decision, and I think they're going to stick with it when it comes to telephones. But at the same time, they said, and not in that case, but in a sort of related series of cases, the information about the phone number, about what phone number he called, is not private. So the content of the conversation is private because he closed the door. But the phone number, he had to punch into the phone, or I guess in those days it was an actual dial into the phone. And by dialing the phone, he informed the phone company. And because they informed the phone company, it can't be private because he disclosed it to a third party. And that's what authorized pen registers. Does anybody remember pen registers and what they are? These are little devices that were attached to a phone line that would be able to figure out the beeps every time you or clicks every time you did a dial. So when you dialed a 9, it would click 9 times, and it would count how many times. So you could tell what phone numbers you called. And those things were considered, are still not considered to be private under the Fourth Amendment because they're disclosed to third parties. Well, the world we live in now is one where we constantly disclose information to third parties, often unwillingly. It used to be that you go into a store and you'd buy a book, and you'd pull out $5, and usually got change from that if you bought a book. And what book you bought and how much you paid for it was between you and the bookseller. And maybe somebody standing there near the catchers observing what you're doing, but that was it. Now you generally pay with you may buy it online, or if you don't buy it online, you actually go into a store. You generally don't pay cash. You generally use a credit card or a debit card, and that information gets sucked up by the credit card company. It gets sold to Expedia and the people that, what are the other credit reporting services? And then it gets aggregated. They wind up, and this I found out just in the last week or so. I was at another conference. This is why these conferences are so useful. I was somebody from the industry that provides content, and what they do is they now can tie your credit card to your set-top box. So when you are watching a program and it cuts to commercial, the commercial you get may be quite different than the commercial in the person next door watching the same program. So I said, how do you do that? He says, well, there are microchannels on your cable TV or satellite, and they will switch you to the cable, so they have different commercials running parallel. And if you are there at home, guys, and you get a Viagra commercial, it may be that, and this is exactly the example that the guy told me. He says, you don't know. Is it that they think something about me that I don't particularly want to disclose to the world? Or is it that everybody got a Cialis or Viagra commercial? Chances are very good you got that Viagra commercial for a reason. The reason this is so significant is the third-party doctrine holds essentially that the government can see anything you disclose to a third party. I mean, they are I think we don't acknowledge this often, now those of us who are concerned about privacy. The government is involved in very important work. They are there to fight crime, they're there to root out child pornography, they're there to look for terrorists, they're there to protect us from all sorts of evildoers. So they are doing incredibly important work. I mean, we just want them to do it in a responsible way, but what their objective is really important. And what the Supreme Court has said in the third-party doctrine, if other parties, if you disclose information to third parties, then you can't say it's private from the government. And this goes back to a case from about the same time as Katz, a case by the name of Hoffa. Who here remembers Jimmy Hoffa? I saw him down the block just anyway, Hoffa was prosecuted. For those of you who don't know, he was the head or boss of the Teamsters at the time. And he was prosecuted by the government for various, the kind of activities that union leaders sometimes engaged in those days. I'm not saying he was guilty, but
Wasn't it
he was
tax?
guilty, yeah, okay. Well, I don't know. The point is, and the way they prosecuted him, much of the evidence came from information that he himself disclosed to people around him, one of whom was a spy for the government. They planted somebody there who was present when he discussed all sorts of things, including matters that were of attorney-client, that would be normally protected by attorney-client privilege. And what the Supreme Court says is, look, you have a choice on choosing your friends. And if you happen to be dumb enough to choose somebody who then betrays you, too darn bad. You are not protected. Now, I don't know how you feel about Hoffa. I'm
ambivalent.
I'm ambivalent about it. I think there's some logic to it. But at the very least, Hoffa made the decision. He trusted the stool pigeon, and he made the decision. He made the disclosure. He could have asked the guy, go away, and if he'd been suspicious enough, and I'm going to have a conversation with my lawyers, leave the room. He didn't do that, and at least he made what one might think is a reasoned choice about it. The problem is that much of what we do in daily life, we disclose all sorts of information to third parties, and most of us, even those of us who believe ourselves pretty sophisticated about technology, have no idea we're disclosing it to third parties and have no full appreciation, just the degree to which we're disclosing it. The business that Chris was talking about, until I heard him talk about it 2 or 3 years ago, it didn't dawn on me. Now, once he explained it, I said, duh, of course. How are they going to find you on your cell phone? They don't just guess. The only way they can find you is because you log into a cell tower. So, the way somebody in Paris or Tel Aviv can get a hold of you, even if you happen to be in Lubbock, Texas, or someplace like that, is your phone is constantly talking to the cell tower saying, here I am, here I am, here I am. And it's a very good thing, because when you get a phone call, it can find you very quickly. If the phone didn't do that, you would miss a lot of calls. But you don't think about it until somebody points out to you that's what you're doing. And once you do, you become a slave to technology. Does anybody here not have, just raise your hand if you don't have a cell phone with you. Right. Okay, I ask the same question of people, and of course we can all be pinged, and we can all know where the great left-wing conspiracy is going on right here. Anybody here, how many people here, and then I usually get 1 or 2 hands, right, doesn't have a smartphone? There we go, okay. Okay, usually that's about the sprinkling of hands I get in a group like this. And, of course, the smartphone delivers all sorts of additional information, as Chris explained. Not only the GPS information, and of course, if you take pictures, it puts all that data in the pictures. And the third-party doctrine is a really, really difficult hurdle because we disclose, and I'm going to just take 1 more minute to talk about why it is such a difficult problem. We could have legislation, for example, that says, look, go away, Experian. We're not just concerned about the government, we're not just concerned about the government. I think it's sort of creepy to have stuff funneled to me based on my purchases, or to have people relating to me in ways that are shaped by sort of how I Google, but it happens all the time. I find it sort of creepy. Doesn't matter if there's a government involved. I mean, even if the government is not involved, I find it sort of creepy. But I often ask myself the question: let's say we had legislation and Congress said, look, we're going to put a stop to all this stuff. It's just not going to happen. You can't do it. You just can't gather information. It doesn't care whether you're government or private. You can't gather information unless you get an explicit waiver. Well, there are costs involved. There are serious costs involved. The reason you pay as little as you do for your credit cards is that they sell this information to Experian. The reason this winds up subsidizing your cable viewing and so on, there's a lot of money involved in this. Google is free because they get ad data which is targeted to you based on your searches. And let's say we put an end to all of that. People would have to start paying for Google. People would have to pay for credit cards and all that. And I often ask myself the question, much as it bothers me and rails me, and I get, I'm not going to use the word, but I'm going to tick off about it. That's the word. Would I be willing to pay $10 a month to avoid it? I think so. Would I be willing to pay $100 to avoid it? I'm not so sure. Would I be willing to pay $200 to avoid it? I think you're now coming to my price point. I think probably not. If it's $200 for the whole family, maybe. But if it's $200 for me and my wife and my 3 sons and my grandchildren, that's real money. So the reason I think this is going to be very difficult to do is people are basically cheap. I mean, we've gotten used to getting the stuff on the cheap by selling our privacy. It's a deal it's a bargain we didn't start out making. It was made for us, but we've gotten comfortable with it. And I think it's going to be very difficult to get people Congress to legislate, for example, and say, we're going to put a stop to it. You go and start paying for it. I think people are going to rebel, and they're going to say, no, I want my free Google, I want my free email, I want cheap credit cards, and so on. And so long as we are willing to sell our privacy for that kind of price, which I think I don't think I'm being pessimistic here, but I think that's about the price point for a lot of people. I think that it's going to be very hard to complain that the government gets the same stuff that we're willing to sell so cheaply to third parties.
Thanks, Judge Kaczynski. I think I'm going to just make one comment/question of my own and then open it up to you guys. So the third-party records doctrine, obviously I think probably all of us, on this panel would agree that is a real problem. But I also think that there's a relatively easy doctrinal solution to it, which is that rather than hold that merely by disclosing information to a third party, you lose your constitutional privacy interest in that information. The court would just hold that the mere fact that you disclose information to a third party doesn't defeat your constitutional privacy interests. That would solve the problem. Now, it wouldn't actually, it wouldn't solve every problem, because you'd still be left with the question whether in the specific case there was a reasonable expectation of privacy or not. But for that reason, I want to ask a question about the reasonable
Let me
expectation.
just make a retort to that, and let me just, I'll just pose a question. So the government says, fine, we don't get it for nothing, but if Experian can buy it, we can buy it. And we're willing to pay for it. How do you stop them from buying it? Just like they're taking data from the phone company, right?
But buy it from the consumer or buy it from the third party?
Buy it from the third party,
But wait.
just like Cox does.
Make them buy it from me, and then I get to decide.
David, you want to weigh in on that? Or?
I do, because this is another problem that Danielle Citron and I have solved elegantly. And in our view, if the focus is on the technology and the capacity of the technology to facilitate a surveillance state, then we're not asking about the kind of information that's gathered or even how much information is gathered. We're talking about controlling access to that technology. And so if that's our focus, then the third-party doctrine is not the problem, or rather, to the extent it's a problem, the solution is the state agency requirement, which is to say that if a company like Google or a telephone company is so regularly a target of demands for information using technology that, if it were directly used by the government, would raise Fourth Amendment concerns, then that company has become a de facto state agent. And we would need to erect some kind of a legal wall between the government and that private entity, like a warrant requirement or an enhanced subpoena requirement, that would provide that would allow us to preserve that wall between public and private. It remains true that these private agencies might raise their own concerns, but by definition, they don't raise Fourth Amendment concerns. And so those would be difficulties for legislation, but not difficulties for Fourth Amendment.
So I'm going to let other people respond to that, but I actually just wanted to ask, I didn't quite get to my question, which was, at least 2 and maybe 3 panelists denigrated the reasonable expectation of privacy test. And I'm wondering what we mean when we denigrate that test. Do we mean, do we think that this is a problem that in some way we're stuck with, or is the reasonable expectation of privacy test, is it like democracy? It's the least worst option. You know, there are lots of problems with it, but we don't have a better solution.
Did I denigrate
Yeah, I don't
it,
think-
in your view?
Well, I think
I
that-
referred to this
I thought you
problem
did,
that
but-
lawyers have with understanding it. So that people say, well, it's a circular test
Mm-hmm.
because as soon as the surveillance is happening, then you must reasonably expect it to be happening, and therefore you've lost your expectation of privacy, which is just stupid in my view. I don't understand why people think that when it's clearly not about that, because the general warrants were happening, and so if that was true, you reasonably expected police to come in any time. So it's just a problem with lawyers being
The way we apply the
narrow-minded.
doctrine rather than- right,
Yeah,
right.
narrow-minded in
Right.
our interpretation of words.
Right.
Yeah, my problem with it is that it's really difficult for judges to do it right. And I think the reasonable expectation of privacy test, as it was originally applied and derived, required a normative assessment of the kind of risks we should be entitled to not accept, what we should be entitled to expect in our society. And that's how it was designed. And the problem is that judges, particularly today, are uncomfortable making those normative judgments. And so instead, they look for shortcuts to avoid it. And the shortcuts they look for are problematic, like, for example, the third-party rule, or, for example, a non-content distinction. And so, or, for example, the one that Priscilla just mentioned, which is, well, this information is capable of being intercepted, therefore you don't have a privacy interest. And I think Jones is yet another example of, well, we don't like this reasonable expectation of privacy test because we don't want to face this normative question, so we're going to look for some kind of a shortcut. And I think this is why I came up with my 4-factor test, to try to give them something else to grab onto that is actually rooted in doctrine, that provides some elaboration of the test. But I think the test is asking a reasonable question, which is, And it's related to what David and Danielle are asking, which is, and what Justice Sotomayor came up with, which is how do we balance law enforcement against privacy interests in a way that works in the society we want to live in? And I think the Supreme Court could come up with a different version. They came up with cats, come up with something else. I don't think they have to use that, but they have to solve that question in a way that works with the Fourth Amendment.
And in 2 sentences, I concur with these views, and just to say that the reasonable expectation of privacy test is a normative test, not a descriptive test. And so the question is, what's our normative expectation? It's not an exercise in autoethnography. Otherwise, we are doomed to what Danielle cutely calls technological determinism run amok, which I love that line.
I like ethno what?
Autoethnography.
All right, that's good, too. If there are questions, I think we're going to use these mics. Is that the idea?
Yeah, there's a
Right.
line right there.
Okay. Go ahead.
So this has been fantastic. I think this is really very interesting and really informs my criminal investigations class, is discussion of that. So in Jones, wiretapping was held up as a triumph of the way in which a legislative response to a Fourth Amendment problem was enacted. But it sounds like if we took Judge Kaczynski's view, you would just have a per se rule against wiretaps. Because, I mean, everyone, unless they're shouting into their phone, thinks the only person they're talking to are the people on the other end. So it would seem like they do have that reasonable expectation of privacy. And I just
Well,
wonder if
there's
we
no
would
per
take
se rule against anything. With a warrant, you can get even into somebody's mattress.
Right. But do you need, or PIN registers don't require warrants?
Pen registers don't require, they require something under the, I'm not an expert in this, constitutionally they don't require anything, I don't think, but there is a federal statute that governs them that does have a requirement. And Congress, in fact, has been quite protective, quite responsible, I think, in that area. But technology.
No,
Well,
no.
no. With wiretapping, they have. I'm sorry, this is not. But they've simply been overtaken by technology.
Yeah, but just if I could, the pen register statute requires a rubber stamp court order, where the courts have said it actually is not, the courts are not allowed to engage in independent review, and they must grant as long as the facts establish relevance to the investigation. No, Judge
much.
Smith?
As long as the law enforcement officer certifies it's relevant.
As long-
Then the magistrate judge has to sign off.
There we go. And there's no notice, and there's no suppression
But
remedy.
that's not constitutionally required.
Right, exactly, no, because.
So
right.
Congress gave something more than.
It's, but purely to gather statistics administratively. I mean, it's a joke of a privacy statute.
All right, fair enough.
It's obviously terrible of me, but I just thought there's this case in California called Gonzalez versus Google that I think has a lot of really interesting parallels with this problem, where a subpoena was served on Google to get 10,000 search queries. And of course, that's a canonical example of a third-party disclosure, so you'd figure they wouldn't need any sort of special, it wouldn't even be problematic, but the court engaged in a very interesting balancing test that seems to really mirror Silla's sort of concerns about associational freedoms and expressive freedom. So
That was a district court case,
Yes.
if I remember correctly, and
That's
it went
where-
away.
It went away.
No, the only reason I asked, I can't talk about any pending case, especially a case pending in our circuit, but I am familiar with the case. My understanding is it went away, and, it's very
yeah,
commendable of the judge to
2006,
have done that,
yeah.
I think.
Yeah, but that was a case where they were asking for information because they were investigating the Communications Decency Act, and it was sort of civil discovery. There was nobody who was going to be prosecuted, and they were investigating, and Google was avoiding it because they were worried about disclosing information about their trade secrets. And Judge Ware said that.
Well, so what's interesting is Google used the trade secret defense because they didn't have a constitutional, it didn't seem that they necessarily had a constitutional hook. So
And
they
the,
were
and the
using-
judge had to analyze the case under the subpoena standard, which asked whether it was burdensome. And they said, yeah, it's burdensome because Google's worried that if their users find out that that the government's looking at how many porno searches they did, they may be upset. I mean, I think that's I think it's nice that Google resisted, but it's a little bit disturbing to see the subpoena standard being used to figure out whether all of our data should be exposed to the government.
Hey, let's not be critical. I think,
Yeah,
I thought, again, the case is over, so I hope I'm not coming to a pending case, but when I saw it was very responsible for Google to have resisted
I
for
said that.
whatever reason.
I said that.
And I know Yahoo, some other search providers have not resisted in other cases. I'm not that familiar with all the facts, but it seems to me that if people became more aware of this thing, and if they discriminated on search providers, depending on whether or not they take a public stand in resisting such things, at least go to court and resist a subpoena, it seems to me Google ought to be rewarded for having taken that stand.
I don't
And,
disagree.
people
I
ought
agree.
to switch to a service provider that resists away from ones that don't resist. Just as I think that the phone company, Christopher, what phone company is it that provides the website?
Sprint.
You know, the last time,
Sprint.
last time it was limited to Nextel or somebody.
Sprint was the first, and all the others followed.
Oh, okay. I was going to say, when it was only Sprint, I was sort of happy to have AT&T. But it seems they don't get anything out of it by resisting. And it seems to me consumers ought to be trained to, ought to be taught, ought to be educated to reward service providers that resist.
I think that's absolutely right. And just on the subject, Google has been the leader of pushing back and requiring a warrant for stored content and in putting up this transparency report, which is very helpful. And as Twitter's done that too.
Because at least it brings it before a judge.
Yeah.
I mean,
Yeah.
So I have a story and a question. In 2006, I came home after staying at a friend's house for the night, and my front door had been smashed open. And I thought I'd been the victim of a robbery. And I went into my home, and my house was chaos. I mean, there were papers on the floor. I mean, my house had been ransacked. And it was only when I walked into the kitchen and I saw a search warrant taped to my kitchen table that I realized that the FBI had been to my house and had searched through my possessions and taken some of my stuff. Now, in that case, the FBI got a warrant, and so they satisfied the warrant standard, and they obtained the warrant, and they actually woke a judge up at 2 in the morning to get a nighttime search warrant. But it was only because they taped the warrant to the table that I found out that the government had been rifling through my papers and files, and that I had, in fact, not been the victim of a robbery. In the digital arena, we don't have the automatic notice that one receives when someone searches their home, in that you don't see the evidence of the search. When Google or Yahoo or Sprint hand over my phone records, I don't automatically know. I can't see that they've been touched. And so we rely upon notice in another form to even tell us that this has happened. And unfortunately, through a series of interpretations by lower courts, right now the sort of built-in notice provisions in a Rule 41 search warrant are interpreted that the government has to provide notice to the ISP that hands over data, which of course the ISP already knows because it already handed over the data, and the individual doesn't ever get notice. In the context of ECPA disclosures of non-content data, like location information, you have no mandatory requirement for notice. And so my question to the panel is, yes, it's great that the government gets a warrant in the context of a Fourth Amendment search, but isn't it also important that at some point after the search has happened, that the individual be notified? And what do you think about the fact that either in the case of emails or location data, that we don't have automatic notice to the subscriber, the impacted subscriber at some point down the road?
That strikes me as a perfectly reasonable expectation to have, and balancing the competing interests between law enforcement and citizens in these kinds of technologically enhanced searches.
Reasonable to expect notice.
Reasonable to expect notice, yeah.
Yeah.
But once again, you have to ask the question, you don't get notice that when you swipe your credit card that Chase conveys information to Xperia, which then conveys information to Cox, which then can determine what commercials you get on your television. All that stuff you don't get any notice of that. Why should the government be in a worse position than commercial?
Because the government has the power to retain that power perniciously and has historically used that power, I mean, to target dissidents, to target journalists, to target, and Scylla provided great stories. And the government has a power that is much more dangerous than the power by corporate entities, unless they give that
Well,
information.
there's a reason that the government's subject to the warrant requirement and the private entities aren't, right? Which is what you're talking
It's
about.
called the Fourth Amendment.
It's called the Fourth Amendment.
Well, and it's the- and the First
right, and
Amendment
there's
as
a reason
well.
for that, yes. But I think the question would be,
Why don't you-
I think what you're asking is it constitutionally required in some way for them to give you notice? And so that's a harder question, right? So you would have to say, well, is there some requirement on the Fourth Amendment that you have noticed that a search has been conducted? And if I don't know the case law well enough to know whether they had to tape it to your, do they
they-
have
yeah,
to
no.
tape it to you? They
Yeah,
do,
the
right?
Fourth
So
Amendment, yeah.
if they do in that circumstance, I don't see why you couldn't make the argument that they have to give you notice in the computer context as well. And I guess it's this problem of they're searching the ISP, right? And so we have to make that connection somehow in the litigation in order to enforce that notice requirement through the ISP to you. One of the interesting things, and I'll just say this about the physical trespass ruling in Jones, is that I think there's no reason that the physical trespass doctrine can't be extended to sort of digital invasions of property, right? I mean, if Justice Scalia can make up the tiny constable who hides in your coach, your extra large horse and buggy, in order to create some sense of physical trespass in the founding, I think you could also think of tiny constables going through wires in digital, or even wirelessly, and invading your computer and trespassing in that way. So there may be a way to extend the physical trespass theory of search to wireless or digital searches, although certainly if you look at the court's opinions, they don't see it that way now. But maybe with more education about what actually happens digitally and how your private property gets taken over really physically by code or whatever, however that works, maybe they would change their minds. But the reason I mention that here is because I think by extension, one could try to make that same kind of argument in trying to extend a notice requirement in physical warrant stuff to digital searches as well. And you could try to use that. That's just off the top of my head where I would try to go with it if I was litigating.
Okay. Let me just make this point because I think it's really important. A couple of panelists said, oh, it's because the government has constraints because it has governmental power. Let's be very clear about this. The government only needs a warrant to do things that you as a private person couldn't do at all. You as a private person can't go into somebody's home, no matter how badly you want it, and break in lawfully and do what they did to Christopher. Can't do it. So when they try to do something, exercise a governmental power that they can't otherwise do, they need to comply with the Fourth Amendment. But let's say, for example, they suspect that Ralph's supermarket is being run as a front for an illegal drug operation. And what they want to do is they want to come in and go up and down the aisles and look for suspicious activities. They don't need a warrant for that because that is activity that you as a private person can do on your own. So when they do things like gather information that the credit companies and Expedia and Cox and Google and Amazon and all those people gather for nothing, I don't see why they can't say, look, we are doing important work. We are no less entitled to this information than private parties.
Because Judge Kaczynski, when the Berger case was decided and the Katz decision was decided, wiretapping and bugging by private parties was rampant. And the Supreme Court said that you cannot engage in that without a warrant. Neither a private party, well, they weren't considering private parties, but the cops cannot engage in that without not only the warrant, but a whole lot of other protections, including notice to the target. And then when the Congress legislated in 1968, they made it illegal both for cops to do it without a warrant as well as other protections, and for private parties to do it. So so things may be illegal even though they are possible. And one thing we're trying to figure out right now in the courts in a set of private lawsuits is whether or not some of the things these private entities are doing, whether it's Google or Facebook or what have you, are themselves violations of the Wiretap Act. So it's not enough to say that this information gathering is being done by private entities. It's still possible that it's a wiretap. And Priscilla asks about the case law. The case law establishes that when someone, whether it's the government or a private entity, is engaging in electronic surveillance, and we just have to figure out what that means today, what is the modern equivalent of wiretapping, then that should be subject to the protections of the Fourth Amendment at the highest level, which include notice. And it should happen at the constitutional level, and it should be part of legislation. And I just want to commend the work of both Chris Segoyan and Judge Smith on the importance of those kind of due process protections to having our rights effectuated. And one reason is, without that, we have the Justice Department going in and getting these crazy interpretations of the statute that for some reason dispense with notice, even though Rule 41 clearly requires it.
I want to get one more question from the floor, so Catherine.
Hi, I'm Catherine Crump. I'm a staff attorney with the ACLU. When Jamil started the panel, he listed a number of questions for the panelists to address. And one of them was, what, if anything, is the significance of efficiency to the Fourth Amendment analysis? When I think about what practically is happening here, right, it is that the practical barriers to surveillance have fallen, and it is now simply easier than ever before for law enforcement agents to engage in surveillance. That hasn't necessarily been helpful in the legal analysis, because there's case law that suggests that the mere fact that there's a technological enhancement to surveillance doesn't mean there is a Fourth Amendment problem. But I'm just curious what the panelists think about what room, if any, there is to argue that it is relevant as a Fourth Amendment matter that surveillance today is easier than ever before.
So from Danielle and I's point of view, that's precisely the issue, is that certain technologies provide for efficiencies that go so far as to raise the specter of a surveillance state. And when you're dealing with that kind of a technology, that access to that technology and use of that technology should be constrained by Fourth Amendment reasonableness. And just to go slightly parenthetically to that question, another benefit of this approach is that it shows exactly why Jamil was quite right in Clapper to argue that his client had standing to challenge the 1881A, 1881A, which is to say that if the real Fourth Amendment interest here is an interest of the people not to live in a surveillance state, and the Fourth Amendment stands as a bulwark against that surveillance state, then we each of us have an equal interest in our security as against the rise of a surveillance state. So certainly somebody well situated like the ACLU or individual members of the ACLU could say this is the kind of excessive access to a technology that's capable of facilitating a surveillance state that should be subject to challenge, which is to say they should be able to challenge the legal structure that purports to constrain governmental access to this kind of technology. And it's important from our point of view that the challenge there is to the structure, not to the individual use. Because when we're talking about guarding access to and use of these kinds of technologies, we're quite open to the possibility that there might be a pat policy that could be replicated in a number of different law enforcement agencies in a number of different circumstances that would be per se constitutional. That's sort of what we've done with the warrant requirement. As long as somebody gets a warrant, there is a strong presumption of reasonableness as to any search under that warrant. So too, we think that if we were to get to the substance of 1881A, and the Supreme Court were to say that that sounds like a perfectly reasonable balance between the competing interests of law enforcement interests and citizen privacy interests, then that would be it. But of course, we can't get to the substance because the court is quite wrong-headed about the standing issue.
I just want to say, I think efficiency, remember I have my 4 factors. They're hidden, continuous, indiscriminate, and intrusive. And I pulled these 4 factors out of the analysis the court did in Berger, and then the analysis that the appellate courts did in the video surveillance cases. And I think efficiency comes in terms of indiscriminate, that the easier it is to gather up a lot of information about a lot of people, the more that the judiciary needs to come in and exercise oversight over a law enforcement function. So I think efficiency is important in raising the stakes for a law enforcement technology, for a surveillance technology, and I agree with Justice Sotomayor's discussion of that, and I agree with David's and Danielle's discussion of that too.
Right, and I agree. I think it's, efficiency is great, but efficiency breeds abuse and overuse, and that's exactly what that's the concern the court expresses in Jones, in the concurrences.
It's actually the other way. Efficiency creates abuse. I mean, the more efficient,
Yeah,
sometimes you
yes,
want government
yeah,
to be
yeah.
inefficient.
Yeah.
And as Justice Scalia reminded us at the beginning of Maryland versus King, that's the whole point of the Fourth Amendment. It creates inefficiencies.
So as conference organizer, we're going to push this 5 minutes into coffee break. Apologies to everybody, so that I can ask the question. What are your thoughts about, and what is the significance of Clapper v. Amnesty?
I think we start with Jamil.
Well,
Were you persuaded?
I was persuaded of some things, yeah, not, so I actually think that Clapper, it's about standing, it's a question about who can challenge government surveillance programs that are conducted in secret, and the answer of 5 justices is, they don't put it this way, but is essentially no one. That a statute that allows the government to engage in surveillance in complete secrecy is a statute that is not susceptible to a challenge in a federal court. And so if you think of it that way, some of the same issues that Susan was talking about on the exclusionary rule, sort of on the back end, come up at the front end, right? It's just this question of how is it that the courts are going to engage the question of whether these surveillance activities are constitutional or not, if you have all of these barriers, both at the front end and the back end, to the courts actually reaching the merits. And to some people, I guess it's not, it doesn't seem like that big a deal that the courts aren't going to reach the merits of these constitutional questions, because I think to at least some justices on the Supreme Court, national security really does and should, in their view, exist beyond the reach of the kinds of constitutional claims we're making here. And by beyond the reach, I don't just mean that they will decide against us on the merits. I mean that they will not actually adjudicate the constitutional claims. They think there's something inappropriate about the courts adjudicating constitutional challenges to national security policy. So I think that Clapper is unfortunately very significant in the national security context. Whether it's going to have any implications outside the national security context, I don't know, and maybe the panelists have theories about that.
Let me just say, I think it's a disturbing decision. I worked actually with the EFF on the brief in the Hepting case where we amicus brief, we argued that the judiciary has to get involved in figuring out whether these electronic surveillance programs are constitutional because, and I hate to be U.S.-centered about it, but it's necessarily true that U.S. persons are being swept up in this surveillance, and there has to be a way for that to be reviewed. And I just want to make a pitch for a paper I'm working on, and it still needs editing, but it's on SSR.
I'll read anything you write.
Oh, that's lovely. It's called Reforming Surveillance Law, and it's about a comparison of the U.S. to the Swiss system. And one of the things that we found, I worked with a Swiss lawyer, is that on the Swiss system, they don't allow their police to engage in a surveillance practice until the legislature has regulated it. And so when new techniques come into being, whether it's locations tracking or license plate recognition, the officers can't use it until the legislature enacts a law that regulates it. And we have the opposite system. Our system is officers can do anything until they're stopped. And what this means, the more that the Fourth Amendment is not brought to bear on practices, as we're seeing now with Davis and as Clapper indicates, the less that law enforcement is regulated. And I think that those two things together are very troubling, particularly because Congress, for some reason, finds it difficult to legislate on these issues. So I put those things together to just say that there's something wrong with our system, and I'm troubled.
So I'm going to be giving a talk at Georgetown later in the month, marrying a paper that I did on Davis and some of this work that Danielle and I have been doing on quantitative privacy. And the point that I'll make there and just make briefly here is that the Fourth Amendment doesn't prohibit searches, right? It doesn't prohibit searches at all. What it prohibits is unreasonable searches. And the court has told us quite wisely that reasonableness here, it requires a balancing of the competing interests of law enforcement and citizens, which is to say that the substantive right under the Fourth Amendment is inherently linked to the remedy. And the remedy comes both at the front end, in the controls on use and access to search, and on the back end for punishment of violations of that prohibition on unreasonable search. And the court has done tremendous damage on both the front end and the back end by repeatedly, again, on both the front end in Clapper and the back end in Davis, telling us that Fourth Amendment rights are to be considered separately from the remedies. The remedies have nothing to do with the rights. And it's quite the other way around. In the Fourth Amendment, the remedy is the right. And both in Clapper and in Davis, the court has gutted the Fourth Amendment because it has failed to take account of that fundamental difference between Fourth Amendment rights and other constitutional rights.
Any final comments from the panelists?
I haven't read Clapper, and I probably have to construe it, so I'm going to say nothing about it, but I've
Start with
listened-
the dissent.
You clearly don't have an academic spirit. The less you know, the more you should say.
Yeah, but things you say today will get you accused tomorrow. So I can only say that I've listened carefully to what the other panelists have said on Clapper, and I will give it due consideration if and when I'm called upon to construe it.
All right, let me just thank then all of the panelists for their insightful remarks about this topic.
Thanks, Jamil.
Hi, I'm Bart Gelman, and I won't spend a long time introducing our panelists. You've got biographies. Before we start, everyone please take the battery out of your cell phone. If you have an Apple device, you could just smash it with a hammer. You could do this at home also. If you're tweeting, we have a hashtag, #TrackingCon. The last panel focused primarily on Fourth Amendment, and we will touch on that here for sure as well. But we're going to begin with an explanation from Kevin Bankston of a quite complex set of statutory instruments involved in location tracking. And I'm going to take it to you, Kevin.
Okay. So hi, I'm Kevin, and I've been given the task of laying out the sort of basic history and legal framework of the issue of government requests to cell carriers. I'm a lawyer. I'm the Free Expression Director at the Center for Democracy and Technology in DC. But I used to work the surveillance beat at the Electronic Frontier Foundation until last year, and it's because of that work that Margot and Yale ISP invited me to be here, Margot actually being an EFF alum, and thank you for letting me be here, and walk down memory lane on this issue that I spent a number of years on. Walking down memory lane, I in particular am given the opportunity to revisit what is probably my favorite week as a lawyer, or my best week as a lawyer, in December 2010, because not only was it a great week for me, it provides an interesting lens where we can approach the challenges, the unique challenges of trying to strengthen and clarify the standards when it comes to government access to phone records, cell phone location records, and government tracking of your cell phone in real time. So let's go back in time to December 14th, 2010, a Tuesday, a really great Tuesday because we got a landmark ruling not on cell phone tracking, but on email privacy. The Sixth Circuit ruled in line with arguments made in an EFF amicus brief joined by ACLU and CDT, held that we have a reasonable expectation of privacy in the email we store in the cloud, and found that the Stored Communications Act portion of the Electronic Communications Privacy Act, which in certain circumstances allowed warrantless access to email, was unconstitutional. So it was a really great Tuesday, and Tuesdays usually stink at EFF because that's when we have a bunch of like weekly meetings, and it's really kind of a drag. But you know, the good times didn't stop because the very next day, bam, Wednesday, another win. This one was related to cell tracking. In the very first appellate case to consider what privacy protections apply to your cell phone location records held by your carrier, in a case that Susan Freewald and I both argued during a particularly stressful and snowbound week in Philadelphia in February 2010, notably against our very close frenemy Mark Eckenweiler, formerly of DOJ, who we were hoping was going to be here today but couldn't make it. We, again with our co-amici ACLU and CDT, won a great victory. In that case, awkwardly titled, "In the matter of the application of the USA for an order directing a provider of electronic communication service to disclose records to the government," say that 3 times fast, the Third Circuit en banc refused to review the panel court decision, which had upheld a decision by a federal magistrate in Pittsburgh, Judge Lenahan. Judge Lenahan had taken the very rare step of rejecting, in a public opinion, a government secret application to obtain cell site location information, or CSLI as the wonks sometimes call it, CSLI records in a drug investigation without a probable cause warrant. And so, in other words, we learned that day that our victory in front of the Third Circuit would stand. And so, another great day. But then, the next day, bam, it was just another Thursday, but it's okay because otherwise it was a really good week. So why am I telling you this other than self-congratulation? There is a reason, in fact, there are 2. One is a message to the law students in the audience. It is an advertisement for working at places like EFF and CDT and ACLU on these kinds of issues. Because, you know, when you're in nonprofit, you're going to lose a lot. In fact, that's kind of the job description, because if you're not losing, you're not picking your fights right. You're not picking the important cases. But sometimes you're going to win. Sometimes you're going to win big, and it's going to feel really great. It's going to really kick ass. And so, pardon my French, but it's kick-ass when you win like that, and it was a great week. So the other reason I'm telling you about this is because when you compare and contrast these two cases, these two victories, they're instructive. They sort of help give us a lens to understand the challenge that we face on location tracking. So first, the similarities. In both cases, the government sought data, and in Warshak they got it, with something we ECPA geeks call a D order, after 18 USC 2703D. It's a court order for getting stored content or records, and it's kind of like a warrant, but unlike a warrant, it doesn't require a showing of probable cause, and instead it requires a showing only that the information sought is relevant and material to an investigation, a lower standard. Also in both cases, the government argued that it didn't need a warrant, based on two key Supreme Court cases from the 70s that each held that the respective information in those cases wasn't protected by the Fourth Amendment because we had knowingly exposed it to a third party and therefore had assumed the risk those parties would hand it over. Those cases are U.S. v. Miller, which found no reasonable expectation of privacy in bank records, and Smith v. Maryland, which found no reasonable expectation of privacy against pen register surveillance of the phone numbers you've dialed. The pen registers came up in the previous session as well. So the differences, well, in Warshak, we had great analogies. First off, we had the analogy to the private content of our phone calls, which is really strongly protected under a couple of landmark electronic eavesdropping rulings from the 60s, US v. Katz and Berger v. New York. There was also analogy to the privacy of our physical postal mail, analogy to the privacy of the files we keep in our home, or at least did until we had the cloud. We also had a statute that was clear. There is no question that the Stored Communications Act allows the government to get a whole lot of email without a warrant, based on some pretty senseless distinctions that are themselves based on the way technology worked in 1986 when the statute was written. Most notably and arbitrarily, the statute requires warrants for email less than 180 days old, but not for email over 180 days old. If you'd like to have a drink after the conference and talk about why that is, I'd be happy to chat with you about it. But in the meantime, you combine that clarity, the clear analogies to previous constitutional precedent and the clear statute, and you got something that was further clear, that that statute was unconstitutional, and the court agreed with us. And the DOJ, perhaps scared that they might make their situation worse, didn't even bother to seek en banc review of this opinion, much less go for cert. And since then, this ruling has paid off big time. First off, everyone's requiring warrants now. Google, Microsoft, Yahoo, Facebook, even Twitter, I shouldn't say even, they're great on these issues. They all require the government to come back with a warrant when the government wants to compel the disclosure of stored content. Again, and notably, the DOJ hasn't picked this fight in litigation or appealed any case like this. They appear to be choosing not to risk another loss. And in the meantime, we're getting a de facto rule of warrants for content across the country. Meanwhile, Warshak also provided a great boost for the Digital Due Process Coalition effort. This is a ECPA reform coalition led by CDT, bringing together pretty much all the orgs and at this point all the big internet companies to modernize ECPA, both on the content issue and the location issue. And so Warshak has been a really great boon to the push to codify a strong warrant requirement for content, something that we think might actually, knock on wood, pass this year. The Third Circuit case on cell tracking, on the other hand, didn't give us this kind of clarity, hasn't yielded these kinds of dividends. Instead, we're sort of at a standstill. And there are a few reasons for this. First off, the analogies are much less helpful. It's a lot easier to analogize cell tower records to unprotected dialing information or to bank records than it is to the private contents of your communications. Although we did succeed in convincing the court that that was not an apt analogy because we don't actually knowingly expose or directly communicate our location to our phone company. So there's, the Third Circuit found after we argued, there's no knowing exposure leading to an assumption of the risk in Fourth Amendment terms. Second, the decision itself is a lot more cabined and conditional and contingent than the Warshak decision. It didn't hold that the statute or the Fourth Amendment requires a warrant for cell site location information. Instead, it held that the statute, which is admittedly ambiguous about how it treats location, gave magistrates the discretion to require a warrant in order to avoid the hard Fourth Amendment question, and then hinted that the records might be protected by the Fourth Amendment if they're precise enough to place you inside of a home, basing this on a couple of key location tracking cases from the 80s, Caro and Knotts. Third, the decision hasn't really given a whole lot of new juice to the DDP push to reform location tracking in ECPA. The content fight is going well, but things have been pretty quiet on the location privacy front, even with the help of US v. Jones. In part, this is because there's still some disagreement about whether warrants are actually the appropriate standard for stored records. Some, including Stephanie and Chris Segoyan, have argued, at least as a matter of political expediency, that we shouldn't be pushing a warrant requirement for stored records, but instead should improve the D-order standard. In part, it's because of vigorous opposition from the DOJ, who on this are unburdened by obvious absurdities like a 180-day rule. And in part, it's just because it's a really hard drafting problem. With the content stuff, you can basically just tweak ECPA. With the location stuff, you kind of have to write a whole new statute. So, fourth and finally, when you're contrasting these cases, unlike with the content stuff, there's no indication that DOJ or the magistrates or the phone companies have really changed what they're doing. It seems like the government is still using D-orders for stored records. The companies are still responding to them, and the magistrates are still issuing them, with the notable exception of the gentleman to my right, Judge Smith, who in October 2010 denied a couple of D-order applications for 60 days worth of tower location information, based on the DC Circuit decision that was ultimately upheld in Jones, based on the Third Circuit opinion, and based on some really killer findings of fact that were in turn based in no small part on a really great bit of testimony by security expert Matt Blaze. You should Google for it. It's a really great piece of work. As was, thank you, Chris, for your introduction on the basic tech and accuracy issues. Also, unlike the email context, the DOJ is not afraid to appeal its losses. We are awaiting a decision right now from the Fifth Circuit Court of Appeals where Judge Smith's opinions are being reviewed. They were argued in October in New Orleans, once again by EFF, this time my former colleague Hani Fakouri and Susan, again, making an appearance, and arguing that the statute allowed and the Fourth Amendment required Judge Smith to reject those applications. So, I have 5 more minutes, and in that time I'm going to talk about the issue we haven't gotten to yet, which is real-time tracking as opposed to access to records. And this is going to require a little bit more history, going back a little further in time to 2005. And this story also involves Judge Smith, who, as one will see, has been a troublemaker on these issues in the best way for quite a while. Back then, many of us assumed, and we all know how that goes, we assumed that due to the extent the government was tracking cell phones, it wasn't really clear that it was a routine investigative technique at that point. We assumed they were getting warrants. We assumed this because no other court order under ECPA seems to fit the bill. So you have wiretap orders, which are real time, but they're only for content, not for location information that isn't actually the content of a communication between you and someone else. And there are pen register orders discussed in the previous panel, issued under a really low standard. So low, in fact, that Congress, in a law called CALEA in the 90s, explicitly said, you cannot rely solely on the pen register statute if you want to track location, because it's too invasive and the pen register order is too easy to get. And then finally, there's the D order that I mentioned earlier, but that's clearly inapplicable because that's in the Stored Communications Act, and that's about getting access to stored records. But in late 2005, 2 magistrate judges took the unprecedented step of publishing decisions denying secret government applications to track in real time cell phones without a warrant. And in doing so, to our shock and dismay, they revealed that the government had been routinely and for years obtaining this authority without warrants, and instead using D orders, which is just crazy because those are for stored records. But anyway, those 2 judges were Judge Smith and another judge in New York who was briefed by EFF, Judge Orenstein. So DOJ, once it was caught out using this authority that's plainly limited to retrospective historical surveillance to do this prospective real-time surveillance, they shifted their strategy and recharacterized what they'd been doing before and began instead applying, not for D orders alone, but what we are now calling hybrid orders. And this is a never-before-seen kludge that combines a prospective pen register order with a slightly higher showing required by a D order. Susan has aptly described this as taking one zero that doesn't authorize cell tracking and another zero that also doesn't authorize cell tracking, and then combining them to somehow add up to one that does authorize cell tracking. Someone can correct me here, I've been off the beat for a little bit, but there have been somewhere between 2 and 3 dozen cases at this point, lower court cases, considering the hybrid theory, and many have accepted it, though most have rejected it, sometimes after a briefing from EFF, ACLU, and or CDT, and sometimes in the strongest terms. Here are just a few of the choice adjectives, some of them coming from Judge Smith. Contrived, unsupported, misleading, a chimera, a Hail Mary play, perverse. And my favorite, and I'm not sure if this was Judge Smith or not, a statutory Frankenstein that the government has stitched together from ill-fitting parts.
That was not mine.
That was not yours. So, but as far as we know at this point, and like with the stored cell site stuff, very little's changed. DOJ still routinely uses these non-probable cause hybrid orders to track cell phones. Magistrates still routinely issue them, and we think that the phone companies routinely accept them. Meanwhile, and more like in the email context, the DOJ has refused to appeal any of these cases questioning their hybrid theory, perhaps in recognition of just how weak it is. So we, both the public and the magistrates, are kind of wandering around in the dark on this one, which is basically the theme of an article I wrote for a symposium of Susan's years ago that recounts the history of this real-time tracking issue and the secrecy that surrounds it and pretty much all other law enforcement legal theories and practices when it comes to electronic surveillance. I'm a little bit embarrassed by it as my first journal effort, but Segoyan tells me it's worth reading, and I try to avoid arguing with Chris unless I absolutely have to. So in the meantime, and on that note, now that I've explained just what an unholy and depressing mess the state of the law is on these issues, I'll turn it over to my fellow panelists, and we can maybe try and make some sense of it and chart a way forward.
Thank you, and thanks for keeping your promise exactly on time. Stephanie, and we're going to change this from sort of long presentations to a more sort of conversational format based on some planted questions by the panelists ahead of time and also some of my follow-ups. One of the things that you've expressed interest in is essentially the obfuscation of what the government is doing when it applies for this kind of location data, when it asks for it, that the implicit requirement is for a magistrate like Judge Smith to have considerable technical knowledge or to go out affirmatively and seek it. Explain what's happening there and why that matters.
Sure, and let me just start by saying, as Kevin gave a little bit of his background and how he came to this issue, I was a federal prosecutor for a number of years, and then had the good fortune to be detailed to the House Judiciary Committee when the digital due process effort started, and the committee started to consider how to reform ECPA. And I will agree with Kevin that the content fix has presented a much clearer path than the location fix. And I became, frankly, more educated from folks like Matt Blaze, who started talking about what this technology does and what it can have the potential to do in the future. And I thank Chris because what he explained this morning vis-a-vis single cell tower data and even historical location information about single cell tower data that is the product of a microcell, a picocell, and a femtocell, that technology can produce extremely precise data. That fact has played, or how you may say, not played into what I would characterize as how DOJ has chosen to litigate these cases and even represent to congressional staff about the lay of the land vis-a-vis what the standard should be for location data. So let me now directly answer your question with that intro. DOJ has taken the position, both from a perspective standpoint and with regards to historical location information, that the data is very imprecise. And because it is imprecise, they do not need a warrant. Now, they have conceded that when they are getting GPS data and prospectively tracking, they do get a warrant. The problem is, as Matt Blaze testified to the committee about, and as Chris aptly summarized this morning, that is not the case for the state of the technology. So that, and I know, Judge Smith, I'm not going to force you to talk about the Fifth Circuit case, but in that case, which was an appeal of 3 orders that Judge Smith had issued vis-a-vis government requests for historical location data when they just wanted to use a D order. Judge Smith denied those requests. He was going to require a warrant, and one of the reasons that he relates in his opinion is because of the state of the technology. DOJ, if you read their brief on appeal to the Fifth Circuit, basically represents that in these particular orders, the historical location data is very imprecise. And they suggest that they put forth an affidavit from Metro PCS, and they suggest that if a magistrate judge like Judge Smith were to hold a hearing on the other 2 orders, that the T-Mobile network information would be equally imprecise. Well, that may be the case in these 3 particular situations. But the way that DOJ is sort of pushing their litigation and ultimately pushing the law sort of suggests that we are putting magistrates, judges like Judge Smith, in the position of literally having to look at maps of cell towers every time they have to determine whether DOJ can get information with a D order, with a hybrid order, or with a higher warrant standard. I respectfully submit to you that while our judges are quite able, requiring them to look at maps of cell towers where a new femtocell may pop up, as Chris explained, anytime someone receives it in the mail, is just no way to run a railroad. And it is creating a body of law that is just a legal landscape that's nothing more than a mess.
Well, is it a body of law or is it a body of practice, given that there's so little published on this?
Well, you're getting various decisions. DOJ relies on one. Most of them right now are magistrate judge decisions, but DOJ, for example, relies on a 2005 decision from Judge Gorenstein, to be not Orenstein, but Gorenstein with a G, from 2005, where he is literally examining the map of cell towers in, at that time, the particular area of Manhattan, and determining that single cell tower data is not very precise. So Judge Smith, in some congressional testimony that he gave, documented, I've lost count as to the number of cases, but at least a magistrate and district judge body of law where these decisions are coming out in different ways and really creating no clear rules for any of the stakeholders at issue here, be them law enforcement, be them judges, be them litigants, be them industry, who I know Ed will talk about further, but they too, if you want them to push back, they need clear laws to understand.
But are you saying, and could you document that the Justice Department in your old shop is misrepresenting the facts, is making knowingly false statements about the technology, that a magistrate judge would or could find that if that person had sort of the unreasonable burden on him or her to look into it?
Well, insofar as, for example, in the Fifth Circuit case, DOJ is addressing the technology at issue in those very applications, it would be hard to say that that was a lie, if that's what you are really asking.
But in what they're telling other magistrate judges.
But insofar as they may be, for example, representing to congressional staff or relying on opinions that suggest that networks have a certain level of capacity that is always imprecise, yes, I think that is a bit disingenuous.
I've seen them cite FCC studies from 10 years ago about the accuracy of cell tracking.
Interesting. I'm going to go now to Judge Smith, and don't worry, Ed, I'm coming back to you. And by the way, his colorful writing is not limited to opinions. He's got 2 published articles with titles that Gagged, Sealed, and Delivered. The other one is Standing Up for Mr. Nesbitt, which, if we have any Monty Python fans here, will recognize as the guy who tries to hide behind the bush. In any event, I wanted to ask you why it is that there are so few reported decisions on this, and whether it's possible for anyone outside the Justice Department or anyone at all, given that there are other authorities seeking the location data, to know how often it happens and under what pretexts.
Yeah. First of all, I want to make clear that anything I say, I'm not commenting on the case before the Fifth Circuit or any pending cases, and that's not my concern here, and nor am I advocating for a particular standard one way or the other. My decisions, I mean, I published them for the reason that I wanted there to be discussion and for the appellate courts to tell me, how I got it wrong. So I'm not going to deal with those issues here. But a couple of concerns. I mean, Stephanie referred to this body of law that's now out there with regard to tracking, and it is not really a body of law. There are a bunch of magistrate judges and a few district judges who have opined on what the standards ought to be. But right now, there's no appellate guidance as to what the standards really are. So really, we have a situation where each magistrate judge is basically a law unto himself. If they choose to agree with me, they can. If they choose to agree with Judge Gorenstein, they can and grant the orders. And you don't really know based on, I mean, as was mentioned, there are probably a couple of dozen decisions published, and all in FedSup second, some just on Westlaw that address the topic, but there's no way of knowing what the real majority view is. I would say that with regard to prospective tracking, the majority of published decisions require a warrant, but I cannot say that all magistrate judges, or the majority of them, require a warrant. I mean, frankly, magistrate judges, to speak up for my colleagues, I mean, we're fairly busy people, and we don't have the luxury very often of sitting down and writing an opinion every time one of these things crosses our desk, one of these applications crosses our desk. I mean, when I'm on criminal duty, I get 2 or 3 of these every day.
They could be rejecting them without published opinions.
Absolutely.
But you don't think they are in very large numbers.
I don't think so. But again, nobody really knows because nobody's really done a survey. Now, as to your question is why there's so few appeals, appellate courts cannot decide cases that are not appealed. If there's no appeal filed, there won't be a decision. That's just basic. And ECPA orders are rarely, if ever, challenged. The only party really in position to appeal is the government, because they're the one in possession of the facts and they know what the magistrate judge has done. And so it kind of resolves to an old saw that only the party that could appeal won't, and only the party that would appeal can't. And the reasons for that are that what I call ECPA's regime of secrecy. I think there are basically 3 components to that. One, the first is the gag order, because when we issue these orders, we always require non-disclosure by the provider to the provider's customer. And there are good reasons for that, at least on a temporary basis. I mean, there's no point in getting location data, especially if you're tracking somebody on an ongoing investigation, are going to tip them off. Well, that's going to blow the investigation. So the good reasons, at least for temporarily keeping the providers from telling the customers that they're getting access. Now, the problem is, well, when are they going to learn about it? Well, if the case ultimately ripens to a criminal prosecution and the defendant is charged, then you would think that they would get that information, that these orders would be provided to them. But even then, there's not much the defendant can do because there's no suppression remedy under ECPA. I mean, if the violation, assuming there's a violation, rises to the level of a constitutional violation, then I guess they can file a motion to suppress. But again, that's all after the fact. Now, so that's only to people who have been charged with a crime. They might find out about these orders, that the government has looked at your email, your cell phone accounts. If you are a law-abiding citizen and you are not charged with a crime, you will not know. You will never find out. Not only because of these gag orders preventing the provider from telling you, but because these orders are concealed from the public, because they are sealed. And again, for good reason. You don't want to blow a criminal investigation. The problem is that they are, as they come to a magistrate judge, we seal them for an indefinite period of time. Typically, the language is until further order of the court. Well, as a practical matter, a magistrate judge who issues one of these orders never sees that order or that case again. We just don't. I mean, because no defendant has been charged yet. There's no real case going on. And so, things just move on down the line. So I have no...
Can I interrupt for a second? From what you just said a moment ago, are you really willing to stipulate that, and I'm not a lawyer, so I'm about to start messing up all my legal language, but are you willing to accept that in all cases, or in general, there are good reasons that the subject of the data request should not know it? I mean, as Chris Segoyan pointed out...
generally good reasons for them not to know it before the request is executed. I think they ought to have a right to be advised and given notice sometime after it's executed. In fact, even in the wiretap statute, even someone who's a target of a wiretap is entitled to know about the wiretap within 90 days after the wiretap is completed. Now, as a practical matter, the government can get extensions of that 90-day period. So I don't know in practice, how often they do.
But I mean,
typically, you would think somebody that's a target of a wiretap ultimately is going to be charged, and so they're probably going to learn about it.
But for historical location data, in a case where someone already knows he or she's under investigation, why is that any different from the search warrant that was taped to Chris Segoyan's kitchen table?
Well, good question. I mean, often the rationale that's presented to me is that, well, where there are other targets of the investigation, we don't want to tip them off. We don't want to make this publicly available because we got an ongoing investigation. And so, as a practical matter, what I try to do, I have resisted issuing indefinite sealing orders for these things. I put a 180-day time limit on it, and then ask the government to tell me if they still need it sealed beyond that point, if there's still an ongoing investigation, or somebody may be at risk of physical harm, or a witness might flee or something of that sort. If they can show something to me, then I will extend it. But ordinarily, that's my practice. That is not the general practice. In fact, I did a little research, and we've got in our court pen registers issued back in 1995 that are still sealed. And I'm quite confident that those criminal investigations are long since completed.
I think I need to get into this conversation. And one reason I'm really glad you're here is that there's sort of no point in having panels all day where no one disagrees with anything. And I'm not assigning you a role to disagree, but I'm going to rule out of order for all of us any comments that sort of fail to note areas of disagreement. I mean, let's air them here. One thing I'm curious about, and it's based on a little experiment I did about a year ago. As a reporter, I asked each of the major telecommunications companies and ISPs, going through public affairs, a number of questions, including what their standards were, and whether they, since they're not always bound by the Sixth Circuit or the Third Circuit opinions we've been talking about, whether they choose that interpretation or the DOJ interpretation when they respond to requests. And a good number of them simply didn't answer at all, and the ones who did answer said blah, 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 we're not answering.
Probably wise not to answer.
So why shouldn't your clients, I'll put it that way, feel obliged to tell us what their legal standards are when disclosing our data?
Okay. I'll answer that in traditional DC fashion by first not answering it. I'm at Sidley Austin, and so if it were, I'm one of the global coordinators of privacy, data security, information law practice. And really, it is a global practice because most of these issues are, in practice, global. When companies are deploying things, it's not just about US law, it's about EU law and other norms. I also should mention that I'm speaking for myself, not for any clients or any carriers. I have advised carriers in the past, but if we're going with Star Wars theme, I don't want the Darth Vader music to
we'll make everyone sign a waiver on the way out.
Okay, okay. I think that there is a real desire on the part of at least telecommunication carriers generally to have clarity on these issues. I think they're aligned with the Digital Due Process Coalition. Several of them are members of that. And there is a tremendous amount of kind of retail privacy that goes on. One of the things about being in private practice is you deal with actual operations, and you see that most of these processes, when they come in from the courts, go to a series of clerks. And the clerks are processing them, and sometimes it's self-service. And they want a clear rule. The carriers want a clear rule, and they want to comply with that rule. And so I've seen actually some clients say, listen, it's just too uncertain, just ask for a warrant on location data. Just because there's too much uncertainty, and if they can't get a warrant, maybe they'll just drop it or push back. Or maybe they'll come back with a warrant, in which case it's fine. I've seen one of the this little cheat sheets, one of the ones I love best. What was the standard for location data? The means through which government authorities can obtain location data is complicated, must be evaluated on a case-by-case basis, looking to constitutional privacy rights and some statutes.
Right.
I'd love to get a copy of that.
You've got a chart right here. It looks really handy.
And it is really handy. And I thought, wow, what if you're the clerk sitting there trying to answer that? That's not a very helpful. That's like go talk to the lawyers about it. And I think that's how it comes to. So maybe when they're not answering the question, they're being honest. But if I could get the mouse for 1 second, I did want to put some other players on the market here, because if you're in private practice, can you escape?
I don't think,
Maybe, yes?
Yeah, there it is.
Okay. Can I do the mouse from down here? All right. Because I want to put this, of course we allow, why not? So we've been focused, I want to talk about location privacy and put everyone else out, because if you didn't take his guidance and destroy your iPhone, you'll see that there's two little things. It says I've got 3 bars, and then there's another thing, the Wi-Fi signal, right? And the Wi-Fi location is even much tighter. It's not, some femtocells might be a little bit closer, but the Wi-Fi signal is as important, and internet companies gathering location information can be as significant a source of information about location. And that's the thing, is that we're focusing on telecom because there's law there, there's ECPA. But for much of the people who have location data are not covered by ECPA. People concerned about credit cards, but there's RIFPA there. But we don't have that here. So this is this Lumascape, and this is something that's used in the online advertising industry. This is for mobile. Everyone involved in taking mobile marketing and giving it to a consumer. And you see that the carriers are up there, but they're a tiny little portion of this. And then there are all these companies down here, location-based service apps, location technology companies, there are all these companies that are out there, and it would be a whole seminar to explain how they all interact, and it is quite complex. My point being that there are many other sources of location information that would be available to law enforcement, and those sources of location data aren't under the regulatory scheme that the telecom carriers or the credit card companies or the banks are. And so, although you might be interested in how the carriers are responding to it, to my mind, the worrying thing is how the other companies are responding to it, because those location-based companies then take that information, and one of the main consumers of that information is DHS. It feeds back into the government, and that data does not have any process to it. And they say, well, why can't we have the same information that some guy trying to sell you a cereal ad has?
So that's really interesting, and I want that seminar on the slide. But I want to press you on on part of the original question. There are constitutional, there are statutory, there are regulatory mechanisms that could address these issues, but there are also market mechanisms that could, in theory. But we don't have the transparency that would allow that to happen. So Judge Kaczynski can decide how much he's willing to pay for privacy, and each of us can do that. But we have no way of shopping for privacy because the companies involved won't tell us what their practices are, with some exceptions like Google and Twitter. Sort of as good market capitalists, wouldn't it be the right thing for the companies to make more information available about, okay, they want clear standards, but what are their practices now?
There are efforts, it depends on how they want to market themselves. Among the even telecom carriers, which are over there, I know everything's hard to see on that, even among the telcos, there are much more privacy protective. As I said, one of them just says, get a warrant. It's unclear, just get a warrant.
And can you say which one?
No.
They should say that. People would love to hear that.
That's the point.
And there's that. There is right now a big experiment on this right now. Microsoft is trying to advertise its privacy protective status. I mean, I don't know if you've seen the Don't Get Scroogled campaigns. They are trying to argue that their search results are cleaner, their data handling is better than Google's. And they're trying to sell Microsoft Bing as against Google, which we'll see how much traction that gets. But there are efforts, companies are trying to do it. The question is are consumers, and this goes to the point Judge Kaczynski made, are consumers going to buy it? What is the price? What is the price for privacy? Is it you want to get free ads for Starbucks as you're walking by? Well, then I need to know you're walking by a Starbucks.
Right. Well, but I'll open this up to everybody. But it's true that sometimes, there's I guess it was Bruce Schneier's famous comment that if you're not paying for the service, something like Facebook, you're not the customer, you're the product. And that goes to the subsidy idea, but I'm paying plenty for this, probably $2,000 over the life of the contract, but Verizon Wireless, in my case, figured they're leaving money on the table if they don't also sort of sell me. And one of the issues here for the companies is, the government can ask for all kinds of historical location data, but if the companies didn't keep it, it wouldn't be there. And the companies keep it for their own commercial reasons primarily. So, do you see a conflict of interest between the companies and their customers on something like that?
I think this is when the carriers signed on to the Digital Due Process Coalition. I think that was a good faith, well-intentioned effort to try to get some clarity. And as much as we are worried about the courts and fighting over it, I think the fight would be much easier if Congress got onto the field here, and we had a senator somewhere who would put a location privacy bill forward, and clarify that. And I think the carriers would go with that.
Go ahead. You almost can't hold yourself back.
That would be a great segue to discuss what's happening on the Hill. But before we do that, I just want to talk a little bit more about the transparency issue, because we do have this great effort from a number of companies to try and be more transparent. We're seeing numbers from Google and Twitter. We're seeing from Twitter them starting to be more clear about what their standards are for all their data. Google has said what their positions are on some data, as have some other companies that I mentioned. And it's worth noting that by disclosing what standards you are holding your company to, you can help establish the norm. You can actually help create the rule when there is not a clear rule that's been established, or at least been established for the entire country. And you can help create the norm when you're public about that. And then there's simply the issue of numbers. Right now we're starting to see more internet companies give numbers voluntarily. When it comes to the carriers, we only got them when Misters Markey and Barton pressed for them, and then we got them back very inconsistent with very large numbers, but also not knowing exactly how they counted certain things, so that it's hard to compare one company to another. Finally, there's a third aspect of the transparency that's wholly lacking. And that is clarity on what exactly the records are that are currently being compiled and held. We will very occasionally, and Susan knows this as well as anyone, we'll get a couple of photocopies of a Sprint record from 2008. And that's shown to us as some evidence of what the state of cell tracking is. But we don't honestly know. We don't have the bare facts of what exactly a Verizon or an AT&T or any other carrier, or frankly, anyone else in this ecosystem is storing on us. And that is a real problem. But yeah, so there are some senators who've done that. It's pretty great. Also, Senator Leahy introduced a bill a couple of years ago at this point that both warrant for content and warrant for tracking of a cell phone, but did not for prospective tracking, yes. For tracking of a cell phone, prospective tracking of a cell phone, but did not introduce a warrant requirement for stored records. A couple of folks saw that bet and raised it. Senator Wyden and Representative Chaffetz, bipartisan team up, introduced a bill called the GPS Act that is now also co-sponsored, or hopefully when it is reintroduced will be co-sponsored, by Senator Kirk, that would require a warrant for real-time tracking or access to stored records. As I said before, the heat right now is on content. There was a content fix that passed out of the Judiciary Committee, Senate side, last year. We are hoping that will happen again, and we're hoping it'll get even farther this year. Whether and how location is going to mix with that, we don't yet know. As I noted, there are a number of difficulties with the location stuff that we don't have with the content fix. But this is not an issue that is going away, and there is broad support from not only the privacy groups, but also the carriers themselves to get some clarity here.
Right. Yeah, one of my concerns about the legislative process, which great. I hope the legislature takes care of it so we don't have to wrestle with it anymore. But I'm concerned that they're legislating on the basis of not very good, if any, empirical data. Because frankly, what we do as magistrate judges in issuing these orders, especially under 2703D, there's no tracking mechanism. If you go to our electronic case filing system, even if you have a case number, all you will see is sealed event. There's no description publicly available as to what type of order was issued, what type of crime they're investigating, what agency requested it, just basic forms of information. And they're not required presently by statute to, Congress doesn't require the courts to report that information. Now, they do require the courts to report data on wiretaps, and I think that DOJ is supposed to report on pen registers, but on the Stored Communications Act, there's no requirement that there be any reporting. So I'm concerned, because I didn't know. I wrote an article last year, partly as part of a project to find out how many of these orders we're issuing as magistrate judges. And I came to the conclusion, and there wasn't any real, I wasn't equipped to do the actual research myself. I piggybacked off a study of secret cases or sealed cases done by the FJC, the Federal Judicial Center, in 2006. And with a little manipulation and extrapolation, I came to the number of probably 30,000 secret electronic surveillance orders issued by magistrate judges every year. Now, if you compare that to what the FISA court does, FISA in its entire history since 1979, has issued about 28,000 orders. So as magistrate judges, we preside over the most secret court docket in America, 30 times more secret than FISA. And until we get some way of getting some oxygen in the system, getting some transparency into what we do, I'm concerned that Congress is legislating from a black box. They're legislating based on, hearings and, I was invited to testify and I really appreciated them. I was honored to give my perspective, but I'm concerned that they're legislating without really knowing exactly what we're doing, because we don't know what we're doing because nobody's tracking it.
Yeah, I mean, and I'll just add one thing. I mean, we agreed not to talk much, if at all, about the national security side of this on this panel, but except to note, and you can jump in here if you want, and Kevin and Ed were on opposite sides of the AT&T NSA case, which Ed, I noticed in his official biography, describes as as purported class actions related to alleged national security programs.
Your defense counsel, come on.
But I mean, you can also count national security letters on metadata, which, as opposed to your magistrate estimate, you've got, in the six figures, sort of in the hundreds of thousands of those, and we know even less about the sort of FISA and what the Clapper case mentioned briefly as FISA exempt forms of surveillance about which we know.
Well, then
we don't even know what they're talking about.
Yeah, excuse me. The New York Times last year reported that they surveyed, or based on the information they got from 8 different telecoms, I believe, that they issued something like 1.3 million, or had 1.3 million requests every year. Now, it wasn't broken down, so we don't know exactly what type of requests those were, but I think, probably my count or my estimate of 30,000, remember, this is back in 2006, and I don't think they've diminished at any point since that time. Also, that just counts federal courts. I don't think the state courts are any less active than federal courts, and probably more so because they do the bulk of the criminal justice
Right,
system.
and just my last intervention on this is the admirable Google and Twitter transparency reports, if you ask them carefully, exclude any requests that are made under national security authorities.
Oh, yeah. They really should make that clear on the sites. But I just want, in terms of adding getting some oxygen in the room, this points to another issue of transparency with the companies, and not just the telcos, but everyone. These gags are ripe for First Amendment challenge by the companies that are prohibited from speaking, particularly the ones that last forever or until further unspecified action of the court. I mean, in fact, in part based on not only just general prior restraint precedent, but some litigation around NSLs. And one thing that would be really good for everyone would be if a couple of companies picked those fights. I'd love to talk to anyone who would like to do that. But we haven't really seen it yet, except so far in the NSL context. But these pen register gags are ridiculous.
Bart, can we return back to the legislative process for a minute?
Yes, please. That was going to be the last subject I wanted to cover with you guys, and then we'll open it in a few minutes to the floor.
Because I think it's important to understand practically how this works. And when Congress holds hearings, it often invites, in the best of circumstances, the various stakeholders who have equities in the issue. Congress, perhaps unlike the courts, has the ability to draw lines in a way that balances those equities in whatever policy direction Congress determines is correct. So, in all fairness to Kevin and his work on this issue, the privacy community is starting from a position where they want a warrant for all location data, even a single point of historical.
The privacy community and AT&T, to be clear.
AT&T has, but let me just say, when people come up and lobby on this issue, at least when I was there, the strongest voices for an all-warrant standard We're the privacy community. The problem is the privacy community isn't the only stakeholder here. You have law enforcement as well, and they can make a very compelling argument that a warrant standard for every type of location data will inhibit investigations at early stages and not allow them to build up to probable cause. They could even make the argument that in certain investigations, they want to rule people out of crimes. That arguably is not a Rule 41 standard where you're showing to a court that you have probable cause that what you're about to get is evidence of a crime. That's kind of the opposite of evidence of a crime. Oren Kerr has raised the issue of when we say probable cause in the location tracking context, probable cause of what? Is it probable cause that the location data itself is evidence of a crime, or is it something else? A magistrate judge in Baltimore issued an opinion where the government had an arrest warrant for someone, and they wanted to find him. They wanted to ping his cell phone to determine where he was so that that arrest warrant, which was a finding of probable cause, could be executed. This particular magistrate judge read the law to suggest that because that prospective pinging was not likely to give evidence of the crime that this individual was charged in the arrest warrant, even with a warrant, the government couldn't get it. The probable cause standard didn't fit. So this is a very, as Kevin said, complex issue. And, you know, if we want to look practically down the road and actually change the law in a way that will help our privacy rights, we have to deal with all of the different equities. And law enforcement has to compromise too. But I think, you know, outside of the courts, if you're looking for Congress to do this, all of the stakeholders have to realize they're not going to get everything they want.
But if I could ask this facetiously as a way of getting into the prospects for legislation, I mean, I take it that you are not especially worried that, you know, Al Franken and the EFF, CDT, ACLU juggernaut are going to roll over the national security establishment and the law enforcement establishment and their overlapping interests with the telcos on this one. I mean, is there, I mean, and the broader question for anyone who wants to answer it is whether there is any plausible counterforce that could allow for the creation of legislation that would be a meaningful check on this kind of surveillance.
A scandal involving a congressperson or a senator that implicates their location privacy.
One thing is that you said the overlapping interest with the telcos. I mean, the telcos, I think, have overlapping interest with their customers. Because the biggest thing the telcos will benefit from is that people feel comfortable using these devices and find it useful to have the next generation of technologies that Google Maps works because it knows exactly where I am. And the Wi-Fi signal is even better because it pinpoints me even closer.
Yeah, but they can obtain that kind of customer confidence by making sure the customers don't know how much they're being tracked. I mean, in fact, if I recall correctly, when Chris recorded and disclosed what Sprint said, was it Sprint or Yahoo that once tried to force you to withdraw what you were saying or not publish it because if people knew what they were doing, they would lose confidence in them as a provider?
To get Yahoo's surveillance manual, Yahoo and Verizon objected to the disclosure of their surveillance prices, just how much they charge the government. And Verizon was concerned people would call up their customer service and ask if they were being wiretapped. And Yahoo objected because they said that the information would make them look bad compared to their competitors. And they said that it could be used to shock the customers and shame the company.
Is there anybody else here in the panel who wants to address this, and then we'll go to the floor?
I mean, I wanted to respond to what Stephanie said, because she makes a very important point. It's a tough issue. There are a lot of stakeholders involved. This is one of the reasons why this issue hasn't progressed as much as the content issue. And I also think it is important to recognize and be supportive of the fact that on a privacy issue like this, or in any push for social change, there is going to be a spectrum of groups with a spectrum of strategies and more or less moderate proposals, and that's all to the good and helps ensure the best result. I'm just not used to the person who's left flanking me being Chris, but hey, I can get used to it. I mean, who's right flanking me? I'm sorry, I totally flubbed the joke. But yeah, Chris is usually the bomb thrower, and I'm the more pragmatic one. But in this one, Chris and Stephanie together are a bit less bomb throwy and more pragmatic, which again is good. We need those proposals out there.
I do want to respond on the legislative process. If you consider the alternative, taking it all through the courts, in the Kwan oral argument, the court struggled. There's a couple of humorous quotes. I'll spare that. Struggled with paging technology, whether people could leave a message on a pager and such, in oral argument. And it was quite disturbing as a lawyer who advises technology companies, because most of the people in that Lumascape have products that are not really understood by most of the people in their companies and investors. I mean, they've got it going, and they're going to see if it gets some traction, and maybe a couple of years from now we'll be talking about them, or maybe a couple of years they'll wind up in a What They Know article. But those companies need clear guidance, need to know the rules of the road, and to the extent we rely upon courts to give us those rules, we're going to be trailing so far that these companies will be dead before the rules are clear. So we have to go to Congress, and we have to use that mechanism, because we don't really have any other choice to get a decent sense of how to protect privacy going forward.
So state your name, please. Come to a microphone if you want to ask a question.
Chris Segoyan, ACLU. So last September, October, when the General Petraeus scandal blew up, and we got these details leaked every day, new details about the investigation through newspapers. The method by which the FBI was able to finger the identity of the person who was using this email account that had been sending threatening emails was fascinating. So Ms. Broadwell at the time was on a book tour, and so she was using Wi-Fi at various hotels. The email account that she was using was not registered with her name, and she wasn't even using the Wi-Fi in her room, which there may be records linking her room to her name. Instead, she was just logging in from the hotel lobby at these various hotels around the country. And the way that the FBI traced the account to her identity was by sending requests to all the hotels that had Wi-Fi, where the person had logged in from, and requesting the full guest list. And with these various hotel guest lists, they then looked for common names and realized that she was the only common name on the various guest lists. Now, this technique, in this case, was about hotels, but this is the exact same technique that the government uses to identify people with cell tower dumps, right? Where they get the lists of everyone who's been near a few locations and looks for common names. And in the Broadwell investigation, you had a lot of really innocent people who'd done nothing more than go to a hotel, whose names and other information ended up in an FBI database. And in the case of cell tower dumps, everyone but the target, the eventual target, is innocent, and their name ends up in a government database. From my perspective as a privacy advocate, cell tower dumps are easily the most problematic form of location request. Yet because they are normally about a very short period in time, they don't get the same kind of protection that, say, Alito's concurring opinion would lead you to believe that location data gets after a certain number of days. What can we do about location data, about large numbers of people? Do you think Congress will deal with this specific problem? Or do you think that when Congress eventually deals with location data, and whether we get a warrant standard or a Super D standard, do you think we will get the same standard for one person or 1,000 people's data, even though there are special privacy concerns associated with tower dumps?
And if anybody wants to address the implications in that question, of the data retention and sharing policies of the U.S. government, especially post 9/11. I mean, if you get a big dump of people who are not involved in the case.
I'll start. as Chris knows, because we worked on an article together, standards alone are not going to fix the problem, especially with regards to cell tower dumps, because you are getting such a broad swath of information. So there are certainly things Congress could do, like requiring minimization. Minimization is something that you find in other federal statutes, like the Wiretap Act, like even on the national security side of things in 215 business record orders, where the government is required to essentially take out of its databases that information which does not support the efforts or the purposes of which the authority it is given to collect the information is necessary on an ongoing basis. So Congress could act in this area, but I think honestly this is not something the government is going to come and scream, oh, give us more minimization requirements. I think part of the privacy advocacy needs to really come forward and say this is as important as standards, because standards don't fix the fact in the long run that the government is retaining your data. There was, and perhaps Ed, you can address this better, this recent decision by DOJ to retain data for 5 years.
Yeah, it was I think you're referring to the National Counterterrorism Center. And it was a really arcane thing. There was some wonderful journalism kind of explaining its significance, but I don't think it's gotten the press it should have, that one of the most important things, you've got all these databases across the federal government, right? You've got land records and health records and everything else. And the National Counterterrorism Center has authority to pull those records in and to ping them against their list of bad guys, for want of a better word, and to seize the information about the bad guys. And the standard had been that they get to hold those records for 6 months. And this is all explained out. But they've now moved that standard out to 5 years so that the data can be continually pinged. And so there's this gathering of information across the government. And I think that probably points to, it's something as old as the Privacy Act, really, is restricting systems of records to particular uses. You know, restricting government data to particular uses is a vital concept here, because we need to have that kind of restraint within the executive branch and within law enforcement. And I think this post 9/11 idea of fusion centers and bringing everything together and keeping it together is something that
and pushing it
privacy
out to
advocates
state, local,
focus
and
on.
tribal authorities.
Well, exactly. I mean, the fusion brings it all together, and I think that's one of the most, that worries me a lot more than cell tower dumps.
I think the two kind of combine in a really pernicious way. I mean, we have the problem already, so first we have the investigative technique of getting a lot of data on a lot of people to try and cross-reference and find the person we're looking for. The DDP principles try and address this by at least requiring a court order before you do something like that. But other than the cell phone context, we've also seen, in a case we handled a DFF, a subpoena for the IP address of every single person who visited a particular political news site on a particular day, which is just insane. Then there's the problem, even if you weren't getting these big dumps, of the data they're getting through other authorities, most notably pen registers, all getting fed into the same database. And I'm forgetting the name of this database, and maybe Jennifer can remind me, but I'm trying to remember exactly where I heard about this. But there is an FBI database where all the pen register results go into. And so if you've ever communicated with anyone who was pen registered, there is some level of map of your interactions that's sitting in an FBI database right now that we have really no details on. Trying to put minimization rules into the statutes is a really important way of addressing that problem, but I'm not sure we're going to get it. And in the meantime, these databases are getting bigger and bigger, and we are knowing less and less about what's in them.
I'm going to just alternate sides here.
I have a couple of questions. First one's for Judge Smith. I'm helping some folks pushing for legislation in Texas to require a warrant for phone tracking. And one of the provisions in the bill, because right now the orders for mobile tracking devices like in US v. Jones are sealed forever under the Texas state law. And so we had proposed making it sealed for 180 days and giving them an option to expand it for 180 days. And it turns out, so far, this has been one of the big points of pushback from law enforcement, is that they're saying, well, this is not long enough. We have investigations that go on for years and years, investigating the drug cartels or whoever. And I was interested to hear you say that you have been saying 180 days, then come back and ask for longer. So I was curious, how often are they needing more than 180 days? How long is that empirically? What need do they have for that?
Yeah, that's a good question. I started doing that, I guess, sometime in 2007, 2008. And actually, I took it on myself. I didn't put the burden on the U.S. Attorney's Office. I just, every 6 months or every year, I'd make a list of all the pen registers that I'd issued, sealed, and I sent a letter to the U.S. Attorney saying, here are the ones I've sealed. I'm going to unseal them after a certain date unless you tell me the investigation is still ongoing or give me a good reason why it needs to continue to be sealed. And so since I've been doing that, I would say about half the time they come back with a request for an extension. I haven't been, I would say I give them a year before I send my letter out, although I say 180 days. I get around to it at the close of the year. So typically, my experience, they want to keep them sealed for a year or so. Beyond that, most of the time, the investigation's over with, and they don't push back, and I just go ahead and unseal them.
Okay.
So.
And my other question was, there was a distinction being made, and of course it's common in these debates about perspective versus historic tracking. But in a context where your smartphone is checking every couple of minutes for your email, is there really a difference as a practical matter? Isn't it historical if it was 2 minutes ago? And doesn't that still, maybe I'm not understanding the distinction, but is that really a meaningful distinction?
It's not your misunderstanding. The distinction between the two is sort of an angels dancing on the head of a pin kind of thing, and the DOJ has, in litigation, sort of argued that, well, we're using these stored authorities because as soon as it hits the server, it's being stored, if only for a few milliseconds, so, hey. But I think the main distinction is, we have these statutes that are clearly meant to be ongoing in time, in part because they have things like time limits, while we have these other authorities that are clearly for obtaining pre-existing material that don't have those protections. And that's why the government has now created this kludge where they say, well, we can take the prospective protections from Pentrap and then tack that on to this de-order thing. But your point is well taken and not at all your misunderstanding. It's a deep problem.
I'll come back to you if there's time, but let's keep it. Let get Alvaro into it.
Sure. I wanted to ask a factual question. So Ed, you made the excellent point that it's not just the carriers that are getting location data. Platform companies are, the biggest ones are set to by default collect Wi-Fi data, for example, and then retransmit it back to the platform company every set period of time. Apps obviously get location data. There's a wonderful Wall Street Journal report about how 1 out of every 2 top apps in December 2010 not only got the data, but then turned around and transmitted it to third parties. And so the factual question I have is, what evidence do we have, or what do we know about whether law enforcement is querying those databases? We know, and we have excellent records thanks to the work of people in this room, about the carrier stuff, but what do we know about law enforcement location requests to platform companies or app companies or any of the other companies in that ecosystem?
I would say, I'm not going to answer that directly, but I can say this, that a lot of that goes to building profiles that are mainly assembled for marketing purposes. They want to just sell you clothes and trucks and coffee. But those same profiles are accumulated from different sources in the information ecosystem. And then you see the government having contracts to pull those profiles in, to pull that information in. Like Axiom is one, I think, has a pretty significant government contracting section. And so information flows around the marketing ecosystem into Axiom and then flows over. And that's the complexity. And so In part, I'm saying, hey, lighten up in the carriers. But the other part is saying there's a lot more information out there, and at least the carriers and the banks, there's statutes there, and there's cases. The rest of it is Wild West, and to some significant degree still.
Hi. I have two related factual questions. Number one, let's say an assistant United States attorney wants to engage in real-time cell phone tracking and has the misfortune of drawing on a particular day a magistrate judge who does not grant those orders unless the government shows probable cause. I'm curious whether anyone knows whether there are policies and procedures in place that would prevent that assistant United States attorney from simply refiling that application the subsequent day when the magistrate judge would no longer be on duty in the hope of securing a different magistrate judge who did not require such a rigorous standard. And second, and relatedly, does anyone have any factual information about the government's, whether the government sometimes files sequential requests for historical cell site information to avoid having to meet a warrant requirement for real-time tracking?
All right, everybody's looking at me, so I guess I need to answer that question.
How do you feel about farm shopping?
Well, but just
That's why he was laughing.
Just the first narrow question, having been denied by Judge Smith, can the government come back the next day to Judge Jones?
I think there's nothing I know of that prevents it, other than the potential displeasure of the magistrate judges who find that out and find out that, okay, they've gone to another judge on the same application, they turned you down, why are you coming to me? There's no, I don't think the principles of collateral estoppel or res judicata apply, and so they can do that. But typically, and I have some concern about it. I don't think that practice is necessarily widespread, although I will say that as far as the judge shopping problem, I mean, we have 5 magistrate judges in Houston, and we rotate the criminal duty among us. So there's one judge on duty for every 2 weeks. And basically when we're on duty, that's all we do, that 2-week period. And our schedule is mapped out in advance, and the U.S. Attorney's Office knows when I'm going to be on the duty and when the other ones are not. So if you were a prosecutor, what would you do? But wait, if you can, until you know you're going to get somebody based on experience. And the prosecutors know the magistrate judges. I mean, I've been on the bench now 8 years, almost 9. 3 of the other ones in Houston have been on, they're on their 3rd terms, their 8-year terms. So we all have a track record, so they know. And I've looked at the numbers, and my share of pen register applications doesn't equal the average that you would get if if it were completely random. I know that. So.
I don't think I'm speaking out of school to say, I think you have some numbers on that. I mean, do you want to, at least estimates, do you want to share those?
Well, the last time I checked, and I did it for the last 2 years, I think, I believe the numbers where I got around 8 to 10% of those applications, whereas you would expect I would have gotten 20%, 5 out of.
So you get half as many.
I get half as many, yeah.
Somebody tweet that.
Well, I mean, is that really a surprise? And I'm
No, it's not a surprise, but
I'm not sure that there's anything necessarily nefarious about it. It's just common sense, right? If you're a prosecutor.
If I were a prosecutor, I'd avoid you too.
How about the other part of the question about sequential historical requests?
I've not seen that. So
There's probably a fair amount of paperwork involved, and so much paperwork involved. I mean, there's a volume aspect to this. I can't see them doing, I mean, you could do sequential. The judge would finally, I think, come back and say, I would expect, counsel, you're here for the 3rd day in a row, the same thing? That question might spring to your mind.
Maybe.
Yeah.
Yeah.
But in the Fifth Circuit, which Judge Smith can't talk about, in Judge Smith's case, they filed an application for historical records to be created on an ongoing basis. Just what Kevin was asking about.
Okay, so we have another.
Apropos of the last question, I just can't resist telling us.
Oh, sorry, identify yourself, please.
Oh, I'm sorry, David Gray. I can't, this is not a new problem, of course, in the days before the sentencing guidelines. at least in the Southern District of New York, people used to pile in when the judge for whom I clerked, Charles Haight, who's a proud graduate of this law school, was in part one because he was notoriously light on sentencing. So he had many more plea agreements on the days that he was in part one. But my question actually goes to Kevin on a throwaway statement you said at the beginning of your comments, which is that we're not doing our job here unless we lose some cases along the way. And we got a very different story a couple weeks ago from Walter Dellinger, who was one of the architects of Jones, who, borrowing from Thurgood Marshall, said, never, never, never lose. No matter how small you have to go there to win. Because when you lose, you're done. When you win small, you survive to fight another day. And in thinking about his comments and comparing them to yours, I wonder which of the two strategies is better, particularly if we think that there are radical changes afoot in our conceptualizations of privacy and our conceptualizations of the Fourth Amendment. Because if Quine was right, then we have this highly integrated web of beliefs, and we can't change them all at once. We can only change each one of them one at a time. And so if we want to affect the big changes, don't we have to play small ball and never, never, never lose?
No. If you're in the nonprofit space, if you are a civil libertarian, as your job, I think you have to be on the vanguard and you have to be making the strongest arguments. And it may take years, it may take decades to actually prevail on those arguments. And so the job is to lose until you win. But for example, a recent loss, EFF and ACLU together tried to stop a subpoena to Twitter. Some of you may have heard of this. It was related to WikiLeaks. We represented Birgitta Johnsdottir. Did I say subpoena? Yes, I'm sorry, the D order to Twitter. And we made very aggressive Fourth Amendment arguments that the IP address logs, i.e. the logs of what IP address the targets were logging into Twitter from, were protected by the Fourth Amendment such that a warrant was required. This is a very aggressive argument, but one that is colorable and I would say probably correct, based on the gains that we made in the two cases I talked about earlier. Because we have Warshak saying that just because we have this data in the hands of a third party does not automatically mean we don't have a reasonable expectation of privacy in it. And we have the Third Circuit saying that data that is taken from you, that you are not explicitly communicating, is distinguishable from Smith and Miller. And so it was through those wins that we could iterate towards a stronger Fourth Amendment argument that we couldn't have made the year prior. And we lost that argument. We may eventually win it, but we're never going to win it if we don't try, sometimes without all the ammunition we'd like to have.
Can I flesh out the Walter Dellinger story a little bit more? So Walter Dellinger was co-counsel on the Jones case, and he is a very distinguished professor from Duke Law School. And I think most of us in the room, I certainly didn't know that he did quite a strategic move in terms of driving the Supreme Court's argument in that case. I think Scylla mentioned in her presentation that early on in the government's questioning, Chief Justice Roberts looked at Michael Dreeben, who was the Deputy Solicitor General that morning arguing for the government, and says, what in your theory keeps you from putting tracking devices on our cars and tracking us? And all Dreeben at that moment could really respond by saying, is the justices of this court? And he went on then to explain that how the court's precedent under Knotts allows such tracking on public thoroughfares. Well, at the time, at least, I think most of us in the audience didn't know that Professor Dellinger had done an interview with Nina Totenberg that aired the morning of the Supreme Court argument. And in that interview, he put it out there and he said, if we don't win this case, it's going to mean that the government can track the Supreme Court justices with these GPS-enabled devices. And ergo, you heard from Justice Roberts later that morning, a question inspired by Mr. Dellinger's idea.
That's awesome.
And so that, with Kevin is a very good advocate. Just last night, I was telling him how impressed I was that he got the Third Circuit to create even more confusion in the law. But Mr. Dellinger's strategy really, I think, spoke volumes. At least to me.
So NPR, Wall Street Journal, and Time Magazine can be force multipliers for you. But I'm going to try to close this with one last question and see if you each want to address it. What one or two legislative changes, statutory changes, would you most want to see, and in your case, Judge Smith, just as an analytic point, might address some of the things that you're talking about, and rank it on a scale from Thurgood Marshall's sure thing to snowball's chance in hell?
I'm not going to make predictions about what a legislature will do, and I'm not going to get involved in advocating what the particular substantive standards ought to be, but from a structural point of view, I think ECPA's a big problem with ECPA is the secrecy regime. It's set up so that the statute now, it's a complex statute, it rarely gets appellate review, and that's the way our process works. I mean, it's supposed to work, that when you pass a statute, every statute has rough edges, has gaps, and they're not discovered until they're litigated, then they're passed upon by the Supreme Court, and then it's a process. And then once the Supreme Court rules and says this is what the statute means, then if the Congress doesn't like that, they change the statute. So I think there are three things I think that would aid this. One, I think we need to limit and actually eliminate the automatic gag order and make it the default rule that there not be the gag, or at least that there be notice given to the subscriber or the actual user of the phone within a reasonable time after the order is issued. Secondly, I think we need to drastically limit the amount of sealing that's done. In fact, I think most of these applications actually don't really need to be sealed. I mean, they don't, all they need to do is redact the names of the confidential or the information that's in there. But if there needs to be sealing, it needs to be for a limited period of time. Third, I think we need to keep track of what we're doing. And I proposed, my idea is we need something similar to a civil cover sheet that we have for civil litigation, which is the first, if you're a lawyer, you've ever filed a case in federal court, one sheet of paper you have to file, there's a civil cover sheet that describes what the case is about, who the parties are, basis of jurisdiction, what type of case it is substantively, and what relief you're asking for. Just 8 basic pieces of information. I think we can do the same thing on the warrant side, just a warrant cover sheet. So every time an application is made to a magistrate judge, that gets on the system. That's made public. Just who the agency is making the request, what they're asking for, what crime they're investigating, what jurisdictional basis they have for the request, if they want it sealed, if they want a delayed notice. Just, you can do that on a single sheet of paper, and I think that ought to be replace this sealed event designation on our electronic case monitoring files. So,
Ed?
and I think Congress could legislate that. Courts can do that on their own too if we want to, but it's a process.
So we're supposed to stop, but I want each of you to answer that, and then we'll, by indulgence of the...
So my 3 items, one would be the elimination of the special treatment of 180 days. That strikes me as absurd in this day and age. It was an artifact of the time when storage space was awfully expensive, and now storage is essentially free. The second one is, and that could well happen. The second one is a much bigger ask, is to make all the folks on the Lumascope, the PowerPoint I had up there, subject to the same rules, so that the carriers and the platform providers and the app providers are subject to the same set of privacy restrictions, and it's against the whole ecosystem, so that you don't have this heavily regulated telco carrier dealing with the essentially unregulated internet company. We should have a similar, a level playing field, and then let consumers choose from there. And the third thing is some way to accelerate judicial review in this area, so that we don't have Quan coming out and giving us guidance about whether pagers may or may not be a protected privacy interest when no one's using pagers anymore.
I'll start with minimization, because I think, as the example given by Chris, these cell tower dumps are becoming more and more useful to law enforcement, that we have to find some way to make sure that innocent third-party data doesn't remain in databases for potentially forever. So at some future time, that data isn't used in a different crime, and that was, and therefore there was no judicial process that allowed for the use of that data in an unrelated investigation. The reporting requirements. I mean, I very much take Judge Smith's point that Congress right now is trying to legislate in a space where they don't have a lot of good information. I mean, I feel like, unfortunately, if we waited for only reporting requirements before we started on other things, we'll be here 5-10 years from now. But going forward, Congress needs good information so they know in the future when, if at any time, the equities need to be rebalanced. And finally, clear rules dealing with law enforcement access to location data, both historical and prospective, that do a fair job of balancing equities and giving us better privacy rights.
I think those are all fabulous ideas. I support them all, as well as the digital due process principles that you can find at digitaldueprocess.org. The one thing I'll throw out in addition, and this is something I'd proposed in my article for all of ECPA, I think Warren Kerr had proposed this for the content regarding parts of ECPA, and that is a suppression rule such that if you obtain any information in violation of ECPA, that gets thrown out. That would prompt a lot more precedent, a lot more facts coming out of the court grappling with those issues, and would create very strong incentives to actually follow ECPA. Three things that we don't really have right now.
Thank you all for coming.
Thank you.
Thank you.
Welcome back. All right. Thanks so much. My name is Jennifer Valentino. I'm with the Wall Street Journal, and we are going to have a discussion here about my favorite surveillance technology. They're known colloquially as stingrays, and I think most of you are here for Chris's technical explanation this morning, but he's going to go over a bit more about this particular type of device and how they were originally used and how they're used now.
So I've been interested in the stingray for a couple of years now. There are two sort of things that really pushed me down this path. The first was reading DOJ's electronic surveillance manual, and there's a line in there that basically tells DOJ employees, if you're going to use one of these devices, if you're going to use a stingray, make sure you call Mark Eckenweiler first. And for those of you who know, Mark, before he left DOJ, was like the godfather of wiretapping at DOJ, and so the fact that there was a line in there saying, don't use this without calling this guy, was like a big red flag. There was something suspicious about this technology. And then in the spring of 2011, I received an email from the court-appointed shadow counsel for Daniel David Rigmaiden, who said, hey, I've found you by Googling. I think you might be interested in some of the items in this case. And it turned out that there was an amazing case with a pro se defendant who was running circles around the government and had been able to somehow figure out that they'd used this high-tech surveillance device in his case. I gave that to Jen, and she ran a front-page story about it. And ever since then, there's been a lot of interest, both in the privacy scene and in the media, about this high-tech surveillance technology. I want to just talk a couple minutes about what I've learned in the last couple of years about this stuff. So the stingray is the trade name for a generic device known as an IMSI catcher, IMSI catcher. And these have been around for about 15 to 20 years. They came out of Germany and the UK, and in fact, there was a long patent lawsuit between several German and British company over who owned the patent for this. And last year, or 2 years ago, the British Appeals Court ruled that actually this was not original enough to even be deserving of a patent. Originally, this technology was used in the intelligence and military space, and to a large extent, it still is used a lot there. Although Harris has really captured the US law enforcement market, the US military uses similar technology made by Boeing and Selexion, a British company. And in fact, there are lots of other governments around the world who are using this stuff too. We've known that law enforcement have been using technology like this for about 15 years. As I mentioned this morning, Kevin Mitnick was caught using one of these devices. As I understand it, the device was actually on loan from Bell South, who at the time was concerned about people cloning analog phones to make free calls. These devices have traditionally been very expensive, around $60,000 a pop, although Harris's latest product in the Stingray family costs $170,000. Local and state law enforcement agencies have been buying these in the last few years, largely through DHS grants, as I understand it. And so I've been trying to learn as much as I can. I've gotten the price lists, I've gotten some of the sales literature describing what these things are and who's buying them. I've struck out with a lot of the law enforcement people, but where I got some really interesting stuff was through the FCC. So it's important to note that because these devices broadcast as cell towers, and because they're using the same spectrum that the cell phone companies have paid for, and paid for, it's extremely expensive spectrum that is auctioned off by the FCC, it's not entirely clear whether you can just set one of these things up and use it. And I know that Alan will talk about this a little bit more. When I filed a FOIA with the FCC, I found out that local and state law enforcement agencies actually request permission of the FCC before they use these things. Every law enforcement agency, every local law enforcement agency that I found that has requested permission to use these things, all had the exact same text in their letters, which suggests that it was probably provided by Harris as like the process of issuing these things. And so the FCC is playing a role. The FCC knows that this technology exists, and they license the Harris device. They actually, when Harris makes a new model, they submit it for FCC testing. The FCC is giving them some kind of like device ID to show that it doesn't unduly interfere with the communications network. And so the FCC knows what's going on. It's also, I think, really critical to understand that the Stingray, because it emulates a cell tower and tricks people's phones into talking to the gear, is essentially exploiting a security vulnerability in the cell phone system. And for those of you who aren't aware, there's a debate going on right now in Washington, largely via scholars, over whether there should be expanded law enforcement intercept capabilities for things like Skype or Gmail or other modern communication services. And there is a school of thought that suggests that, or that believes that new legally compelled interception backdoors are a bad thing. And so a group of scholars, including Matt Blaze, Susan Landau, and Steve Belevin, have said it's better for the government to hack into people's equipment and people's computers than it is to force Google or Skype or Facebook to put in new intercept capabilities into their products. Well, if you think of the services that AT&T and Verizon provide when they provide a wiretap, a CALIA required wiretap, if you think of that as a legally compelled backdoor, then the use of a Stingray is akin to the government hacking into your phone. They are taking advantage of the security vulnerability in the phone, or a flaw in the design of the phone system, which is that phones will respond to any tower that advertises itself as a tower of that person's phone carrier. And there's no way to really fix this. Even if you have the latest and greatest cell phone in your pocket, whether you have an iPhone 5 or the Google Galaxy Nexus, whatever, even if you have a 4G phone, your phone still talks 2G. Your phone is backward compatible because you may drive to West Virginia and go and see your family, or you may go camping. And so even though the 3G and 4G protocols are secure and have authentication and have encryption and have all these bells and whistles, what the government does is they jam 3G and 4G, and they force your phone to go back to this crappy, insecure 2G standard, and then suddenly your phone is talking to the government device. So it's important to understand that the government, through this technology, is in fact exploiting a vulnerability in the phone system. It's also important to understand that the government doesn't have a monopoly over the use of Stingray hardware, right? So if I'm Joe, the average citizen, and I call up AT&T and I say, I would really like it if you wiretapped Alan's phone, AT&T's lawyers would tell me to get lost, right? The government has a monopoly over lawful interception. Foreign governments cannot call up AT&T and say, we would really like it if you intercepted Alan's phone calls. They will also be told to get lost. But when it comes to exploiting security vulnerabilities in the phone system, anyone who wants to do it can do it. Even if it's illegal, effectively, anyone can do it. And so although the Stingrays and the similar devices were originally sold by Western surveillance companies in Germany, in the UK, and the US, there's now a global market for this stuff. And there are Israeli companies and Spanish companies and French companies and Chinese and Indian and Russian who sell it to basically anyone who shows up. And so what this means then is that our phones, individuals' phones, businesses' phones, the phones of government officials, are all vulnerable to the security flaws that the Stingray takes advantage of. The FCC knows about these flaws because they are licensing the Stingray and they are permitting local law enforcement agencies to use the Stingray, and the FCC isn't doing anything to fix the vulnerabilities because they're sort of in on the scheme. The Stingray is just sort of one example of the balancing act that takes place when the government exploits security vulnerabilities. And this is just one example. But the Stingray problem is a big one because the cost of fixing this is so expensive. If the government takes advantage of a security flaw in Windows, Microsoft can push out a patch at a relatively low cost and people are suddenly protected. When the government takes advantage of a security vulnerability in the phone system, patching every phone, patching every old phone is really expensive, and the phone companies don't want to do it, and in some cases you won't be able to patch many of the phones. So this is a flaw that is going to stick with us for a long, long time. The last thing I want to say about these devices is that over the last sort of year and a half, 2 years, I've called up several companies in the Beltway area who sell or resell these devices, and I call them up on the phone, I say, hi, my name is Chris Segoyan, I work for the ACLU. I'm calling about this device that you sell. I'm fascinated by it, blah, 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 blah. And I don't think they get many phone calls. Some of them are in Chantilly, Virginia. A bunch are also in Fayetteville, North Carolina, which is where Special Forces and Fort Bragg are. And so I've called these folks, and on multiple occasions I've had 30 to 45-minute phone calls with people about this technology. They are quite happy to answer questions, but at the end of every phone call, they all let me know that they will have to notify the people at NSA about the telephone call, and if I want to talk to them again, NSA will have to approve it. I just think it's interesting to flag the fact that this is a technology that NSA seems to be coordinating the use of in some way, and NSA is definitely in communication with every vendor of this equipment. Oh, and the last thing I'll say is, although companies sell this around the world to governments, and although the Chinese government can buy this and the Indian government can buy this, there's also been this really interesting change in the last couple of years, which is you can now build one of these devices for about $1,000 using open source hardware. And in fact, people have demonstrated this at Black Hat and DEF CON. And in fact, last summer, I organized a demo for congressional staff, for staff working for 3 members of Congress. And we did a live demo of interception of voice and text messages in a House hearing room and scared the bejesus out of the staff assembled. If you are comfortable with your own government using this, and you are comfortable with the risk of a foreign government using this, even because it means that our government can still keep using this against the bad guys, it may, even if those things are okay, it may be time to evaluate the status quo when any hacker or identity thief or private investigator can build one of these things and park it outside of a Silicon Valley office or a bank or a law firm and intercept calls. But the age of low-cost stingrays is looming on the horizon, and I don't think law enforcement have fully woken up to what's coming soon. Thank you.
So with that in mind, Alan, why don't you tell us a little bit about the legal basis for these and the broader effect they have on privacy as well?
Sure.
Let me see if that can work.
Oh, you know what? Sorry, I forgot to say one thing. I forgot to say when you would use these. So let me just quickly say why you would use a stingray. There are 3 main scenarios when you would use a stingray. So the Rig Maiden case, as I mentioned this morning, the phone companies are required to provide location data through the location capabilities through the E911 law. Verizon and Sprint do this via GPS chip, and T-Mobile and AT&T do it through the towers. Verizon and Sprint only put the chips in phones because phones are the only devices that are required to be able to call the ambulance and the police. Verizon and Sprint don't put GPS chips in their data cards, the card you put in your laptop to connect to the internet over the cell network. And Daniel David Rig Maiden was using a prepaid Verizon data card to access the web, and the government wanted to locate him. They could not get an accurate ping of his phone because he was using a Verizon data card and Verizon didn't have a GPS chip. So the first reason you would do it is if the phone company is not capable of locating the device for some reason. The second reason you would do it is if you believe that your target is switching phones very frequently. So let's say your target is using burner disposable cell phones. You know where he lives, you know where he works, and you park the Stingray van outside his office and send the signals through his wall, and then you get the serial numbers of the devices inside. You're not looking to geolocate, you're not doing an intercept, although devices may be capable of doing an intercept. You just want the serial numbers of the phone so you can then go to the phone company and bring up a wiretap. In that case, a Stingray is going to be really, really useful. And then the third and most interesting scenario is when the phone company won't help you. So if you're doing a foreign intelligence surveillance effort, if you're spying on politicians in France and the French phone company won't help you out, a Stingray is really useful because you can drive it through the streets of Paris. The same goes for the streets of Washington, D.C. if you're the Chinese government. When you cannot get the phone company's assistance, the Stingray is the next best thing. All right, sorry about that.
No problem. I want to thank Chris and Margot and people at Yale for having me here. I'm going to talk a bit, as Jen mentioned, about the legal basis for the use of this technology, which I think ties together some of what the other panelists have been talking about today. So the first panel talked a lot about the Fourth Amendment and standards for location tracking. The second panel talked about statutory standards. And I think we're in an interesting space here with the use of these IMSI catchers and digital analyzer technologies where the legal standards are not clear. We know a bit of the standards that law enforcement believes applies. The DOJ has their own theories, and I think that it's interesting to unpack that a little bit. So if we start out with the Fourth Amendment interest that we spoke about this morning, two cases other than Jones, I think, have an impact on the use of this technology. And those two cases are United States versus Caro and Kylo versus United States. So these are both cases that involve involve technologies that can reveal details within protected spaces. Caro was one of the original sort of tracking beeper cases. But the unique thing about Caro was that the Supreme Court held in that case that when they used a beeper technology to reveal the location of a barrel basically within a home, and the fact that that barrel remained within the home, that was a Fourth Amendment search. And of course in Kylo, the Supreme Court ruled that the use of an advanced technology to reveal details, in that case heat, emanating from within a home, also constituted a search. So these are good cases to keep in mind when thinking about the use of the Stingray technology, when in fact it can be used and has been used in cases like Rig Maiden to locate individuals within their home. So then we think about what the statutory provisions that apply are. So there are statutory protections in place having to do with location. I just want to key on this quickly. We've talked about ECBA today and the standards for requesting disclosure. Of course, that's not evident in this case where you're not requesting records from a phone company, you're collecting them directly. So I just wanted to outline that there are protections specifically in the Communications Act highlighting location information as both consumer proprietary network information and limiting the collection of location information with a mere pen trap order. And this is where the hybrid theory that was discussed in the previous panel comes from. So the DOJ view has been, and as Chris mentioned, this technology has been used for over 15 years. Used to be referred to as a digital analyzer. The DOJ view was originally that they could get a pen register order to use these devices. A court ruled in 1995 that a pen register, that these devices did not fit within the statutory definition of a pen register, but the devices used at the time, which was only collecting call information, didn't require an order at all. And so it remained largely unregulated. So that changed when the Patriot Act amended the pen register statute. And now it's the DOJ's view that that these devices can constitute a pen register because they collect signal information. So you can see a bit of the language there of what was changed and why that matters. So that this is from the FOIA. This is a PowerPoint deck from a FOIA request that I'm pursuing for documents related to Stingray from the FBI. So it's the DOJ's view that this device fits under the pen register standard. But of course, as I just pointed out, the current communications law prohibits the collection of location information using a mere pen register order. And I think Judge Owsley will mention how the government is going about requesting these issues. And the other problem that comes up is the issue of interference. So the Communications Act also regulates devices that cause interference to communications services. The DOJ has noted, again, in their own documents about this technology, they've flagged this as a potential issue. This one provision of the Communications Act, 333, prohibits willful interference with a signal. As Chris mentioned, some law enforcement agencies are seeking essentially permission from the FCC. It's possible that this is at issue there. But I've also seen reference to the pen register statute in the sense that they're keying in on this language at the bottom about imposing a pen register with a minimum of interference. But this language does not actually mesh with the type of location triangulation that's actually going on with this technology. So the broader privacy implication here is similar to what Chris discussed earlier about tower dumps, that necessarily a Stingray is going to collect a broad range of information about nearby devices beyond just the target. So one of the questions that we have is, what happens to all that data? What happens to the data regarding innocent devices? As you can see, the FBI is not particularly forthcoming on their maintenance or purging of this data, but it's good to know that they at least are thinking about it. And this brings up another issue that Chris mentioned, which is the extreme control and secrecy that's being exerted over this technology and the use of this technology. As you can see, there are heavy redactions in the FOIA documents that I've received so far. And one thing that I think is particularly interesting is that these documents are being withheld under the National Security Act of 1947, which is strange given that I'm requesting these documents from the FBI, not from the NSA. So that's an issue that hasn't been completely ironed out yet, but as Chris pointed out, there's tie-ins back to the NSA for the use of this technology, and there's some level of sort of control going on there. And that sort of, you can see that in the documents themselves, because huge swaths of the pages that have been disclosed are withheld under this B3 statute, including, in this context, it's a conference that was held at some point for DOJ employees, and I can't even know the titles of the subject matter on the agenda in the conference. Introduction to blank, or just blank. And this is a very instructive page. So we're not getting a ton of information about how this technology is used, but as I mentioned, there are several interesting questions about the legal authority to use this technology under the statute, under the Fourth Amendment, and that's what I think we're really working to uncover here.
Thanks. So, Judge Owsley, what are you seeing actually in your courtroom when these are requested?
Well, I think just generally, and Judge Smith will probably back me up on this, it's not like we see a lot of these requests. To my knowledge, and I say to my knowledge because, well, to my knowledge, I've seen two in the last couple years. I may have seen them before and not realized what it was, because what they do is they present an application that looks essentially like a pen register application. So any magistrate judge that is typically looking at a lot of pen register applications and not paying enough attention to the details may be signing an application that is authorizing a stingray. And at one point, I got my first one, and the first thing I did is I called up Judge Smith and said, "Hey, I got this. This is curious. What do you think about that?" He's like, "Oh, that's a triggerfish." What's a triggerfish? Well, it's this and that, and so it's a stingray, triggerfish, cell site simulator, and so that's one of the things is you have all these terms for it, and in my experience, magistrate judges are not the most technologically savvy group of people, maybe more so than other judges, but not all that conversing in a lot of this technology. So I sent out, after a while, I got another request, and I sent out an email essentially to every magistrate judge in the country, explaining to them what a stingray was and what a cell tower dump was. And I wanted information on what they were seeing on both of them. And I would probably get responses from, say, maybe 10% or so of the magistrate judges around the country, many of them saying, "That's interesting. I've never seen anything like that." And then a few people would have seen one or the other or both. Either somehow in Texas, it's very prevalent that you need stingray requests and cell tower dumps, or there are magistrate judges around the country that are getting these requests, not realizing what these requests are, and authorizing them as a 2703D order or a pen register. So let me talk a little bit. And when I get these types of requests, Stingray, usually I have an agent in my office, and so the first thing I do is I start asking them questions, and they often don't understand what they're asking for either. And so I said, well, let's get the AUSA on the phone, or let's get the AUSA over here, and we can talk about it a little bit more. And so we do that, and typically the AUSA doesn't have any more insight or understanding of the technology or what they're fully requesting, because they're using basically a form that's been provided to them by Maine Justice, and they're just told to go forward and use that form. I'm just going to give you the two examples that I have, so you at least have an understanding of where they've attempted to use them in my experience, why, and give you a sense of sort of how they might be utilized. The first one I had was a request involving a prison. And there were allegations of criminal activity within a prison by inmates in which the government wanted to access, they basically wanted the Stingray to locate and track that phone and find out where it was and see what it was calling and whatnot. And I said, that's when I called Judge Smith, and we had a conversation. I had some conversation with some other people. And to the AUSA, I'm like, well, I need more information about this. I'm not sure, that this really fits into the pen register statute. So I'm told the AUSA will get back to me with a memo. So a week later, I call up the AUSA. I said, I'm still waiting for that memo. I have this open pen register application on my desk, and I hate to let these things lie around. Oh, I'm going to get it to you. And it goes on for about 6 weeks, and finally, the AUSA comes back and, well, Judge, a couple days after we filed that application, the prison officials located the phone. I said, well, okay, then you don't get an application because it's moot. And they went away. And then, so the second time I had one was a drug enforcement investigation, and they had a cell phone number of the target at one point, but he had changed phones to change his number, and so they weren't sure of what his number was, and they wanted to track him based on where he was living. Again, I asked him sort of for authority. It's not forthcoming. I asked him to explain to me what, if anything, they're going to do with the various other information that they get. Again, that's not forthcoming, and ultimately I issued a decision in part relying on some of the stuff that was mentioned about Rigmate and denied it. And so that's generally been my experience with Stingrays.
So in the boilerplate orders that you are being asked to hand down, you said they look like regular pen register orders, but usually those are referring to a third party. And so actually in the Rigmaiden case, one of those orders also was referring to Verizon to assist the government. But it seems to me that that's not actually what is happening. So what did those orders look like? And
to be honest, I haven't looked at one recently, but if you go onto the DOJ's website, or not website, if you search electronic surveillance manual, you can get, it's about, 250 page document. And if you search for the term triggerfish, it will come up with the request, and it uses the language from its pen register application, which I think just precedes it in the manual. And they also attach a proposed order to attach with the application. So it's not exactly like your garden variety pen register application, but they're citing 3123. They may label it as a pen register because their theory is they're seeking a phone number or what phone numbers are receiving, and so they're trying to pigeonhole it into that, and so.
I think the other thing to keep in mind there, if you look at, I think this is the right one. So one thing that they're doing at times is a pen register is usually directed at a third party, and one of the reasons is that the third party helps them implement the pen register. And that's not necessarily the case with the Stingray because they can just use the device to capture information about nearby phones. But they do, I believe, at times they can use the service provider to help them facilitate that process by first narrowing the scope of where they're looking. So it's possible that in that example that Verizon would give them cell site information first to narrow the range of where they're going to go with the van. And then once they have that information, they take the van out to that area, turn on the Stingray, and then they can find the target device.
So the DOJ now says that these are pen registers. I'm going to guess that you guys disagree, but what do you think the order should be? Or do you think that pen register is valid? I guess it's theoretically possible that you've completely changed your mind in the last
20 minutes?
20 minutes, yeah.
I mean, so the ACLU and EFF filed an amicus brief in Rig Baden's case. And one of the issues that we raised in our brief was that these devices and the use of these devices is very similar to a general warrant, right? The thing that our founding fathers fought against and opposed the use of by the British, right? In the scenario where the government doesn't know who they're looking for, they know the telephone number, but they don't know where the person is, or they know the phone serial number, but they don't know where they are. And the government's driving around a neighborhood with like an unmarked van, driving around trying to narrow down and find out which house a particular device is in. They're sending signals through people's walls. They're sending signals through the walls of a lot of innocent people. None of those people are the suspects of a crime. None of those people will ever be told. It's not really that different than the police knocking on every door and walking into everyone's living room to see if there's someone hiding behind the sofa, except that here the government has a device that does it for them. I would argue that, and I'm not a lawyer, and this is not the ACLU official position yet, I would hope at some point we would be able to argue that, in fact, when you're using a Stingray to find someone where you're going to be looking through a lot of innocent people's houses, that in fact a search warrant isn't enough either. I just don't think it's kosher for the government to be searching the homes of 50 or 100 or 200 innocent people to try and find the one guy who's hiding somewhere. Now, if they know where the target is and they are just trying to find out which cell phone he's using that day, so the sort of drug dealer burner scenario, I think in that case a warrant should be the right standard. They're sending signals through your walls. I think it's very similar to the spike mic cases that we saw a few decades ago. I mean, these signals go through the wall of your house, through your car, through your purse, through your pocketbook, through your jeans. I mean, wherever your phone is, the signals are going all the way through. This is different than Kylo, because in Kylo you had this these thermal signals emanating from the house. Here, the government's signals are going through your wall. So I think at the very least we're looking at a warrant, but I think there are some real situations where they shouldn't be using these things at all.
I think that one of the problems with the pen register theory is the provision that I talked about earlier of CALEA that limits the collection of location information with a mere pen register. And this is a problem that's solved theoretically in the historical and prospective tracking context, as the earlier panel discussed, with the hybrid order. But since we're not talking about stored communications, the hybrid order doesn't make any sense in this context, even if it made sense in the other context. So I think it's very problematic to say that they can use a pen register order to authorize Stingray surveillance that collects location information. And then in addition, I generally agree with what Chris was saying about this penetrating the walls of homes, closed containers. I think in general between Caro and Kylo and now Jones with the trespass theory is a pretty clear view that this is a Fourth Amendment search, and I think that in general that requires a warrant standard, and it's even more problematic when you talk about the impact on private users, non-target users, and whether the solution is minimization or not using the technology at all is I think an interesting conversation, but it requires us to know, I think, a lot more about the technology and to have a bit more transparency about what's going on.
I just wanted to follow up on the pen register, the statute. I think historically, the way the statute is designed and drafted and the way it's been interpreted by courts is that you need to have a target number. So it sort of flips it the Stingray sort of flips it on its head in the sense that you're really looking for the target number without, instead of knowing what the target number is getting and then gathering the information that Congress anticipated in its pen register applications. And I don't know the answer to this in the Stingray context, but I view, I see to me, there's a fair amount of overlap for cell tower dumps and stingrays. I think stingrays is sort of cell tower dumps on steroids is I guess on some level how I view it, because you have, actually with a pen register, you have a lesser standard for the government to go out and do its own surveillance, as opposed to, at least with the way that they're trying to do cell tower dumps. Now you have a higher standard in 2703D, and you actually have to go through the phone company. But I've seen in cell tower dump cases, there's a case out of Connecticut where they convicted someone where they got 180 cell phone numbers. Now, 179 of those were folks who had nothing to do with the crime, and if you want to look on Google and search it, you can find all those cell phone numbers. They are posted on the internet. There was a case out of Arizona involving, to me, the classic scenario, and Chris alluded to this earlier today about how you use a cell tower dump, at least efficiently from law enforcement perspective, in the sense of there was a series of bank robberies in Arizona, and they targeted 4 of the banks in rural areas, and I think they got over 150,000 different hits. So, and it's unclear to me if that's 150,000 different individuals or different utilizations of a cell phone. But you can see that, there's a lot of compromise of that type of data, and I don't think the government sort of, one, appreciates that or has any plan for what they're going to do with it.
So one of the things we actually haven't really touched on is the capability of stingrays and MC catchers to actually gather content. Is that something that any of you have heard about? And, is that a concern for you at this point?
The Stingray device, or the MC catcher, the generic technology, can intercept content. I know this because I saw it with my own eyes in a congressional hearing room last summer. Harris, the company that makes the name brand Stingray product, doesn't have a lot of marketing material that's shown up online. In fact, I got my first ever glimpse at a bunch of material last week in Portuguese that I downloaded from a Brazilian surveillance vendor that happened to have something floating around. I've not seen any English language documentation for many of Harris's products. We do know from Harris's price list, the price list made available through the GSA, that they do sell an interception module for the Stingray product line. We don't know which agencies have purchased that interception module. However, for the other big IMSI catcher vendors, the Boeings, the Selections, and then all of these Israeli and Russian and Swiss and German companies, all of them advertise in big bold letters in their marketing material, interception of communications content. Not only do they do interception, so the classic scenario they describe in their sales literature is a hostage situation. You have a hostage crisis going on, the government parks outside, the bank or whatever, turns on their fake cell tower, and when the hostage takers call, a taxi company, it reroutes the call to the police taxi company, and they're like, sure, we'll be right there, and then they send the fake taxi to come pick them up. So with these commercial products, as advertised by foreign surveillance vendors, they can reroute calls, they can block calls. You see them being used right now in prisons in the US and abroad to only allow whitelisted phone numbers, so the prison guards can make all the calls they want, but anyone who's smuggled a phone into the prison is basically blacklisted. These devices can capture content, and Harris's previous family of products, the triggerfish, these analog. So the difference between the triggerfish and the Stingray is the triggerfish did analog cell phones and the Stingray did digital phones. That's my understanding. And the triggerfish line, more marketing material for those is available online, and those definitely advertise that they could capture content. I mean, I think they are capable. Whether the DEA or whether Joe Arpaio in Arizona has purchased the content interception kit is a matter for debate, but the technology is definitely capable of doing it.
And I think one thing to note is that in the DOJ documents that I've received so far, there are, I should have added to the slide as well, but there's definitely a number of pages where, at the top of a big slideshow for training materials, it says, "Thou shalt not intercept content," right? They're aware of this problem, but that in and of itself implies that the capability exists. And when you see discussions in email chains about internal discussions about the use and training of materials for this, you see references to one person to another saying, "Oh, do you understand how to turn the knobs?" Right? And so there's an implication that for some of these items, there may be the capability. They're maybe explicitly told not to do that under certain circumstances and under certain legal authority. But if the capability exists, and as this technology is loaned out to local law enforcement and on down the chain, is everyone going to be trained the same way? Is everyone going to be aware of the legal limitations of what they can do? If the capability exists, then I think there's always a possibility.
So I realize you've only had a couple of these come before your court, but, is this something that is mentioned? Do you think judges
They don't
are
understand
aware
the
of this?
technology,
Yeah.
but they know that they're supposed to say, we're not going for communications.
Okay.
I mean, so there is sort of this party line, at least at this point in time, of this is surveillance, but it's not surveillance for communications. So in the two cases that I've had, they at least understand that that's what they're supposed to say. They may not understand why they're saying it or anything else about the equipment, but they understand that that is, a concern from Maine justice, and so they're concerned about it.
So do you think there's an understanding that this equipment is also gathering numbers of, innocent devices?
Well, I mean, I don't know. I haven't seen any literature from DOJ, and I haven't heard anything from their assistant United States attorneys that I've dealt with. I will say that I think the agents don't necessarily get the message that DOJ assistant United States attorneys get. So, when you talk to the agents, they're like, "Oh, we're just going to drive around. We're gonna follow this guy, and then he's going to go over to a club, and we're going to turn it on over there, and we're going to see, and then we're going to follow him here. He's going to go eat." And so there's a lot of that sort of. They understand how to surveil, but they don't understand the implications of what they're utilizing, and they may not appreciate the distinction between communication, no communication. I don't know if there's just a button that you hit or something like that, and all of a sudden you hear everything or not. But there's always that temptation to see what's going on.
I also think one thing Chris mentioned that I would underscore as well is I've seen in descriptions for local law enforcement applications for this technology mention of the denial, the sort of blocking functionality. And that gets into a whole host of other issues, as I mentioned, the interference problem, and just a question of what legal authority is required to deny service to someone's phone, right? As it's not exactly a search, but it's certainly something that I would imagine law enforcement can't just do whenever they please. They have to have some level of authority, and a pen register trap and trace doesn't really seem to fit that at all. So.
There was one other point I wanted to emphasize, which is, so I've been filing FOIAs the last couple of years about this stuff, and I got a really interesting set of documents from ICE, Immigration and Customs Enforcement, a few months back, revealing that ICE has purchased $3 million worth of Stingrays over the last few years. And this was in the context of a request to buy more stuff, and they said, we should be able to buy the Stingray brand products because we've already spent $3 million on this stuff, and we don't want to switch to a different brand. At the time, they were also purchasing the airborne mounting kit for the Stingray, so airborne mounting kit and airborne training, so they were putting these things on airplanes, whether those were drones or manned planes, we don't know. ICE has $3 million worth of these things, and they're $60,000 a pop, so they've got a couple. The FBI has them, the DEA has them, the U.S. Marshals have them, local and state law enforcement agencies have them. There are a bunch of these things floating around, right? The police in Minnesota, in Texas, in Florida, in California, in LA they have them. So they're being used around the country by local, state, and federal law enforcement agencies, yet we have one opinion in 1995 saying that these things are kosher without any kind of order. And then last year, we got the first order from a magistrate judge saying, no, I'm not going to allow the use of this thing without a warrant. It's strange that there are so many of these things that when Alan files a FOIA, the FBI tells him that they have 20,000 documents that's going to take 2.5 years to deliver. They have 20,000 documents covering the use of this technology, and we have 2 orders, 2 or 3, maybe, I think there's maybe 2 other cases we found was like a mention here and there. It's really strange that this device is being used in so many places by so many law enforcement agencies, yet so little stuff has surfaced. And I think that demonstrates an intentional act by law enforcement agencies to suppress discussion of the existence of this technology, how it works, or that it's being used at all.
So how is it that they've successfully been able to do this if they're supposedly using them so much?
I mean, I think if you want to be optimistic, you can say that they've forgotten to be as open as they could be in describing this. One other way would be to say that they're hiding the ball. But in Rigmaden's case, for example, he had to go through, 2 or 3 court-appointed lawyers, and then finally fired them all and did it himself before he was able to catch them. He was able to find sufficient information to show that they were using this. And even for a while, the government was saying they weren't using this. They were saying, oh, we were merely passively collecting data. We weren't sending out any signals. Now, maybe that's because this is so technical that the folks who are writing the briefs don't know what's going on. Or maybe they just really, really don't want anyone to know what's happening. But there really isn't much discussion of this. And there's a lot less than you would expect, given how many people have this device.
I think one answer also is that, again, from the documents, it's clear that Justice has a pretty strong belief, and this came up in the Rigmaden case as well, that this is a law enforcement sensitive method, and it's their belief that it's privileged, and they will actively, and they did in the Rigmaden case, and they have in at least one other case, United States versus Gary, suppressed information about the technique in discovery in a criminal case. And so it's really hard to build case law around the use of this technique when they refuse to disclose anything about the technique, even in a criminal case where they're bringing evidence that was gathered using that technique.
But it's not just law enforcement, right? This is national security as well.
Right.
And I think the fact that NSA is involved in some way in this, and the fact that they're using similar technology, if not the same technology, in war zones, in Iraq, in Afghanistan. These things are likely mounted on drones. There's a significant national security aspect to this technology, and I think you end up with a weird situation when you have small-town sheriffs and intelligence agencies using the same gear, right? And it's much easier to keep a secret when it's just the spooks. But when you have small-town cops using this stuff and people being prosecuted using evidence that's derived from this gear, it becomes very difficult to keep everything under wraps.
Yep.
So is this, the evidence that they get from these, does it appear in any cases? I mean, how is this not something that is, used later on?
Yeah, I mean, as I mentioned, in the Rigmaden case, it came up in at least one other case, again, criminal case. They briefed this law enforcement sensitive technique issue. And I think they being Justice takes the position that even in criminal cases where they have evidence derived from this technique, they don't want to reveal the existence of the technique or the fact that they used this technique because they consider it to be sensitive and privileged. And the problem there is, as we discussed earlier today, we know there's a long history and information available about wiretaps, and we know a lot about at least how historical cell records are collected and prospective cell record requests occur. And we know comparatively very little about how this technology is used by law enforcement, and it makes it very hard to evaluate, the equities and the statutory and constitutional standards that apply to the use of this technology when it is basically in a black box.
Well, and that burden would fall on criminal defense attorneys. I mean, and they're, federal public defender, very taxed, or even, the criminal defense attorneys in general. So they get their discovery package, and then, they go forward from there, and they may not even think to question how the number was obtained or whatever was obtained through the Stingray. They just sort of go forward, and if it doesn't scream out to them as a sort of standard sort of motion to suppress issue, then they go on, and, they look at the other issues that they may or may not have for their client's defense.
I mean, I think it's also important to remember here, the government still hasn't even conceded that they were using a Stingray in Rigmaden's case. They say that the Stingray is a generic term used by officers. They won't even confirm that it was the Harris Stingray device that was used in this case. Right? I mean, they say that the officers who used those words in the documents that Rigmaden obtained didn't really know what was going on. They weren't the ones using the technology, and so, they've conceded that they used some equipment that transmitted signals, but they won't even say which particular equipment it was or what kind of signals were sent.
So I have one last question, and then we'll open it up to the room. But are you more concerned about stingrays or cell tower dumps? Because Judge Owsley mentioned that these are like cell tower dumps on steroids, but I do feel like you have to have an officer who's driving around or flying around or whatever. So it's a little bit more like the beeper scenario than just getting all the cell towers in your city.
All right, so I want to emphasize, this is my personal view, because we haven't figured this out internally yet. I am most bothered by direct acquisition of surveillance by the government. Whatever role the phone company lawyers play, they are perhaps some form of speed bump. And we can argue about how effective of a speed bump they are, and if they've been thoroughly captured or just slightly captured by law enforcement. But they have some form of resistance. There are instances where the phone company lawyers say, you know what, that's not going to work, we need a higher order, or maybe we'll tell the person, or we'll invite amicus briefs from outsiders. That's not possible when the government goes out and drives around the neighborhood and sends signals, invisible signals through your wall. It's also not possible when the government hacks into your cell phone. And my personal view is that direct acquisition or direct surveillance by the government is way more prone to abuse and is way more likely to remain secret forever. I am deeply bothered by secret surveillance techniques that are not reviewed by an independent third party, and given that the government doesn't seem to be too inclined to be very open with magistrates about what's happening, stingrays and other technologies that exploit security flaws give me the heebie-jeebies.
Yeah, I mean, I think the biggest problem I see with stingrays is the secrecy aspect, the fact that we don't know how they're used, how exactly they work, what different techniques are available, capabilities are there, and keyed in with the point Chris is making that the accountability measures that would be in place for other warranted, more standard surveillance methods are really non-existent here. I think tower dumps can also collect a lot of information about innocent non-target devices, but with stingrays it's mobile, right? They can move around and thus gather even more information about devices. It's just not clear what limitations are in place, and I think there's similar problems with the techniques, but I think that's the biggest issue with stingrays.
I generally concur, although, my concern generally is just for the third-party information. I think probably volume-wise, you get, and Chris would tell me if I'm wrong, you probably have a chance to get more on a cell tower dump because you're talking more towers and as opposed to one apparatus that's going around on a sort of micro level. But if you're the individual whose information's sort of swept up, I don't think it matters whether it's through a cell tower dump or a stingray.
I mean, in either case, you're not going to know.
Right. Unless it's posted on the internet, which is something possible, I guess.
So are there any questions? Yeah, just go up to the microphone on either end.
Hi, Jim Green. I have two questions about just the nature of how the tool is used, if we know this yet. The first goes to the applications that are made to the FCC, and just what the nature of those are, and particularly where they're directed, because if they go to say, the Office of Engineering and Technology, then it would probably suggest that it's an interference analysis versus if they go to the Office of General Counsel. And the other one is, do the more muscular stingrays that law enforcement uses and intelligence agencies use have the ability to dial into a specific IMEI or other unique identifier such that even if they can passively receive an enormous amount of information from discrete cell phones, the government could claim when we're passing signals through walls, we're looking for one specific phone and we're not really pinging everything.
So that's a complex question. I'd need to look, for the first one, I'd need to look at the letters that I got back. So I got these letters from local law enforcement agencies to the FCC asking for permission. I need to go and see, I think it was the General Counsel's office. Interestingly enough, I also found through Google searching a single request from a company in Fayetteville, North Carolina, requesting permission to use a Stingray, the Boeing device, and then a couple other similar ones. When I called the CEO of the company, who answered the phone, he told me that they wanted to train special forces in how to use the gear, and so they figured it was probably a good idea to get permission from the FCC, and the license was granted. And the guy who I spoke with said, you know, we're not the only ones doing training. We are the only ones who've applied for a license, but there are others who are purchasing these devices and using it for training and who aren't bothering to get licenses. In terms of how the devices work and whether they can send signals into a house that will only the particular phone in question will respond to, my understanding of how they work is that generally the tower sort of sends out a signal to everything in the area that says, hi, I'm an AT&T tower and I'm nearby. And then any AT&T phones in the area will respond and say, hi, I'm an AT&T phone, this is my serial number and I'm here. And so there's no way to send a signal into a house that says, if you are this serial number, please respond, everyone else don't bother responding. Just the way the protocol is designed, I think every device naturally responds. I don't think there's a way to do like a Go Fish, but a specific Go Fish for one phone.
Hi, I just have one small breadcrumb to contribute to this, which is that I was recently at a party, and there was an FBI agent at the party, and I said, so tell me
Great
about
party.
this. Yeah, I know. And so making small talk, I said, so tell me about this Stingray stuff. And he explained to me that it was his field office's policy to only use Stingrays to locate fugitives, because that way there was never the possibility that there would be a suppression motion filed.
You still get third-party information, though. But yeah, I mean, I was talking to someone about this. It's a probable cause standard to sign the stuff for fugitives, whether it's, you know, whatever the electronic surveillance is. But you can't come in as a fugitive that's been caught and say, I was wrongly surveilled and caught, I get a get out of jail free card. So like the agent said, I mean, it's sort of it's not going anywhere even if it's not up to the proper standard.
And one other point about the fugitive issue is there's an older FOIA document that I think generated one of the first news stories about triggerfish technology from, I believe it was 2007 or 2008, where within a different FOIA request, EFF received an email chain where a FBI field agent and tech officer was sort of complaining about the practice of the fugitive tracking groups and how they would come to the sort of tech agents requesting the use of the van, what they call refer to as the WIT van, because that's the group that sort of operates the van, and saying, well, these guys basically want to take the van and drive it all around town, aimlessly looking for these people. When we ask them questions, you know, do you know where this person lives? Do you know what areas they frequent? Have you done background research to figure out where they might be so we can narrow the scope of this? They get blank stares. So.
Hi, Alex Abdo from the ACLU. Just a quick question. I'm not an expert in the pen register statute, so forgive me if this is the answer to this question is obvious, but and this is perhaps to you, Judge Owsley, do judges have discretion when issuing pen register or orders to essentially impose minimization requirements on the extra information that Stingray acquisitions might acquire? And are you aware of any judges imposing those types of restrictions? And perhaps you too, Judge Smith, if you know.
I don't think they have it, because really a pen register is almost essentially a ministerial act. So there's very little discretion for a magistrate judge in a true pen register. Now, if you bring a wolf and you put sheep's clothing over it and you tell me it's a sheep and I realize that it's a wolf, I'm not going to say, oh, well, you can put that sheep with the others. I'm going to say no. So in that case, I think a magistrate judge is well within her or his position and authority to say this is not really a pen register and you can't have this based on this standard, because it's an extremely low standard.
That's a good segue into my question, which is, it would seem that pen registers can't be used for this, considering the prescription in CALEA against relying solely on a pen register for call location information. So why aren't they at least using hybrid orders? It's my first small question. Bigger comment question, first off, thanks for the great panel. This issue raises a sort of more fundamental, almost philosophical issue that was at the heart of the NSA case and sort of the substance issue that we may never get to, which is what counts as an interception? And what we've always argued in the NSA cases, or rather EFF, where I used to work, and they're still arguing it now, is that as soon as a communication goes into a device controlled by the government, that is an interception and that is a seizure of that communication. Paul Ohm wrote a great short piece on this called The Right to Delete, where as soon as you've been dispossessed of the right to dispose of your communication, that's when, that's the Fourth Amendment moment. Correct me if I'm wrong, but my understanding of the IMSI catcher is that regardless of whether, as Judge Owsley says, they flip a switch and convert it to audio that you can listen to, or whether or not they store the communication, all the call content in the area is going through that IMSI catcher. Am I right? Is that correct? I mean, isn't it like a man in the middle such that all the content is going through the device?
So the answer to Kevin's question is complex. So why don't you respond to the first part? You want to pass?
All
right, then let me
Go ahead.
Let me respond. All right, so the way that, if you're using a Stingray just to gather the serial numbers of the devices nearby, it's sort of it's a tower that breaks the rules. So the tower broadcasts and says, hi, I'm an AT&T tower, I'm available, and I have a really strong signal strength. And by the way, the phone doesn't detect the signal strength of the tower broadcasts its own signal strength as a value. And so the government's tower is like, I have a signal strength of 1 million. And AT&T's tower strength is like 50,000, and so the government's tower always wins. This is actually one of the features that the British company patented, this like lying about your signal strength. The government tower says, I'm an AT&T tower, I'm available, come use me. And then your phone's like, oh, cool, I'm an AT&T phone, please provide me with service. And then the government's tower, once it has your serial number, says, actually, I changed my mind, I don't want to provide you service. Okay. So they get your serial, they can triangulate your location because there's been a back and forth, there's been some communication, but they don't actually have to carry your service. And they can do that really quickly without causing any drop in coverage or even any change in display on the phone. The commercial IMSI catchers I've seen usually have some kind of upper limit of the number of devices that they can perform a man-in-the-middle attack on simultaneously, and it's somewhere in the ballpark of 5 to 10. So I'm not aware of any IMSI catchers that can do like 500 phones simultaneous interception, but they do all seem to advertise the ability to like canvass an area and get hundreds of serial numbers in a relatively short period of time.
What about the phones that they're doing full pen registers on?
So you mean,
where
they're passively...
If log who you're talking to, is the content of that call going...
If they're doing a pen register in... So sorry for those of you who this is way too complex for, but there are two ways to perform interception. There's active interception and passive surveillance. Active means the tower is actually pretending to be a phone tower. It's like it's sending out signals, and then there's also passive surveillance where it just like sniffs the signals. Depending on the quality of the encryption used by the network, they may be able to just passively monitor stuff and get the pen register without sending any signals out. Whether that is a true interception or pen register, I mean, every signal is going through their device. They're just not looking at the parts that have the communication, sort of like a TCP dump on your computer. Sorry, this is way too complex. It's complicated.
As to the first question, I think it's a little hard to parse because in the manuals or the training materials that I've seen, they discuss both cell site simulator technology and more traditional location tracking methods like historical records and real-time records. But they do have a point in there where they make the point that under the pen register statute and CLIA, as you mentioned, you can't gather location information. They indicate that a hybrid order is a thing that they know about. A lot of it's redacted, but it's not clear whether they're using those hybrid orders for stingrays. And to me, the problem with that would be that there's no stored communications in a traditional sense that you're accessing from a provider. So I don't think it's a good fit for them. But
I pretty much agree with that. I mean, I don't know that I have much to add.
I don't know if we're out of time.
Yeah, just for.
Okay, so
we've got a
I
couple
just
more
wanted to
questions.
highlight something that Chris had said in light of what Susan instructed us on this morning on the impact of the exclusionary rule, which is that as part of its systematic efforts to reconstruct the silver platter doctrine, the court in Lopez Mendoza told us that the exclusionary rule doesn't apply in immigration contexts because the threat of exclusion in a criminal trial is sufficient to deter law enforcement officers. But the Fourth Circuit, in a case called Oscar Torres, which is 18 months ago or so, held that it also doesn't apply in criminal context if the primary motive of law enforcement is immigration enforcement, which is sort of a silver platter doctrine upon a silver platter doctrine, which suggests that if ICE is using this technology, it's entirely beyond court review because there is no remedy available if the Fourth Circuit is right. But separately, I wanted to ask Chris if he could comment on a related technology that I don't quite understand, but I think is similar to a stingray, which is a technology that intercepts MAC addresses that are communicating with open, public wireless access points. And that's an important tool, I understand, for child exploitation and pornography prosecutions. And I just wanted to know whether it raises some of the similar issues that you've discussed with stingrays.
So the difference is that stingrays cost 60 grand, and even the tools required to build one yourself are $1,000 and require a significant amount of geeky expertise. What you're describing, so the tools that you would use to find, to sniff the network and find a particular MAC address on the Wi-Fi network, that software is built into every laptop. I mean, every laptop can do wireless sniffing. And it's built into Mac OS. The program, if you have a Mac laptop, is called TCP dump. You can run it on your own network lawfully, but not on anyone else's, as long as you're the only one on your network. I think it's difficult to compare those two things for the simple reason that wireless sniffing is taught in Computer Science 101, and everyone has the tools available. And you can readily encrypt your communications to at least stop people from intercepting the communications content, and you can change your MAC address at will, also with a command that's built into your laptop. You cannot change your phone's equivalent identifier easily, and in fact, some people have said that it should be illegal. That some phone companies have told the FCC they believe it is already illegal. And the tools to do interception are still not quite as easy as they are in the wireless space. So they're not the same.
So I think, do we have time for one more? Okay.
Since you're here partly in your role as principal technologist, I will ask you one other tech question. Chris, are there potential or actual tools being used? Are there sort of tech hackers and coders at work on ways of learning more about stingrays by observing them in the wild, as opposed to trying to get FOIA disclosures or cold calling CEOs?
So this is one of my favorite areas of emerging research. So an IMSI catcher is the device that is the generic stingray. For some reason, in Berlin, there's like this core group of cell phone hackers. For some reason, they're all in Berlin, and they do open source cell phone security research. So those guys have built an IMSI catcher that detects the presence of an IMSI catcher nearby. And they've built them using a $20 prepaid phone that they've modified. The same phone that Track Phone, the prepaid phone company, sells at 7-Eleven, they've modified this phone and use it to detect. So it turns out that even though a Stingray looks like a normal tower, it doesn't actually act like a normal tower. And if you know what you're looking for, it's so not like a regular tower, except that your phone isn't programmed to shout, hey, there's a Stingray nearby, run away. But so they've built some sophisticated software that looks for the signatures of a Stingray and then gives you different level of color warnings. So like green, yellow, and then red, run away, drop your phone and scream. So the IMSI catcher stuff is really interesting. A bit of unfortunate news. So there's this process called WASSNR, which is this international arms control agreement or arms traffic, or export control agreement. And the latest round of WASSNR negotiations includes expansions that would both prohibit the export of IMSI catchers, but also prohibit the export of technology to catch IMSI catchers. And I think that is really, really problematic. So basically what they're saying is they want to limit the ability of certain governments to have ready access to things that could detect US surveillance equipment or British surveillance equipment.
And it's not clear that using an IMSI catcher is kosher with the FCC, right?
I mean, you're passively monitoring highly regulated spectrum.
Right.
So probably not.
So, yeah.
That's good. I didn't hear an
All
answer
right.
to that.
Thank you so much. Thanks, this was a great panel, guys.
Hi, everybody. My name is Noah Shackman. I am a contributing editor at Wired Magazine, and I've got the honor of moderating our last set of panels. Because maybe after 7 hours of learning about all the different ways that you can be spied on from afar, you're not sufficiently freaked out and paranoid. I think our next set of guests will be able to take care of that for you. We're going to do 2 panels. First, to increase your paranoia and freaked outness, is about turning your body parts into tools for tracking you. And then we'll get to everybody's favorite topic, flying killer robots. First panel is on biometrics, sort of using your body and sometimes your behaviors to spot you, which may sound totally weird and totally some artifact, something new from the 21st century. But in fact, biometrics are at least 2,400 years old. Back in 3rd century BCE, Chinese used handprints and thumbprints to authenticate contracts and documents. In the modern era, in the 1870s, an employee of the British East India Company in Bengal used to use fingerprints to track his prisoners there. And then 15 years after that, and going halfway around the world in Buenos Aires, was the first case of using a fingerprint to help crack a murder case when a woman by the name of Francisca Rojas accused a man of killing her 2 small children. The man was promptly picked up by the authorities, tortured for a long period of time, and he still maintained his innocence, and so they went back and actually checked the crime scene again, found a bloody palm print, and it wound up being Mrs. Rojas herself who had the print and was charged with the murder. So that's the first documented case. Since then, biometrics have been expanded. In the last recent years, the US government has funded research into using biometrics, everything from earlobes to body odor as unique identifiers. They've learned to pick up biometric indicators from far, far away, and also track you by the data you upload to the cloud, which is itself a kind of biometric, which we'll hear about in a little bit. But the applications remain broadly the same as what they were back in ancient China and in Buenos Aires. It's what historians, I believe the term was invented here at Yale, it might have been Harvard, call the shaggy problem. It's after the famous god-awful Jamaican rapper who had a hit in 2001, It Wasn't Me. Sure, that guy looks like, that sure looks like my signature, but no, it wasn't me. There may be some guy using my ID card to get access to this building, but no, it wasn't me. And there may be a smoking gun and a dead guy in my apartment, but no, it wasn't me who killed him. All of which may seem benign, if a little creepy. But the problems come not when biometrics are, or not exclusively when biometrics are tools of crime solving or contract enforcement, but as a method to monitor your activities, or as a way to sell stuff to you and to only you. And so here to discuss the shaggy problem and all other aspects of biometrics, we've got an all-star panel. First, to my far right is Jennifer Lynch, who's a staff attorney at the EFF, working on government transparency and privacy. Who do we have after that? Travis. Hi, Travis. He's a PhD candidate in media, culture, and communications at NYU, studying the social cultural histories of identification practices, focusing on biometrics. Ralph Gross is a postdoctoral fellow at Carnegie Mellon, and he's the founding partner and chief scientist at Disruptive Robotics, LLC. Alvaro Bedoya is the Chief Counsel to the Senate Judiciary Subcommittee on Privacy Technology and the Law, and to its chairman, Senator Al Franken of Minnesota. And last but not least, we have Laura Donahue, who's a professor at law at Georgetown. So with that, I've asked Jennifer to sort of give an overview to get us started on various types of biometrics and some of the legal issues involved. So Jennifer, want to take it away?
Hi, thanks everybody for coming in. I also wanted to thank Margot and Heather again for organizing such a great conference. It's really been wonderful to hear everybody talk about location data this morning. And as a transition to biometrics, we thought we'd start off sort of like Chris did this morning, although much lower technical level, just to get everybody on the same page about talking about what biometrics are. So my talk is going to be split into two parts. The first part, I'll talk a little bit about what biometrics are and what some of the privacy issues are with biometrics. And then then everybody else is going to talk, and we're going to come back to me, and I'll talk about location data as biometrics, sort of a more out there aspect of biometrics. So to start us off, what's a biometric? Well, as Noah said, they're unique markers that identify us or that verify our identity, and they're based on our unique intrinsic physical and behavioral characteristics. And there's some examples up there. The most common are, of course, fingerprints, DNA, facial recognition, iris scans are being used pretty commonly now, and palm prints. And then sort of the more out there ones are gait, voice, or keystrokes, anything that can create a distinctive pattern. And they're really becoming a part of our daily lives. You can already use a fingerprint or your face to unlock your phone. You can use a fingerprint to get into some gyms. We're already, most of us, part of the largest facial recognition database in the world, and that's Facebook. If you're on Facebook or if your picture has ever been uploaded to Facebook, you're likely part of their facial recognition database. And also, most of us are probably in one of the many government biometric databases. So, for example, at least 31 states now use facial recognition for their DMVs. If you live in one of those states, your facial recognition ready photograph is in that database. The FBI has a database of over 100 million fingerprints. DHS has a database of about 130 million fingerprints. And the numbers are just increasing every year. And so to give you a little bit more information on sort of the technical aspects of biometrics, when somebody captures your biometric, whether it's your fingerprint or your photograph, it's not that photograph or that actual physical fingerprint that's going into a database. What's happening is that a computer is turning that into ones and zeros, it's turning that into electronic data, and that data is going into the database based on a set of standards that's developed by a standard-setting organization. That data may or may not be able to be shared with other databases. Travis is going to talk a lot more about that. So, biometrics raises its own privacy challenges. Sorry, I'm just making the fonts different between my notes, so it threw me off a bit. So biometrics, there are the three characteristics that make biometrics so useful, also make them problematic for privacy. That's that they're immutable. You can't usually change your fingerprint or your iris or your DNA like you could change a social security number or a driver's license number. They're readily accessible. We carry them around with us wherever we go. It's very easy for somebody to just say, give us your fingerprint. Very easy for us to leave behind a DNA sample wherever we go. And they're also individuating. The whole point of biometrics is that they distinguish us from other people. So some biometrics, like facial recognition and DNA, also present additional challenges for privacy because they can actually tell you more about a person than just their identity. This is a conversation that David Gray and I had at lunchtime about whether if you just have a DNA profile, how different is that from a fingerprint if you just have the amount of information that's extracted from DNA to identify you. But the problem is with a DNA sample and with a facial recognition photograph, you're not just getting that one piece of information that identifies you like a number. You're also getting, for example, with DNA, information on a person's family relationships, maybe on where their ancestors came from, their propensity for genetically transmitted diseases in the future. With facial recognition, you might also be getting, because you're getting a photograph of a person. If it's a crowd photo, you could get who that person is in the photograph with, who they're associating with. If the photograph shows how a person's dressed, you might learn about their religious beliefs or their political beliefs. So there's a lot more information that you can get from those types of biometric identifiers. The other big change in biometrics that's going on today is a move from immediate biometric identification to remote biometric identification. So immediate biometric identification is when you get arrested and you get booked and a law enforcement officer says, give us your fingerprint, give us your DNA. That's used immediately in the case of fingerprints to run a scan to see if you are the person who you say you are. So that's immediate identification. Remote biometric identification has now become possible with some of the more modern surveillance technologies where you can capture somebody's biometric ID from far away. There are now telescopes that can capture an iris scan from about 1,000 meters. So the problem with that is that you don't know when your biometric is being collected. You have no control over that. You have no knowledge if you're ending up in a database. And it can also happen on an ongoing and continuous manner. So it raises a lot of the issues that we've been talking about with location data collection, but moving into the biometric context.
Yeah.
All right, let me pull up my my PowerPoint. Okay, so this stuff, the stuff that I'm going to be talking about today is based off of research that was made possible through through a Presidio Muri grant and with support from the National Day Laborers Organization Network, Cardozo Immigration Law Clinic, Justice Clinic, and the Center for Constitutional Rights. Of course, all credit is theirs, all mistakes are mine. And I want to talk about interoperability between federal biometric databases and immigration reform, because I'm going to be talking specifically about the FBI and the Department of Homeland Security's Secure Communities program. Really quick, here we go. So right now, this is the desired end state. This is taken from the DoD's financial year 2011 report. Right now, the DoD and the DHS don't actually talk to each other. They talk through the DOJ. They've become interoperable, but they don't really talk to each other. But what they really want is they want to have the biometric templates, which is what Jen was talking about. So not the fingerprint, not the images of the fingerprint themselves, not the images of the pictures, but the zeros and ones to all actually match up, and so that they can search each other's databases. The US right now has a federated system. We don't have a single biometrics database. We have multiple, and it gets really complicated when you get down onto the lower level. Individual states have their own fingerprint databases. Certain times regions have their own databases. But at the federal level, there's really 4 main databases, with the Department of State not really being a part of this, and also national intelligence agencies having something like that. But what they're really working towards, and this is something that's happened primarily post-September 11th with all the mandates towards information sharing, is that all 3 of these databases talk to each other and can be searched by one another. And so one of the main programs that's come out of this is between the Department of Justice and the DHS, between the IAFIS system, which is now becoming the FBI's next generation identification database, or NGI, and IDENT. And what they've called this program is Secure Communities. So essentially what happens is when somebody's arrested by a local law enforcement agent, the fingerprints are taken and then sent to the FBI for a background check. That's all well and good, has been happening for quite some time. What happens now is it also gets pinged over to Department of Homeland Security. Department of Homeland Security checks the fingerprint against their database, and if there's a match of somebody who has overstayed their visa, is somehow in IDENT in a way that is not shouldn't be there, or conversely, if they're on a visa that would be invalidated by the person having been arrested. They send a message down to their local ICE agents. The ICE agents then can send over a detainer request to the local law enforcement agency to say, hey, hold on to these people, please, so that we can go over and interview them, see if we need to deport them, et cetera. So in their own words, secure communities, according to the DHS, is all about focusing limited resources and using it to get rid of people who are charged with serious criminal offenses and prioritize enforcement actions for aliens convicted of serious criminal offenses. So they're saying, we want to go after the worst of the worst. Right now, we don't have enough money to really deport everybody that's here illegally. But we want to just go after those people who are here, who are also criminals. And at this point, the secure communities has been activated in 97% of the jurisdictions. Now, there's been a little bit of pushback and a little bit of fuzziness about what the program is. Because initially, they went to these jurisdictions and they said, hey, we want you to opt in. And please let me know if I'm going to start going over time. We want you to opt in. This is going to be a great program. It's going to help everybody out. And you can opt out at any time, and it'll be great. Then once they started getting going, they said, you know what? And a couple of jurisdictions, particularly Illinois and Boston, said, you know what? We actually don't like this anymore. We want to opt out. They reversed their ruling and said, you know what? You can't opt out. I'm sorry, but this is happening. Go with it. And their reasoning was they basically changed the definition of the program. So initially, when the program was being sold, it was being sold as the interoperability. Right? It was being sold as secure communities is the sharing of information between the FBI and the Department of Homeland Security. And then when they said, okay, no, you can't opt out, what they said was interoperability is its own thing. It's mandated by Congress. Once you give information to the federal government, you have no say over what happens with that information. So there are memoranda of understanding between the local jurisdictions and the FBI about what could be done with the data. They basically said those are invalid because once you give it to the feds, we can do whatever we want with it, which means we can share it with the Department of Homeland Security. And so secure communities, basically, they said what it is the means by which the Department of Homeland Security lets the local law enforcement agents know that they want to do something. So even though they say right here that 97% of the jurisdictions are activated on secure communities, with their new definition, only 13 states are. Only 13 states are actually set up to get the emails that say, hey, you have somebody in custody that we want to hold on to. Right. And so here's some of the statistics about this. So you have level 1 offenders, which are felons, level 2 and level 3, and then non-criminal immigration violators. And I'm not going to go too deep into this. I just want to point out that in each of these cases, the non-criminal immigration violators are almost as many, if not more, in each case than the level 1 offenders. And so the level 1 offenders are the ones that they keep on talking about. They're the ones that they're selling the program on. But ultimately, the people who are level 3 offenders or non-criminal immigration violators are the ones who are just as much being caught up in this program. So if you get caught if you get arrested, and ultimately don't get convicted, your information is still being sent over to the Department of Homeland Security. You're still being caught up in the immigration system. And this is even worse with the advent of mobile biometrics. So with mobile biometrics, increasingly local law enforcement agents, the DOD, the DOJ have this already. They have mobile scanners that can do facial recognition, iris scanning, and fingerprint recognition. And they can do that in the field. So if they do a traffic stop, if they're not satisfied with the identification that's being given, or if the identification is not being given, they can then fingerprint the person on the spot. And right now, at this point, the FBI has mobile devices that can search IAFIS and ident. And at this point, local law enforcement agencies have access to a particular set of fingerprints, including the immigration violators file, which are 300,000 people with actionable records of convicted criminal aliens who have been deported for drug trafficking, firearms, serious crimes, or foreign-born individuals who have violated some section of the INA. So basically, anyone who has any kind of record with the Department of Homeland Security of somehow like tripping up on immigration law can be scanned and can have their fingerprints checked against ident, or checked against that in the field. So what's the problem with this? The problem, there's a couple of different issues, and I'm not a lawyer, so I can't really get too much into the nitty-gritty of what might be problematic, but ultimately you have information that's being given up to a local agency and ultimately to a federal agency for a specific criminal purpose that's then being used for civil enforcement. And you also have, at the same time, you have a people who are being exposed to the ambiguities of being sucked into the immigration system. And when you're under suspicion in the immigration system, it's not good, right? Statuses, I mean, this is something that I learned, is just simply immigration status is not something that's set. It's something that's oftentimes fuzzy. And especially if you have a visa status that's dependent on you not being a criminal, you being arrested then makes that really, really fuzzy. Right? So the major danger with this is people being sucked into this fuzzy situation. There's a case of one guy who got pulled over because his boss's truck, he was here legally on a visiting workers pass, got pulled over because his boss's truck's license was, registration was expired. He got pulled in, it took a month to process, and by the time that month has gotten up, he was deported because his visa had expired. So there are real dangers and real harms with this that are potential. And so I want to talk really, really quick about where this kind of comes from and where the potential for this is. And so I did this work primarily with a group of immigration rights activists, and they were all very much against secure communities. But they're also very much for the DREAM Act and for immigration reform. Which is great, right? The DREAM Act, yay! Kids, should be able to be here legally if they have done what they should. So, but the DREAM Act, there's a couple of different requirements. You have to be enter the United States before the age 16. You must have been present in the United States for at least 5 consecutive years. You have to have graduated from high school or obtained a GED, and you must have good moral character, which means you can't have violated any laws. You have to give up your biometrics. You have to go through a background check. You have to get registered into this system. Similarly, immigration reform calls for creating a provisional legal status that means that you submit biometric data, you pass criminal background and national security checks, and it calls for the deportation of criminals, which means the secure communities. So, with the institution of progressive reforms, what you have is you have an entrenchment of these surveillance tools, because in order to say we want to keep the good guys, we want to keep the good immigrants, you have to be able to identify who they are, and in doing so, you have to then create the distinction between the bad immigrants. And really quick, one of the ways in which modern identification was started with anthropometry and things like that were created out of progressive reforms in the 1800s. So this is like an old story where they said, we want to stop, we don't want to just punish a crime. We don't want to like cut off people's hands because they're a thief. What we want to do is we want to say, if you're a first-time offender, we want to let go easy on you. So, but you have to identify who the first-time offenders are and separate them from the people who are the recidivists. And that's where modern penal identification started, is they started doing that, and then they were like, oh my gosh, we have so many recidivists. We've got a mountain of recidivists, but it's just because they never counted them before, right? But initially, the plan was to say, we want to actually go lenient. And so with the DREAM Act, with immigration reform, in order to go lenient on people who are, quote unquote, like the good guys, you have to actually have surveillance to figure out who is and who is not.
Great, thanks. If you can pass the keyboard over to Laura.
Your mouse there.
Yeah, here we go.
There we go.
Can you do? I can't see.
Sure, let me see if I can do it. Is it on the desktop?
Yeah, it's on the right.
Yep. Is it this one?
Yes.
Very nice. You are awesome.
How do you get the full screen?
Just hit slideshow. I'll do it.
Is the next one over?
There you
All right, so what I'd like to address today are three things. First, I'd like to mention that we really have had a technological leap forward in the biometrics realm. Second, I'd like to point out that there's a statutory gap in terms of actually having legislation address this particular area, something that Chief Judge Kaczynski, amongst others, has pointed out from the bench as well. And third, I'd like to note that our jurisprudence, both for the Fourth Amendment as well as for the Fifth Amendment and First Amendment as well, and Fifth and 14th due process, really fail to contemplate the types of challenges raised by biometric identification systems. So I'll begin with the first, which is the technological leap that we've seen in this particular area. I'm not sure we're going to discuss today the commercial realm, but I do want to just begin by noting that biometrics is not a problem unique to the federal government in terms of its use. For instance, right now, Kraft Foods is rumored to be in talks with Facebook so that when you walk into the grocery store, you will pass a kiosk that will identify who you are, go to your Facebook account, and then market to you, advertise food that might be appropriate. For instance, if you have children ages 10 and 8, ways you could spice up dinner with mac and cheese tonight, kind of a thing. In bars in Chicago, there are actual bars where they have facial recognition technologies where you can see how many men or women are at the bar and can go to the bar depending on which bar you'd like to attend. In Las Vegas, there is a bulletin board outside one of the hotels where as you walk past, they look at your age and gender, and they market to you products that they think would actually fit, and race as well, and they market products to you that they think would actually fit. So there is a bigger issue out there. When I took a look at the patents for this, between 1970 and 1995, there were fewer than 10 patents issued in this area. Between 95 and 2000, there were 20. We have seen an explosion of patents in the realm of biometric technologies, 633 between 2001 and 2011. Now, for what I'm particularly interested in, the key sectors that we're seeing growth in are not just commercial sectors, but particularly law enforcement and national security. And this is where we're seeing an unusually high number of patents being granted compared to what has come previously. So what does this mean? Well, there are basically four trends that are going on right now at a federal level with regard to use of biometrics. First is we're seeing a move to what's called multimodal biometrics, which means we're not just doing fingerprint technologies, but we're pairing fingerprint with iris scans, with DNA, for instance, with other biometric data that might be there. Second is we're seeing the pairing of biographic information with biometric information. So it's not just your fingerprint in a database, but it's also your telephone number, your social security number, your children, where you live, where you went to school, your neighbors, your social network sites. All this information is being put together into one place. The third trend we're seeing is interoperable databases. And we've just heard about one of these interoperable initiatives, but there are numerous interoperable initiatives across government so that everybody from the first responders, on the ground law enforcement, through the Department of Defense is now gaining access to similar databases. And fourth, in light of this trend, we're seeing a collapse between law enforcement and national security and homeland security as rationales for these databases. So the databases are expanding to include all three elements. And we're seeing really a blurring of the lines between these particular areas, which matters because the court's jurisprudence in many ways is built on maintaining these distinctions between these areas themselves. So I'd like to just give you one example for a deep dive, and I'm going to start with the FBI. This is actually a slide presentation that was given by the Bureau, available online. And as you see, when they're considering, this was from 2009, and they have moved particularly in this direction, multimodal biometrics is one of the key areas that they see as important for the future. In fact, this push for multimodal identification is seen as important for them to be able to carry out their law enforcement function, and this in turn drives the need for interoperable databases because you can't come up with multiple biometric data points unless you're making use of multiple inputs into that biometric database itself. In this case, the FBI is looking at fusing what is considered context and identity information, and they use as an example 2 political rallies. I'm surprised they're not on a soapbox in a public park, knowing First Amendment jurisprudence, but there you have it. We have 2 political rallies, and the idea is that you can identify individuals present at 2 different political rallies based on facial recognition technologies. Now, the FBI is looking at building these biometric abilities and making them interoperable with DHS, with DoD, and with other agencies in the federal government. They see this as critical to accomplishing their 3 missions. This is criminal law, so the law enforcement mission, the domestic preparedness, homeland security side of it, really, and counterterrorism missions. And because the Bureau has all 3 missions, they want one tool that's going to do all 3 things for them. Well, let's take a quick look at what some of these are. This is just an example of some of the databases that have currently been stood up, and I'd like to spend just a moment on what's called next generation identification. This program is actually 7 different programs within NGI itself. The first one, as I've listed up here on the slide, is called AFIT, which is the Advanced Fingerprint Identification Technology Program. What's interesting about this is it actually includes not just fingerprints, but automated facial recognition technologies. It includes biographic data and other indicators like telephone numbers, email accounts, and so on. It also includes a database called RISC, or the Repository for Individuals of Special Concern. Okay, what is RISC? Well, according to the FBI, it includes KSTs, which are known and suspected terrorists, as well as, quote, other persons of special interest. This is not defined anywhere, and attempts to get that information through FOIA have not been successful. It also includes both domestic and foreign data. So in addition to AFIT, the second program is called WrapBack. Now, this is a service that the FBI will provide to an employer where they collect your biometric identification. They give it to it's given to the FBI, and then if you appear at any civil or criminal, in any civil or criminal context, they will notify your employer that you were present at that activity, or that you, for instance, received a ticket, or that you are a suspect in a case, and they explicitly include civil activities. So if you're present at a political rally, for instance, it's entirely within the guidelines of this program that could be reported back to your employer. The third program is called the Disposition Reporting Improvements. Then there's a national palm print, that's the 5th. There's an enhanced IAFIS repository, which allows for single identity management of biometric data. There's an iris recognition program, that's the 6th. And the 7th is called the Interstate Photo System, which previously you might be able to have your mugshot, for instance, in this database, but this has actually been changed in very important ways. First, it now allows for bulk transfer of photographs into this system. So you can load numerous photographs into it at a time. Second, it draws data from publicly available sources as well as privately held sources. So it can load information from social network sites, it can load information from friends and colleagues, it can load information from your company, it can load all of this, and it now has video technologies attached to it. So this means that CCTV footage can be fed into it, any videos found online. The technologies are being built into the system now to include all this information. Okay, now why this matters to me is something that I call immediate biometric identification versus this remote biometric identification. And I'd like to just highlight 5 ways that these are fundamentally different. And so far, the courts have really grappled with immediate biometric identification, which is where you have a case, a single individual is presented, generally close up, 0 feet to 3 feet away, or sorry, 0 to 3 inches away, that's right, because you have to actually take the iris scans, although now we can do, of course, remote iris scans. You're in custodial detention, or you're actually trying to gain access to a government facility, for instance. There's often notice and consent, although not always, but often notice and consent are involved, and they tend to be a one-time or a limited occurrence. Now, in contrast, what the technology now allows us to do with facial recognition and distance iris scanning, these other modalities, gait technologies, hormone sniffing, vascular patterns, all these technologies that are being explored right now in biometrics, is that you can scan multiple people. And you can do it at a distance, at a great distance, in public space, without notice and consent. You may be completely unaware that this is happening, and in a continuing and ongoing manner, a continuous and ongoing manner. And I would argue that this is just fundamentally different than the way we have conceived of biometrics previously. And these new technologies really open Pandora's box in terms of privacy concerns, First Amendment concerns, and I think there are also some Fifth and 14th Amendment due process issues, although I think those will be eventually resolved. What is clear is that at this point, on the statutory side, we have yet to grapple with those technologies. Specifically, on the one hand, we have broad authority to obtain personally identifiable information. And I won't go through all of these. I've written a law review article, it just came out in Minnesota Law Review, actually about a month ago, that goes into great detail on all of these statutes and really carefully goes through to see how they apply or not to biometrics. But on the one hand, we can collect personally identifiable information, yet the statutes which are meant to protect privacy for PII have carve-outs for national security, specific carve-outs for national security. So the Privacy Act and the SORNs, for instance, don't cover broad video surveillance. They do not apply to state and local government records. Law enforcement, national security, and classified information is explicitly exempted in these statutes. It only applies to U.S. citizens and companies, and the CIA, for instance, has a broad exemption applied to all agency records themselves. The Electronic Government Act of 2002 and the privacy, the PIAs, which are expected to be issued, also suspend reporting requirements for law enforcement purposes and for national security purposes. If you turn to Title III, that's specifically in the criminal law realm, that applies to wire and oral communications. In 1996, we had ECPA come along, and there it only applies to oral and not video transfer itself. This is specifically where Chief Judge Kaczynski has actually referred in his opinions to the failure of ECPA to address this, suggesting that actually this is a purposeful omission, and we shouldn't read ECPA broadly to apply to biometrics, or in this case, sorry, to audio transfer of video recording itself, that we shouldn't read it to apply to those particular situations. The circuits are split, by the way, on this, on what they should do about it, but I think that is the right opinion in this particular case. Finally, the constitutional abyss, and I'll end with this. If we look at our Fourth Amendment doctrine itself, the Jones case being the most recent example, which was decided, of course, on grounds of trespass, as was discussed this morning, it doesn't take account of the types of technologies that we're discussing, with the possible exception of iris scans, where you could argue that there's been a penetration of the body for the scan of the iris itself. For facial recognition technologies, gait technologies, hormone sniffing, vascular patterns, these other types of biometrics, it doesn't fall within Jones. Now, you could read Jones with a shadow majority to say that, in fact, when you can learn that much information in an ongoing manner about individuals, the court might be ready to move its understanding of privacy. But you have a good deal of jurisprudence cutting against this, particularly the distinction between public space and private space. So Serralo, the cases where they're looking from up above the homes, Kylo, for instance, these other cases, it would be I think it's a hard argument to make under existing jurisprudence. There's also this national security versus criminal law distinction in the jurisprudence, where you have these cases now coming forward that blur these distinctions, and so many of these tests that have been set up are not relevant to this particular issue. Now, it is possible that you could, the Fifth Amendment, I want to touch very briefly on the Fifth Amendment issue of self-incrimination. That tends to apply to situations where individuals are prevented from actually acting or being forced to act in a certain manner. And it doesn't fit with the biometric concept of when you enter into public space, there's a sort of citizen beware. At this point, you are under surveillance as long as you are in public space. It's not that you are being forced to take a particular action itself. The First Amendment questions of speech and assembly. If these are being gathered, if this information is being assumed for national security purposes, this fits a fairly rigorous test that one could adopt under the First Amendment. And finally, for Fifth and 14th Amendment due process, the more accurate this technology becomes, I think that your argument in this particular area falls. And so the conclusion that I've reached, and I'd actually be interested to hear what's happening in Congress, is it's actually an issue that Congress really needs to step up to the plate, because this is a new new type of technology. We're no longer dealing with immediate biometric identification. We're dealing with something called remote biometric identification, where anybody in public space can be surveyed indefinitely with that information kept. The agencies are already taking advantage of this. They're making this interoperable, and we have few, if any, restrictions on the way in which this information is being stored, kept, shared, and ultimately used. Thanks.
Thanks, Laura.
So my main introduction to this, actually, before I begin, let me just clarify, I am speaking in a personal capacity. The opinions I'm about to give are my own. They're not those of my boss or anyone else in the Senate. I want to make 3 points. Number one, that the future is now for facial recognition. Number two, that this is a big deal. And 3, if I have time, that the phone booth door is very much open with facial recognition. So the future is now. You know, a lot of people think of facial recognition as something out of Minority Report. And I think, as is clear from the presentations today, facial recognition is not something from some, weird dystopian distant future. It's happening around us right now. I'll bet that almost every single person in this room has a driver's license, a passport, and a Facebook account. And if you have those 3 things, you are definitely part of one and are probably part of 3 different facial recognition databases. And what I'd like to do to give you an idea of how pervasive this technology is take a deep dive into Facebook. So in late 2010, Facebook rolled out its Tag Suggestions program. Now, to the external observer, all this program did was the following. Let's say I took a bunch of photos of this conference, I uploaded them. In early 2010, I actually had to go through all my 20 photos and say, click, that's Noah, click, that's Noah, click, that's Noah. And Facebook thought this was really annoying. And so what they did was automate that process. And when Tag Suggestions is active, and it is right now and everywhere except for Europe, you upload these photos and it says, hey, aren't these guys Noah? And then you say yes, or you say no. And Noah is identified very easily in your photos. What's occurring in the back end is that Facebook has made a face print for you. And it is using, every time a close friend of yours, not anyone, a close friend of yours uploads a photo, Facebook scans those photos for your face prints, and then it says, hey, that's you. Now, Facebook didn't just roll out any old facial recognition database. Facebook actually rolled out what is likely the largest and most accurate facial recognition database in private hands. Why do I say that? At the time of its rollout, Facebook had 845 million members. It was rolled out on an opt-out basis, and it activated for anyone who had more than a handful of photos tagged. And the average person actually has 53 photos. Women have a little more, guys have a little less, average is 53. Now, assuming a 60% non-participation rate, total number of people who either don't have enough photos or opted out of the program, assuming a 60% non-participation rate, Facebook would have a face print for 1 out of every 20 people on the planet. Assuming a 20% non-participation or opt-out rate, Facebook would have a face print for 1 out of every 10 people on the planet. Why most accurate? Every single time you say, no, that's not Noah, that's someone else, the algorithm is improved. And so in a very funny sense, Facebook has crowdsourced the refinement of its facial recognition database, which happens to be probably the largest in private hands. So, a lot of people think, okay, Facebook has my face print, so what, who cares? This is a big deal. Why? First of all, government can get this data. And why would government want this data? Well, this is not a random sampling of people. The 1 out of every 10 or 1 out of every 20 people in the world who are part of this database happen to be young, happen to be connected to the internet, happen to have enough money to have a computer and an internet connection. These are interesting people, and they are people that I would say either the American or a foreign government would want to know more about. And I want to cut away to something wonderful that Laura pointed out, which was that slide from the FBI. Okay, those political rallies weren't just any political rallies. Those were Obama and Clinton rallies.
And in a hearing which we held at the Senate Judiciary Subcommittee on Privacy, Senator Franken asked Jerome Pender of the FBI, hey, I'm worried that there's going to be a chilling effect on speech. And Mr. Pender said, well, don't worry, because you can only use this for a criminal justice purpose. The problem is, in all of the states where the facial recognition pilot has been rolled out, it is technically a crime to do things like block a sidewalk or crowd the entrance to a federal building, the kind of thing that occurs naturally in a peaceful protest. But you don't need to go all the way to the government to cause trouble and to cause some kind of harm here. And because there are definitely scenarios in which there's misuse by Facebook itself or a person to another person, peer-to-peer. A lot of people say, hey, who cares? Facebook has my faceprint. I trust Facebook. That's not the question. The question is, do you trust Facebook 5, 10, or 15 years from now? Because a faceprint stays roughly the same between age 20 and age 50. And so during this hearing, Senator Franken actually asked Rob Sherman, manager of privacy and public policy at Facebook, hey, can you promise that you won't sell this data to third parties? And this is verbatim, not the entirety of Mr. Sherman's response, but this was the initial response. Quote, it's difficult to know in the future what Facebook will look like 5 or 10 years down the road, and so it is difficult to respond to that hypothetical. Finally, there are scenarios in which there are real person-to-person harms. Now, a lot of people might say, what does that mean? This technology is coming to the street and already has come to the street. In early 2010, the Israeli company Face.com rolled out the first commercial-grade, high-grade facial recognition app. It was called the Click app. As soon as it came out, an independent researcher who many of us know, Ashkan Soltani, hacked it and figured out that you could basically use it to download the face prints of anyone on Facebook. And thus effectively use it as a universal person identifier on the street. And mind you, this was a company, this wasn't a back alley company, this was a major company that took itself very seriously and in fact prided itself on its privacy protections. And it was hacked almost immediately. So the final thing I want to say is that the phone booth door is open. And what I mean by that, Laura has actually covered for the most part. Judge Kaczynski wonderfully highlighted that even in Katz, it was important that that phone booth door was closed. Because even in Katz, the court said, hey, you have a privacy in that phone booth, but not in what you knowingly expose to the public. You can't open the phone booth door, yell out your conversation, and say, hey, that was a private conversation. Every single time you walk outside, you knowingly expose your face to the public. And so constitutionally, this is a gray area at best. The final gloss I will say is Laura's analysis went through step by step the constitutional provisions, and those primarily obviously govern the person-government relationship, the Fourth Amendment relationship. Commercially, there is no law that expressly regulates this space. So if you think it's bad in Constitution, in the constitutional arena, it is even more empty and in the commercial arena. And that's it.
Great, thanks. Ralph? Oh.
Okay. So I'm going to talk about a series of experiments that we did at Carnegie Mellon University a couple of years ago, where we looked at the converging of a number of technology trends, namely, on one hand, the increasing public self-disclosure of people on online social networks, most notably the photos that they upload, continuing improvements in the face recognizer accuracy, which, if you look at government evaluations of the technology, we've seen that since 1993, the error rates of face recognizers decreased by a factor of 272. So it's a massive improvement in capability. Cloud computing, ubiquitous computing in the form of smartphones that we all carry around, and statistical re-identification. And we put this all together in a number of experiments where we took publicly available data from online social networks. We took off-the-shelf face recognition technology, and we put the two together using Amazon Cloud instances for the purpose of large-scale, automated, real-time, peer-based re-identification. We did that both using online and offline data, and we took a step further in order to use it to infer sensitive personal data. So what we did in practice was download a bunch of images from a dating website, download a bunch of images from Facebook, and put those two together using a face recognizer produced by a company called PitPat in order to re-identify people on the dating website where usually you use, you're not using your real name. Whereas on Facebook, you do use your real name. In fact, Facebook really wants you to use your real name and will punish you if you don't. And we put the two together in order to evaluate if we can use face recognition in order to re-identify people. And in the experiments that we ran on a data set that was collected in the Pittsburgh area, we found we were able to re-identify 1 out of 10 members of the dating website, which is a fairly large number. In the second experiment, we took that to the offline world in the sense that we set up a cheap web camera on CMU campus, and we asked students to participate in a little study for a few minutes where we recorded 3 images of them. And then we used the same process, uploading it to the cloud, running the face recognizer, and comparing it against Facebook images. And in the experiment here, we were able to identify 1 out of 3 subjects. One of the interesting anecdotes that came about was that one of the subjects told us beforehand, "You're not going to find me," because the main profile image that I have on my Facebook profile only shows half of my face. The top of my head is covered by a baseball cap. "You're not going to find me." Well, we did find him because one of his friends uploaded an image of him in which he was tagged, which created some surprise on the subject side. And in the final, so what I've showed so far is that we can take image data either from the real world or from online sources. We use a face recognizer, and we can link you to a Facebook profile. Now, in work that we've done in 2009, we took information that is often disclosed on Facebook profiles, which is your date of birth and your hometown or your likely place of birth. We combined that with a model of how Social Security numbers used to be assigned. By now, in 2011, the Social Security Administration actually changed the algorithm and randomized it, but at the time that our paper came out, that was still the old algorithm. So we took these two together, and we were able to predict your Social Security number based on date of birth and place of birth. So then the natural question is, well, can we combine these two? So can I take an image of your face? Can I link that to a Facebook profile? Can I extract from that Facebook profile your date of birth and place of birth if available, or at least extract your real name and then search other databases for this information in order to predict your Social Security number? And in the experiment that we conducted, we were able, for 27% of the subjects that participated, we were able to guess the first 5 digits of the Social Security number within 4 attempts, meaning that we got, our algorithm is probabilistic and it returns, likely matches. If we take the top 4 of them, for 27% of the subjects, we were able to guess that correctly. So, we can go from a face and we can end up with a Social Security number. And this really highlights a process that has been made possible through the advance of technology that you could refer to as data accretion. So you start up with an anonymous face. You use a database of face images from Facebook, LinkedIn, organizational roster, and use face recognition in order to find the name for that anonymous face. And once you have the name, you can query other sources of information and infer, in the case that we showed in our experiment, sensitive information in the form of the Social Security number. And you link that back to the originally anonymous face. We took that even one step further in order to show that you could do that in real time by building a smartphone app that essentially does the same thing, which is you would hold it up to a person's face. You take an image, it's uploaded to the cloud, it runs the face recognizer, finds the Facebook profile, and on and on and on, and returns a likely estimate of the Social Security number. So the implications that we think this research has is that we see the beginning of face being your face being a conduit between online and offline data. Previously, this is a lot more separated than it is now. You could see that as the emergence of what we call personally predictable information. So in the case of the Social Security number, this is clearly a very sensitive piece of information that no matter how much effort you put into trying to protect it, if I can predict it from information that's publicly available, there's nothing you can do. I can still predict it. We see that as a potential start of visual facial searches. So if we go back to the example that was brought up before in taking images of crowds, if these images are stored, there's no requirement that I do that search in real time, right? I can go back half a year later and run that search, or I can go back a year later and run that search. And so, your face is the key that potentially holds together a whole bunch of different databases. We've shown that, if you give that tools into the hand of people, you could do that kind of like in a peer-to-peer basis, running it from your own smartphone. And it really raises the question of, are your social networking profiles now becoming your real ID that everybody subscribes to? Now, let me conclude with a few limitations. So, I think we're not quite there yet where everybody has to run out and buy their own, Guy Fawkes masks in order to protect themselves while being on the street. So, while technology has improved tremendously, you can't do the same experiments or the same searches that we've shown on like a national scale right now. But we think we're not far from that. So, there are still technical limitations. There's also the question of how do you get access to these face images. And, computational costs, while, decreasing are still a factor. However, there's the strong suggestion that all of these limitations are going to disappear rather quickly. And so, we have to really ask ourselves, what type of application are we comfortable with of this technology and all of that data that enables it.
Wow, it's really interesting. Thanks, Ralph. I'm going to open it up to questions, but I'll take moderator's prerogative and ask the first one.
Do you want to?
Oh.
I was going to give my talk.
Oh, yeah. Oh, my gosh. I'm sorry.
That's okay.
Yeah.
I'll try.
I got so fired up by Ralph's talk.
Let me see if I can find it. I can't actually read it. Can you see? Is there Jennifer Lynch?
There are two.
Yeah.
Go one up.
Is that one?
No, that's not it. Go one up. This is EFF 2013.
Does it say part 2 or part 1?
Overview.
Okay. And that one?
Part 2.
Okay. Is that the slide? Okay. Okay, so this is the second part of my talk, and I'll try and move through it relatively quickly so that we can get to questions, because I'm sure you're all getting a little tired of sitting in your seats. So I wanted to talk about this crazy concept of location data as biometric. This came out of a conversation I had with a guy named Jeff Jonas. Some of you may know him. He's a chief scientist at IBM. He's one of those guys who just thinks about crazy stuff. He's also done a lot of work on facial recognition. developing technologies for the gaming industry to identify card sharks. And so Jeff and I and Chris Calabrese from the ACLU gave a talk about a year ago about database interoperability and biometrics. And Jeff said, hey, how about location data as biometric? And I said, well, that's kind of crazy. What do you mean? And he said, well, here's what we have. You can't have the same thing in two places at the same time, and you can't have two different things in the same place at the same time. And that makes location data into biometric data, because our location, our pathway through our life, is distinct to ourselves. Nobody else travels that path. And even with the variations in our path, that path is still distinctive. You can cancel out the variations as just noise. And so I have a few examples of this. Before we get to that, so this is some of what we've covered this morning about how much data that we get from cell phones. Of course, cell phones are location tracking devices just on their own. And then as I think it was Ed was talking about this morning, all of the technologies that are on our cell phones, all the different apps that we use on our cell phones also generate their own location data that they're selling to third parties. The data is being de-identified, but it's questionable whether it's actually possible to de-identify location data, as I'll talk about a little bit further as we move along. And your movement, your pathway through your life, it reveals where you spend your time, when you're in a certain place, and who you're there with. And it reveals what's typical about your pathway through life, and it also reveals what's not typical. So maybe you're traveling the same way, you're going to work every day and you're coming home, and then one day you travel a different path and you go to someplace different. Maybe you go to the lesbian bar, as Scylla was mentioning this morning, or you go to the abortion clinic, or you go to meet an associate who's a known criminal. That creates a difference that can alert people to distinctions in your path. So this is the cell towers. We've talked about the accuracy of cell tower data. This is all the towers within a 4-mile radius of Yale Law School. You can see there are 74 of them, 529 antennas. There's actually one application for a new tower here. So this can get pretty granular in the data. So what can you get from this data? Well, this is a guy named Malte Spitz. He is was a German Green Party politician, and under German data protection laws, he sued his telecommunications provider for access to his cell phone records. And when he finally settled his lawsuit before they deleted all of the data under German data protection laws, he got access to 6 months of cell phone records. That was every ping that his cell phone ever made, every number that he dialed, every text message he ever sent during that 6-month period. It resulted in 35,000 call data records. He gave that information to a German newspaper, and that newspaper plotted his path throughout those 6 months. And you can actually go to this website and you can follow where he goes throughout his day. It's pretty great. And the other thing that the German newspaper did was they took all of the publicly available data about Malte, and this included like his tweets, his speaking engagements, a lot of information from Facebook, and they combined that all, and so you can see where he was on any given day and also what happened at that time. So I think Malte's path through life is probably less distinctive to him than some of us, because he probably does a lot more traveling as a politician. But here's another guy. This is Aaron Parecki, and he is the CEO of a company called GeoLoki. It's a data tracking application you can download for your iPhone. This guy loves geolocation data. He's tracked himself with his own software, and he's generated 2.5 million data points over 3.5 years. And this is what he says about the data. He says, this is a data portrait of my life, everywhere I've been and the places I've been most frequently. The map is colored by year, so you can see how my footprint changes over the years depending on where I live. But if you look at the map, I'm going to try and use my handy little laser pointer here. This is that I got from Morpho, which is Biometrics company, so I thought it was appropriate. If you look right here, and then it's enlarged over here, this is where he frequents in Portland. So you've got outliers like sometime over the time period he went out over here. But for the most part, he is right here in Portland. It doesn't matter that maybe he moved in this year. He's really just hanging out right here in Portland. So that becomes pretty distinctive.
That's cool, though.
So then I went to myself. I did what probably no other privacy advocates do. I downloaded Latitude on my cell phone and started tracking myself for a month. I thought, if other people do it, I should see what happens. Latitude has this kind of crazy feature that's called location history. If you turn it on, it will record everywhere you've been over a given period of time. So I've been tracking myself for a month in preparation for a talk I'm giving at South by Southwest next week to see what I could come up with. And Tuesday, February 12th, right up there, I'll try and use the laser pointer again, is a pretty typical day. I started from my house here. I went to work at EFF, back to my house. I went down, I dropped my son off at preschool. I went back home, and then I picked him up at preschool, and I went back home. And if you look at my Tuesdays, they pretty much all look like that. There's some variation you can see down here. This is Los Altos. My girlfriend lives down here, so I'm driving down there a lot. One day I drove out to Danville. I bought a rug. But you can see that was just one day, and most of my path is right here. And even though the data is not that accurate, you can see like this long line right here. It's not showing you everywhere I was in between, but it's pretty clear I just went from San Francisco to Los Altos and back. And so it really shows you where I've been. So where do we go with that? Well, like I said at the beginning, we're sharing this data with third parties. Our cell phone providers, our location applications are sharing this data with third parties. This is an example of that. This is some research that UC Berkeley and MIT did on traffic patterns in the Bay Area. How did they do this research? Well, they got 360,000 mobile phone billing records from Bay Area customers over a 3-week period. And they got that data from those mobile phone users' provider. The data was supposedly anonymized or de-identified, but if you look at the previous slides, I don't know how, and if you listen to what Ralph has been talking about with whether it's possible to anonymize yourself, I don't know that it's possible. I mean, the whole point of this research was to determine traffic patterns in the Bay Area. Where are people going? What are the bottlenecks that they're creating with their traffic? And with that data, you can learn where a person is every day, every part of every day, and what's the distinctive path that they're traveling through their lives.
That's huge. Yeah, that's really huge.
So I think this is a little scary because location data as a biometric, it combines all the problems that we see with location data that everybody's been talking about this morning with all the problems of biometrics. So non-trespass surveillance and biometrics sort of merge together. And some of those problems, as all of the speakers this morning have pointed out, it shows you who you're associated with, where you go, what you do, what's important to you. And it also identifies you. And as Laura pointed out, and as many of the speakers pointed out this morning, it's still not clear what law would protect this kind of data.
Awesome. I'd be kind of embarrassed to see my location signature at the moment, which would be like from my bedroom to my living room, back to my bedroom, back to my living room. Anyway, I'm going to take moderator's prerogative and ask a quick question, then I'm going to open it up to you guys. And I'm going to ask that nobody throw anything at me when I ask this question, but just in the interest of playing devil's advocate, isn't the idea of your face becoming the sort of universal recognizer and bridge between offline and online data? Isn't that awesome? I mean, we already know that passwords are basically useless now, that anybody with a decent laptop computer, given enough time, can break a password of any length or complexity. So isn't it great that our face is now going to be used? Because presumably you can't hack your face in the same way that you can hack a password.
Well, you could actually. I mean, there are face recognizers typically need to include a form of liveliness test, so that I can't just take an image of you and when asked to identify myself, just hold up that image in front of the camera and then pretend to be you.
Which is how Japanese kids got around the facial recognition on cigarette detectors, is they just held up magazine pictures of like actors And-
Okay, so non-terrible face recognition, like, still, isn't there something great about that? I mean, in the same way that DNA has been enormously beneficial in getting people off of death row.
So I think that ultimately it boils down to kind of definitions of what you think of as privacy and what you think of as what I mean, because what's the harm, right? What is the problem? And Helen Nissenbaum is the chair of my dissertation committee, and she's I'm giving her full credit for this. Is ultimately we live one life, right? But we have siloed aspects of it, right? What you do with your doctor is not what you want to have known at your business. What you have going on at your business, you don't want to have known at your doctor. So the problem with biometrics is that it can provide that key that then breaks down all of those barriers, right? If your face, which is attached to you at all times, right, and is for the most part open at all times, can then be identified in all of these different locations or in all of these different contexts. I think that's where the potential harm comes, right? The potential harm comes with the breaking down of these barriers, the breaking down of these silos, where your identity in one context is completely is open and used in other contexts.
Laura, you want to respond to that?
Yeah, I would just add to that I think our traditional concept of privacy as based on personally identifiable information is the wrong way to think about this. And what we're looking at is a public or a social harm that can be caused by these types of technologies, and the breakdown of how we have understood traditionally privacy. That is, it's based on probable cause or a reasonable suspicion. You're getting to a point where this information is kept and stored. And one of the points that you brought up, now about the storage of this information, as of March of 2012, NCTC has issued, this is in the Office of the Director of National Intelligence, has issued new guidelines. And instead of for 180 days, data is to be kept in mind for 5 years. So for 5 years, this information of any database that's acquired by NCTC and then passed on to other agencies can be kept in mind for 5 years. Now, in your scenario, the facial recognition that's part of that is then associated with data not just from one point in time from a suspected crime, but from everything you do for 5 years surrounding that particular data point on either side of it. And the problem with that is that gives you a completely different view of the individual in society and of society as a whole. And so it seems to me that what we're coming to is a sort of caveat kiwis, right? Citizen beware. When you leave home, you will be recorded, and everything you do, everywhere you go, will be identified as associated with you and who you are in this world. And that is a very different concept of public space than we have traditionally had.
Can I make one also technological distinction? There's many different kinds of facial recognition uses. So the use where you're describing, where you look at your phone and it's supposed to recognize you, that's a verification use. It's a very different calculation. It's just, hey, the phone looks at me and says, is this Alvaro? Totally different set of privacy considerations, much fewer concerns than a scenario where it's a camera looking at an unknown person trying to identify that person. So the first is a verification use. I think that's awesome. The second is an identification use, and that raises a whole slew of other issues.
And there's also then that divide also with facial detection, which is what Laura was talking about with the bar that lets you know how many guys are there. And so one of the big distinctions within industry is between profiling and identification. And they try and how they say that they're privately protective is that they say it's doing one thing or the other. It's like, well, we're figuring out whether you're a guy or not, but we don't know your name. Or we're trying to figure out your name, but we don't care about anything else about you. But the thing is that with Ralph's work is that they're two sides of the same coin, and oftentimes, especially with facial recognition, one of the hard things about it is it's a camera, right? I mean, what is the technology we're talking about here? We're not talking about some weird, like the Stingray, which is this kind of this thing that we're just now getting, it's like highly controlled. We're talking about cameras and algorithms. So, and the proliferation of cameras is just, they're everywhere. And that's the technology that we're talking about in terms of facial recognition.
Okay, we've got 2 microphones here for questions. Chris, you want to take the first one?
Yeah, so I have a question. I guess it's either for Ralph or Travis. So there are some dating sites that are used by people who are within specific
So,
protected classes. So there are websites for
going to
people
the
who are
totality
gay
of
or lesbian. There are
circumstances
people for
test,
people. There are
your
websites for
opponents
people who are of a
argue
particular
that one of
religion.
the
There are dating websites for people who have
strong
particular kinks.
weights
and
in the
there are dating
government's
websites
favor
for
in
people
this
who have
case
particular STDs.
is protecting innocent persons.
Do we think?
And I notice
do
you
think
don't
that in the
mention
long
that.
term,
And I'm
those
wondering,
websites will no
aren't you
longer be
missing
sustainable
something?
for the fact,
Not
for the
only,
simple fact
yeah,
that people will
maybe
be able
your
to go on
client
and mine the
doesn't
whole
want
database,
his
sign up,
DNA taken, and maybe
extract the whole
disagrees
database and
that he
link it
should
to
in this
people's
case.
names and
But
use
suppose,
it in
Counselor,
nefarious
that
ways. I mean, those
in the-
websites
this
exist right
unsolved
now
rape that was-
because
that
of
the
the
DNA
high
linked your client,
transaction
someone was
costs
arrested on the
and the
basis
fact that
of
everyone's sort of
eyewitness
playing by the rules.
identification and was about to go
That's
to
not
trial,
sustainable in the
wrongfully
long run,
convicted.
right?
And the only thing that saved this
Yeah,
person
it certainly
is the fact
raises,
that the Maryland
raises a
police
concern
had the
about that.
authority to run your client's
So,
DNA.
what we showed is that,
How
technologically
does
it
your
becomes
test-
a lot
how
more
does your
feasible to
test
do that.
include, on either side of the scale, the interest
the
of
obvious
the innocent?
question then is it legal for you to do that? Is there,
How would
maybe
you
not
respond
in
to
the
that?
exact scenario that you described, but maybe in others,
Would
is
you-
there
I
an
mean, I
economic
guess there
model
are
that
limits,
would,
right, there are
fuel
limits to
that,
what the police
would
can do to
people
allegedly protect
then
the
make,
innocent? There has to be.
actually go and implement it? I mean, certainly, signing up to a website like you mentioned and then downloading all the images is, most certainly breaking their terms of service. And if you then would want to put a commercial service on top
Your
of
Honor,
that, then you would
yes,
be
the innocent
probably in a
is
whole heap
important,
of
but
trouble.
my guilty client deserves
But, that's a
protection,
different
too.
question. What we've showed is
Oh,
that,
shit, that's a-
technologically, you get to a point where you could do it.
And I think, I mean, yeah,
'Cause that's what-
if
who's
they're
responding?
uploading
Which brief?
photos,
Is
I
it
think
Tut's
that might
brief?
have to, I mean,
against you?
that would seem the thing that would
Okay.
be
Oh,
difficult
that's
to
better.
stop, because if you can download the photos, then you can run the algorithms
because
on
he's-
it.
whoever he's going against is gonna be
I
really
think,
tough.
I think the real difficulty is coming from things of data analytics, where you don't know how you're being tracked, how you know, where it's obvious if you're putting yourself on a dating website that says, I'm an atheist, and you're putting your picture up, and all of a sudden, all of your Facebook profile, ads are like atheism.com, right? There's an obvious link, and you're like, oh, they must have cookies, or there was something here that linked me to that. But I think that where the danger is coming is when there's so many different pieces of information that it's impossible to know exactly what you're doing, right? Where profiling becomes a type of discrimination, where you have different prices, where you have different ads, where you have different things being shown to you and given to you. And the thing is that it's in the interest of the companies who run these algorithms, who do this data mining, not to let you know how to manipulate it. Because if you manipulate it, you can game the system. You can get the lower price. You can always have advertisements that are completely irrelevant, and you can go to the bathroom during, right? And so it's in their interest to keep the algorithm black boxed, but if that happens and you can't tell what you're doing, ultimately you have no influence over your profile. And especially if you're being profiled wrong, and all of a sudden, I'm walking down the street and everything is for Dove soap, right? It's problematic that way.
I wonder if any of the panelists can talk a little bit about the implications of technology on what is an even bigger database of Facebook and that sort of win. The government's effort to suck up all the data as it passes through the confines of the internet.
Okay.
I think they're gathering it up at
Is
4
DNA really
terabytes a
as-
second. They're going to get a yottabyte of data, and apparently they're analyzing it all. I understand going on Facebook and checking for it's not. Can they apply this technology to all that data?
Absolutely. Yeah, that's part of the point, is exactly.
Can you repeat the question?
Sure, can you repeat the question?
Oh, no, here, we'll repeat the question. So the question is Facebook is gathering up massive amounts of information, a yottabyte, and is it
not Facebook.
The government. Oh, yeah, NSA. Yeah, they got in Utah.
Football
right? Yeah.
Everything goes through all of the confines.
And is it possible to then run that kind of technology against it? And
Yeah, I mean, the answer is yes. This is what, actually, Wired Magazine had an excellent discussion of the football field's worth of servers right now that are being run by NSA in order to process all of this information. And just after 9/11, the Attorney General issued guidelines saying all open source information obtained, whether it's through national security letters, whether it's through voluntarily being given by telephone companies, whatever the source is, that information is to be kept, retained, and mined for further information. And if you combine that...
And encrypted, right?
Yeah.
Yes, oh yes, of course, right. And if you combine that then with these extended retention of database information. So in order for an entire database to be transferred to NCTC, for instance, which is the National Counterterrorism Center at ODNI, it has to likely have terrorism information in it. Well, it's hard to envision any major database that doesn't have possibly some sort of terrorism-related information in it. And these databases now are being kept and mined for up to 5 years. So this is the stated intent of gathering all of this information.
Next one.
Quick question for Travis, Laura, and mainly Alvaro. Privacy. So the facial recognition and historical online tracking. For instance, can you opt out of your information being kept or shared? Right now, it seems like everything is opt-in, and if you don't want it, then you have to contact the provider and ask them to opt you out for sharing your information or putting it on a public data website. I would rather that my information is opted out, and if I choose to opt it in, so that's from a legislative point. Second, go back to Travis on the privacy issue. For instance, facial recognition. Indeed, Facebook is amazing. However, I took Google was horrible because I got a Sprint phone and I got the Android was with Google app. So anytime I call somebody, it automatically saves those phone numbers into my Google contacts. And I didn't know they were linked till I looked it up and it's like, that's the people I call. So I called them and said, yeah, you need to opt out. So any Sprint call I make is saved on my Google profile as contact. So
But-
that's one issue that
so
I did
is
not
it your
opt
position
in
then
for.
that
I took my email
DNA
and
testing
Googled it.
is
From
less
1995, it came up with my kids' pictures
less
from
reliable
1995 tied to my email. I have no clue where that was posted or where was it. So I had to go back and change the email and try to figure out where I've ever posted those pictures and remove them. So if you Google your
So
phone,
fingerprinting
your
is not-
email, then it will link all those data together. So is there a way to opt out of the sharing of information rather than
Well, that's what I'm wondering.
automatically opt out, rather than automatically opt in, and then you have to opt out?
I think I follow, but let me just say this. I mean, our privacy laws at least purport, the ones we have, to create opt-in regimes where, yes, you have to say, yes, share my video data. You have to say, yes, cable, wireless carrier providing me phone service. Tell someone where I am. And otherwise they can't. So to the extent we do have statutes covering these commercial areas, they do, at least on their faces, create opt-in regimes. In practice, a lot of folks bury it in the terms of service. And you never, and you click through and suddenly you've opted into the world. The only other thing I'll say on this regard is what personal opinion, speaking personal capacity, what I always see in my job is people justifying the involuntary collection of data on totally unrelated but distinct voluntary sharing. So you put your photos on Facebook. You opted into Facebook. Yes, I did. But I didn't opt into this back-end analysis of my data. And I see that pattern a lot. I think Ashkan Soltani calls it inorganic data, and I think there's a lot more inorganic data than organic data being collected.
I just wanted to say, one really quick thing about like the pictures of the kids is that the persistence of data is astounding. I think one of my favorite images of this is that with the UK, when they finally decided to get rid of their biometric database, they had to physically destroy everything. Right? There's a great picture of one of the ministers like putting the biometric database into a giant shredder, because even though the data is immaterial, it has a much longer shelf life. It tends to live on. And now with Europe putting in the right to be forgotten, Facebook and Google are both having to deal with, how do you delete a photo? It seems like it should be an easy thing, but it's really, really not, because they cache it. It's every single time it bounces through a different server, they have to go through and delete every single instant of that photo. And it seems like it should be an easy thing, but I've talked to some of the engineers, it's really, really not, and they're just now coming to terms with how to actually delete a single photo off of their servers.
Do we have any more?
Sorry, I just want to add one thing. These are commercial answers to it, and the right to anonymity that we're seeing now in Europe, and the scarlet letter phenomenon, whether or not you can recreate yourself. I think those get at very deeply humanistic issues. On the government side of this question, you have no right to actually examine any data held on you if there's a national security or law enforcement purpose behind it. So you have no opportunity to question it, look at it, review the records, confirm if it's accurate, see how that information was put into it. These are all exceptions built into the 2002 legislation, the 1986 legislation, 1978 legislation. They're exceptions for national security. And the more that this merges with law enforcement, you have fewer and fewer rights to actually take a look at the information that's being collected on you and how it's being used.
We've probably got time for one more question.
Hi, Jennifer, I particularly appreciated this sort of expansion of the question of what is a biometric and thinking about location as being relevant to that. I guess to build on the more expansive conception of this, I wonder how health information might overlay with this assessment of what constitutes biometric, whether it's that it's immutable, whether it's easily retrievable. Obviously, with the advent of electronic medical records as a sort of a secondary aspect of healthcare reform, and the need to sort of build these huge, and the existence of databases on who has diabetes, and the ability to do cancer genetics more effectively by looking at histories of patients. How might that sort of legally and practically complicate this assessment of what is or is not a biometric? And yeah, I'm just sort of curious about the practical implications of that.
Thought very much about health records, so I should probably always cut myself off when I say something like that, but of course I'm a lawyer, so I'll keep talking. I think that the health record situation raises a couple different issues. One is that with e-health records, there's a really good reason why we are moving towards e-health records. There's a reason why we're storing our health data electronically, and that is because we can improve our healthcare by doing it. If your data is portable, you can take it from doctor to doctor to doctor, and it's easier for them to treat you. But it also demonstrates that the risks of that, and that is that once your data is portable, it can move from place to place to place, and it can also be aggregated with other data. So in terms of health data forming a biometric, I think that there are biometrics within that data, and it just adds to the picture of who you are. It adds to the ability to identify you, but it raises more distinct issues about data aggregation and also about data being collected for one purpose and used for another purpose.
So really quick, just in terms of a definitional issue, biometrics, in terms of how the industry talks about it, is really just about identification of persistent identity over time. And so it's kind of funny because there's lots of biometrics that are being talked about, like EKG and brain scans and things like that just really aren't practical. They're still doing tests on it, they're still getting funding for it, but really fingerprints, iris scans, facial recognition is kind of still where it's at, because those are just simply, you already have that. You don't really need to set somebody up with a brain scan to find out who they are over time. And this is, health records are actually an instance of biometrics actually being used really well. Because what they do is they use palm vein recognition, where you look at the patterns of the veins on your hand, and it's an authentication task, right? It's a verification task. It's just simply, are you who you say you are? And then this is being used to keep records private by saying only the people who should have access to it can have access to it, and then saying also, okay, are you the patient who should be getting this medicine? And so this is one of those cases where it's not being used for identification. Palm verification actually doesn't really work very well for identification, even if you wanted it to try to use it that way. So it's really just for authentication, and it actually is privacy enhancing and helps protect the patients.
So I would just add as a two-finger on that, authentication is exactly how biometrics first entered the law post 9/11, and it very quickly morphed into broad-scale identification and remote biometrics.
Yeah, but then it's a question of the technology, right? Because fingerprints can be used for broad-scale identification, but not actually. Facial recognition can be used for identification and verification and remotely. But palm vein, for example, you can't do it remotely, at least not yet. And it doesn't really work very well for identification, at least not quite yet. You get too many false positives.
We'll disagree.
Oh, yeah, okay.
Because there's vascular pattern at a distance.
Okay.
Yeah.
So I just leave this, we'll wrap up this half of the panel with, with one final thought, which is, right after 9/11, facial recognition in particular was sold as like a way to catch terrorists in a crowd. Right, and sort of famously, they put in facial recognition cameras at the Super Bowl in Tampa right after 9/11. But what this panel has made me think is that actually, if you're like a member of Al-Qaeda, you might be actually one of the few people that's not in the facial recognition database, right? Everybody else is on Facebook and Match.com and whatever, and is actively participating in a facial recognition regime, whether they know it or not. It's only if you're really trying hard to stay out of it, or in a place where those technologies aren't pervasive, that you might not be in that group. So in fact, the sort of promise of catching a terrorist in the crowd may be the very last thing that you can do with facial recognition.
I just wanted to, Travis and I would probably say the exact same thing on this, but despite the slide from the Criminal Justice Information Services that where the FBI is planning to identify the face in the crowd as the person moves from one political rally to the other, the technology is just not there yet. The computer technology is very good at identifying a picture of a person, or the image of a person who's standing in front of a white wall looking straight towards the camera, and comparing that image with another person who's standing in front of a white wall looking straight on at the camera. It's not good at comparing that person in front of the white wall with a person in a crowd photo. It's just not there yet for a lot of different reasons that we have a whole other panel to get into. And even Helen Nissenbaum has said that it's not for the foreseeable future that we will be able to do that, although the technology is improving extremely rapidly.
Okay, Laura, last comment on this, and then we got to get to the flying robots.
So you're raising the substantive issue of whether they're actually in the Facebook, and assuming there are other sources that you can get information and photos, whether you're a soldier in Iraq or Iran or wherever you might be, right, at the time. But there's an additional issue, which is pattern matching. So we have seen a lot of, query-based or subject-based database data mining, but what we're moving to is pattern-based. And here it's even less opposite in a sense, because while something like fraud, pattern matching, pattern-based matching might work to identify high-frequency events like fraud that might occur. For terrorism, it's almost impossible to come up with an algorithm for this. And so New York Clearinghouse, various agencies have tried to come up with algorithms, and it's even harder with a massive database to come up with an algorithm to anticipate who might decide to engage in terrorist activity. So it's actually even less applicable in some ways in the counterterrorism realm, although we're turning to large databases as a solution, essentially a silver bullet, to try to find those who are responsible for violence.
Okay, I'm going to cut it off here. Thank our panelists. And we're going to take a 2-minute and 20-second break, and then we're going to conclude the day with drones. So,
Yeah. Everyone said everything.
if you can say that I can't believe we're both.
I'm going to run away for a second.
Very good. Thank you. That's
How do they grade Watch your breathe.
Oh, I see. Yeah? Yeah, you're slowing down. Yeah.
A fine gentleman. Oh, no, thank you. Hey, how are you? Wait, oh, that's CG. Actually,
Right.
You're doing a work history Awesome. That's fine. Just grab some.
Yeah.
So you asked him if he'd moot you?
How's it going? You living up there?
You should send an email, cussing. John would be pleased by your
Good. Yeah, I think about it. I worry about it.
spunky attitude.
So, yeah, so I think your opinion was right in that case, not to include video technologies, because it's not in the future. Oh, I have all the citations in the law review article, so, but it's, the other side, I'm starting to read the statute as though it covers it, and it's nowhere in the statute, which I think is, you're right, not to.
I'm ready to go. Perfect. Okay, and now we come to our final panel. Going to talk and drop the mic. And we've got, we're going to talk about drones, which is a topic, you know, that you'd have to be living in a remote village somewhere on the edge of nowhere to not have heard of.
They know it better than you.
Yeah, except that actually probably, depending on the village, you probably have a drone everywhere now. But obviously, these drones are not going to stay over remote villages for very long because drones are coming home in a major way. Not only is there all kinds of desire in legislation to bring cops and DHS to allow them to have access to drones, but also if you go to the corners of Atlantic Avenue and Flatbush Avenue near my house in Brooklyn, and you go to the very rundown Verizon store there, you can buy your very own quadcopter spy drone for $299. And trust me, if it's on sale on Flatbush Avenue, it's on sale everywhere. So to discuss those developments are Nabiha Syed, who's an attorney at Levine, Sullivan, Koch & Schultz, LLP, and is a former First Amendment Fellow at the New York Times Company. We also have Catherine Crump, who is a staff attorney at the ACLU's Speech, Privacy, and Technology Project, and she's also a non-resident fellow with the Stanford Center for Internet and Society. Nabiha, take it away.
It's late in the day, and I apparently have 5 minutes. And so I'm going to tell you a very brief story and then flag a few reasons why drones are kind of the culmination of a lot of the biometric concerns, First Amendment concerns, Fourth Amendment concerns we've talked about throughout the day. So the story is about a man named John Silva, who was a tinkerer and also the chief engineer for KTLA-5 in 1956. And so here he is sitting in 1956 trying to figure out how to get more of a market share of people watching television. And he realizes that the LAPD had just bought a helicopter and they were using it to monitor traffic. And there was no camera involved, they would just use it to then periodically relay reports about traffic. And he brilliantly realizes, hey, wouldn't it be awesome if I could retrofit a copter with cameras so I could broadcast traffic and then give people live traffic updates. And so he does so over the course of the year. He rents a helicopter from the Army, he pairs up with GE to figure out how to take 2,000 pounds worth of broadcast for camera material and end up putting it onto a small helicopter. And he successfully has the first in-the-air broadcast of traffic in 1958 before anyone else has done it, and it's a great hit. And it's such a hit that the LAPD then decides to do the same 5 years later, and they now have the biggest fleet of airborne police traffic control helicopters that now all have cameras on them, of course. And so I bring up the telecopter, as it was called, for a few reasons. The first is that it is not always obvious how developments in the private sector will end up affecting law enforcement, and that we should actually think very actively about the relationship between the two. And the second is that every time I talk about drones, people who are, not so cognizant of privacy say, well, what's the difference between like a helicopter in the sky with a camera and a drone? There's no big difference. And there are, like with all technological developments, some of it is a little bit like what it used to be, and some of it is new. So broadcast from a helicopter, it's mobile, so they can follow location in real time, which is why we got to see O.J. Simpson in his white Bronco racing down LA highways. And a helicopter is also airborne, so it does have the same vantage point that drones will have, and it can capture images beyond where a person can go and snap photos with their phone or with their camera. So what we see here that's similar with the helicopter and the drone is the pairing of visual content with locational content. It's a visual dimension to your locational privacy because it can track both where you go, but also who you're talking to, who you've met, what you've done in that time in a visual component. The ways in which it's different. So a drone, better known as an unmanned aerial system or unmanned aerial vehicle, is unmanned. So the Supreme Court jurisprudence that talks about helicopters or airplanes flying over and pilots incidentally seeing what's going on is a little bit different here because someone is making a cognizant decision to either videotape it, continue to tape a drone as it's flying where it's supposed to go, and then to watch it later and catalog it as needed. The second difference is that there's a plane of view difference. You would probably know if there was a helicopter right outside of your window because it would be big and it would be noisy. Drones can vary quite a lot in size, and DARPA's doing a lot of research on making very small hummingbird drones that would not be obtrusive at all. And the third, of course, is cost. You can get one on Atlantic Avenue, apparently for $299. I thought they were going for $350, so I have to go make a trip. And you can also get very big ones for about $20,000, which will run for 1,600 hours of flight time with constant recording for $20,000, as opposed to $1 million that it would take for a helicopter. And what the decrease in cost does is that it allows 3 distinct groups of people to experiment more with this technology. The first is private individuals, tinkerers like John Silva, private companies, and public institutions. And I'll leave the discussion of public institutions and the Fourth Amendment implications to you, because you're the expert to that. But I just want to flag what we spoke about earlier today with the kind of the third-party concerns and the associational privacy concerns when it comes to both private individuals and private companies, particularly the companies. The FAA regulations say that there should be no commercial use of drones until 2015, assuming they stay on schedule, which is a big assumption. But commercial use of drones already exists. Aerial photography for both sporting events, for films, for real estate is already prevalent, and the FAA is doing nothing about it. One area that I have been spending a lot of time in is actually the potential for drones in news gathering contexts, because law enforcement has been pretty good about blocking access to certain areas, saying, no, I'm sorry, you have no right to record here, taking away cameras from photographers, and blocking access in other ways. Having airborne drones do that makes it a little bit harder for the cops to take it away, unless they wanted to shoot it out of the sky, which is its own thing. So you actually see like a interest expressed by the Drone Journalism Lab, the Daily, which has already used a drone to do some weather forecasting, BBC, and a variety of other outlets in kind of the expressive use of drones, using it for news gathering, and a variety of, potentially non-scary uses that could be really useful, that could give us a lot of information. We will see unconventional uses of drones outside of the law enforcement context like that grow rapidly, I'm sure, as soon as the commercial licenses are readily available. And what that means is that we will be, as Judge Kaczynski flagged earlier this morning, entrusting all of this visual content that has both locational privacy and visual concerns all embodied in it, available to third parties who have no legal infrastructure to guide it, no privacy policies as far as we know that will mandate them to do certain things with it. And so we're kind of entering this wild, wild west of what will happen with the proliferation of this content. So I just wanted to flag for you all that as we talk about what drones will do for society, as we enter a rulemaking process with the FAA, to really be thinking about the private dimension of this, not only what law enforcement will do terrifyingly with this new technology.
Okay, so I will just mention briefly on the private front that the ACLU is, of course, a free speech organization in addition to a privacy organization, and we think there are many tremendously beneficial uses of private drones that people will make, although there are also obviously potential privacy harms. One can certainly imagine a creepy guy flying a drone over his neighborhood looking down at everyone sunbathing at their pools, right? And so we're planning, with some help from some folks who are here, to put out a white paper later this year trying to grapple with the difficult First Amendment issues raised by the private use of drones. Why are we ending a conference where we've primarily been talking about cell phone tracking and GPS by talking about drones? I think it highlights the ways in which privacy advocates need to win every battle about location tracking, and the government only needs to win once. That is to say, if the Supreme Court says that you need to meet a Fourth Amendment standard to engage in location tracking with a GPS device, the next question becomes, what about automatic license plate readers? What about drones? So on and so forth. I think that is one reason why at some point it would be useful to have some legislation that actually tried to deal with location information as a unit rather than each individual technology that comes up. one of the most interesting things in my view about the current debate about drones is that I have not previously seen a technology inspire so much opposition on privacy grounds as drones. And I think it would be useful, particularly for those of us who are privacy advocates, to think about what is different here. Like, why have organizations like the ACLU and EFF and CDT and EPIC and others, been raising the alarm about cell phone tracking for years and years and years, and yet drones, aren't even really in use very much by law enforcement agencies in the United States and are already generating substantial opposition. And I just want to suggest a couple of reasons for this possibility. First of all, the default setting is different. Kevin Bankston, who has probably done more than anyone else to safeguard us from warrantless cell phone tracking, mentioned earlier today that until 2005, privacy advocates didn't even understand that cell phone tracking was occurring without a warrant based on probable cause, right? So there was a default, right? The default was policy by procurement. Law enforcement agents simply acquire a piece of technology and begin to use it, and it is often months or even years before the public is aware that's going on. And by the time the public learns, this technique is already integrated into law enforcement practices. It's hard to argue against something when law enforcement says we've been relying on this for years. It's an essential element of our crime-fighting arsenal, and no one has complained. We've been doing this for years, no one has complained, right? Drones are different. For totally unrelated reasons, primarily focused on safety, the Federal Aviation Administration has thus far largely prohibited the use of drones in the United States. And because of that, that actually puts the onus on those who want to use the technology to make an argument that it's not going to invade privacy. So it means we can have a debate about privacy up front, right? And so you can actually today witness what it is like to debate the privacy implications of the technology before every police department is already using it. Further, I think it's also worth mentioning that the public is deeply familiar with drones, right? We've been watching what this powerful technology can do overseas for years in places like Yemen and Afghanistan. As a privacy advocate, I often notice that television doesn't like to cover privacy issues because you don't have great visuals of cell phone tracking, right? You get like the still image of the cell phone, right? Television loves covering the drone issue because you have these amazing sci-fi-like images that you can splash off on the screen and everyone likes to see it. Another thing that I think is different about drones, the drone debate, than other issues is that this concern about privacy in drones has primarily been led by conservatives or bipartisan efforts, but really it's coming from the right. For example, it was not the Democratic Party but the Republican Party that this past year included in its party platform a specific statement about drones, that we should all be safeguarded from unwarranted use of drones within the United States. And to see that in a major party's platform was quite remarkable. And so the ACLU on its website, we have a little chart where we've been mapping out state-level legislation. There are now 29 states where in the state legislatures some legislation related to drones has been introduced. They vary widely. Both houses of the legislature in Virginia, for instance, have passed a proposed 2-year moratorium on the use of drones by law enforcement in the state. Other states have gone so far as to introduce legislation arguing for a warrant requirement before drones can take off the ground. Rarely in my career at the ACLU have I been outflanked in terms of proposing privacy protections for a technology. In 2011, my colleague Jay Stanley and I co-authored a report on the domestic use of drones in which we proposed that law enforcement only use them where they had a reasonable belief that flying the drone would turn up evidence of specific wrongdoing. Tea Party Republicans have actually gone further than that around the country and have proposed there be an across-the-board warrant requirement, or a probable cause requirement, higher requirement, before drones can take off the ground. I think if there was a subtitle for my little part of this presentation, it would be Ryan Calo was right. Ryan Calo was formerly at Stanford, now at the University of Washington, and suggested that drones may be the leading edge of a privacy movement, that people will see this technology and conclude that this is one step too far. Regardless of what happens with drones around the country, if this movement is successful, right, you start seeing privacy protections put in place for drones. And the other interesting thing I think to note is it's happening at the state level, not at Congress, right? And so you have all of these laboratories in which this technology is being trusted. But if this movement goes somewhere, perhaps we can back into some of the other issues we've been talking about, right? Because you can draw then the connections, right? Well, one of the reasons people are concerned about the privacy implications of law enforcement use of drones is because of the way they can engage in pervasive surveillance of private property, of long-term location tracking, and perhaps, we'll end up starting out by having success regulating law enforcement use of drones, and then can, pivot off of that to address other technologies. So, if I were, in charge of a large foundation and had lots of money to throw around on privacy issues, I might look at this issue and say that maybe the privacy community has been making a mistake by focusing so exclusively on the federal level here. And that perhaps what someone ought to do is focus in on, say, 10 or 15 states where there may be more bipartisan support for privacy and perhaps also state constitutional protections. And to try to develop either good legislative policies or perhaps good decisions in the courts on privacy issues in those states, to be sure that wouldn't affect what the FBI could do, for example. But most law enforcement surveillance in this country is actually takes place at the state or local level, and I think in general Americans, if you talk about surveillance by the FBI, find that to be a remote and distant thing, but when you talk about this Salt Lake City Police Department or the police department where they are located in, become much more concerned about the policies. And so I just throw that out as food for thought. And given that it is 6:58, I guess I will stop talking.
Thanks. Do we have questions? I thought those were two great presentations. Do we have questions for the two of them? Okay, well, I'll ask one then, just to start. So I can be captured by a regular surveillance camera as I'm walking around on the street, right? So what's the big deal if that surveillance camera is attached to a little robot that can only fly for 20, 30 minutes at a time? What is the what's the substantive difference if that camera is attached to a short-term flying robot or to a lamppost?
Yeah, I mean, the difference is between taking a fixed image of where you are in time and then following you and seeing where you are going, who you're running into. You just extend the amount of data points that are in there, right? Rather than a lamppost camera that's like, hello, Noah Shackman walked by this lamppost once. It's you walked by 6 lampposts on your way to a lesbian bar, as Stella brought up. That is the difference.
Like I do, but just to push back on that for a second, at least most of the newer metropolitan surveillance systems, at least want to have a back end in which they can do some of that work. And if you've got a network of 1,000 cameras, that same kind of work can happen. You can have that same location information. So does putting it on the robot still make it any different?
Well, I think this is where the private use of it versus the public use of it becomes interesting, right? Because if you have city-owned surveillance cameras that are everywhere, you're saying that kind of information about where you're going, that on the back end is being aggregated, is kept in the state's hands, which can be problematic, but is at least confined in one place. But when you're talking about the proliferation of private use drones, now that same locational information about where you're going is now being spread around and potentially has legs that you haven't foreseen.
I have a question, but first I wanted to plug a fun book called Kill Decision by Daniel Suarez. It's a techno-thriller about autonomous drones that also has a really great description of a citywide drone monitoring platform that with Uzi catchers does pervasive facial recognition and phone tracking over an entire city and is really kind of mind-blowing to think about. I'm sorry, Kevin Banks and CDT. The question, the question for Catherine, and there is an acceptable answer, which is we don't know yet, is since you called it out as your first comment, the issue of free expression and First Amendment rights to use drones for news gathering or other private monitoring. What's the balance there? Have you all stated a position on how to balance that yet, or is that still in process? And again, it's perfectly okay to say we don't know yet, because I certainly don't have a good answer.
Yeah, it's a really hard question, and it's one we've done a lot of thinking thinking about, but we haven't quite reached an answer, right? So the current FAA policy is sort of a blanket ban, and that seems wrong because there are these great uses you can put private drones to. At the same time, to pivot back to something that Judge Kaczynski was mentioning earlier, right? If you can engage in pervasive drone surveillance as a private company, and then all the government has to do is access that, then you've shredded any potential privacy protections that were in place. So, we've sort of been looking at, to what extent are current tort laws adequate to the job, right? There are peeping Tom statutes, for example. There's some privacy torts, and we're sort of starting off by examining those and the restrictions that they place on the ability to use, sort of traditional surveillance technologies in intrusive ways. But we haven't really finished formulating a complete position.
Anybody else? Oh, one last one. Okay.
Jim Green again. I thought that was an interesting first question, Noah, so I'm going to try and extend on it just a little bit. The response to drones seems to be visceral and almost inchoate at this point. We all know we don't like them, but there's a lot of sort of overlapping interests that are potentially mined for advocacy or potentially have minds in them for advocacy. When you mentioned that it has been the Tea Party and certain associated entities that have responded maybe early and most viscerally to them, one thing I'd suggest is that it's the combination not only of surveillance with forward military power and that kind of imposition of government power that worries a certain subpopulation that are responding to drones. In effect, it's an extension of the black helicopter fear. And how do we, as Kevin alluded to, reconcile our advocacy points when we're coming at this from such different points, maybe, in our concerns about this? How do we harmonize that?
Do we need to harmonize it? I guess is one.
Maybe not. That's an answer.
I don't know. I've been one of the big proponents of the GPS Act in Congress was Representative Chaffetz, right? So there have been. I think it's in some cases. I'm not sure it's all black helicopter stuff. I think there's a streak of small government conservatism which extends to surveillance law, and it does lead to strange bedfellows. But I guess I'm just happy to have them.
Okay, with that, let's give a hand to our last panelist. And Margot, if there's anything else?
Thank you all so much for coming. This will be available on the ISP website for viewing later.